moves fast, so we check the settings, cut the deadwood past. Special vote stacking like a tower of bricks, lane enrollments doing overtime tricks. Used to be 2 weeks, now it's 3. If we do nothing longer, you'll see. So we tighten the timing, smooth the lines, start the process earlier, read the signs. 13 days before the big show starts, get your name right where the roll book charts. 13 days, 13 days. Get enrolled before the deadline gates. 13 days, 13 days. Is it speed or democracy at stake? No treats at the ballot, no chips, no tea, no freebies near the box, keep it clean. 13 days, 13 days. Tell me who wins when the rules all change. Auto updates, moving addresses along, go data, keeping details strong. Roll stays current between each race, less last minute chaos, faster pace. Advanced voting, 12-day run, make it formal, job gets done. No costly letters sent by post, more modern system, cut the toast. And prisoners sentenced, no vote while inside, consequences land on the other side. Serious offending held to account, serve your time then re-enroll back on the mound. Mental health detention kept the same, 3 years plus, that's still the frame. And promoted details, safer to share, less risk, less harm, more fair. 13 days, 13 days. Get enrolled before the deadline gates. 13 days, 13 days. Is it speed or democracy at stake? Treats at the ballot, no chips, no tea, no freebies near the box, keep it clean. 13 days, 13 days. Tell me who wins when the rules all change. You should be ashamed, 'cause here's the truth. You made it harder for everyday youth under urgency. Rights get clipped, democracy's ladder missing rungs that slipped. They say timeliness like it's the crown, but it's people showing up, don't shut them down. 100,000 turned up last time, now you call them drop kicks in the grave. If your first vote's turned away at the door, you don't come back, seen that before. So I push this if it won't speed the count. Feels like tilting the field, stacking the mound. They had other options, read the page, but chose the cut, set the stage. Harder to vote, easy to claim, but we see the game behind the name. 13 days, 13 days. Who gets locked up when life's derailed?
And welcome to the special Autopaper podcast live stream. I'm just waiting for the Justice Select Committee to go live. I thought they would have actually already been live by now. It will be finishing at 5:35 p.m, so they've obviously refined the list from there. This is what happens when you find out something with about 1 hour's worth of notice on what is happening on there. So once we know that the Select Committee is live, I will sit down there and actually hand it over to the stream. But yeah, it's just not quite gone live yet, so which is a little bit concerning considering but I mean they're probably sitting down there trying to get all their ducks in a row. I mean this has been sat there and done. And the reason why they're not going live is because the first submission doesn't start to 12:45. See, that has changed in the last hour. But that is pretty damn frustrating. So we've got 45 minutes of waiting until they go live. Oh, gee, joys of what it is. And this already has to put out the wrong message that popped on bad. This is what happens when things are a bit rushed here. So yeah, it's definitely going to be a lot of fun trying to sit there and watch. I'll find if we can see some footage from the Autopub podcast show that actually had the climate change bill put in, which that was a more recent one, because that was put in last week. So we'll put that in as it is. So you can see Alex and I who have sat there and gone for that. So we'll give you something to at least watch for a while over the next hour, while the next 45 minutes, while we wait for the live stream to kick off. And thanks for bearing with us with this. It's not exactly quite the morning that we kind of wanted to start off with, but shit happens. So let's kick that off the right to vote. Now, that would affect approximately 700,000 people in New Zealand. But here's something also worth noting. Those 700,000 people will still have to be calculated when making an electorate. So there's a lot on that. So our poll is, should New Zealand First keep importing their policies from overseas or stick to grassroots policies?
Can I give my opinion on that?
Go ahead.
Stick to grassroots policies, actually. Importing policies, I'm going to give my opinion. If we import some policies from overseas into New Zealand, it may not be suitable for New Zealand, if you know what I'm saying.
Yeah, it's just like when Lee Donahue tried to sit down there and, import, what was it? It was this child indoctrination stuff in the United States. Yeah. So, yeah. So, that's the poll that's going on there. So, shall we sit there and kick off with opening speeches from the Honourable, once I finally find out who it is, Minister of Dodgeball, Paul Goldsmith. And would like to thank Frankie T for that new ministerial portfolio that Paul Goldsmith has that may be in a future ACT coalition be removed. Oh.
Response Tort Liability Amendment Bill.
The legislative statement is published under the authority of the House and can be found on the parliamentary website.
I move that the Climate Change Response Tort Liability Amendment Bill be now read a first time. I nominate the Justice Committee to consider the bill, and at the appropriate time I intend to move that the bill be reported to the House by 30 July 2026, and that the committee have authority to meet at any time while the House is sitting, except during oral questions, during any evening on a day on which there has been a sitting of the House, on a Friday, in a week in which there has been a sitting in the House and outside the Wellington area, despite Standing Orders 193, 195 and 196. Madam Speaker, this bill clarifies climate change laws to provide businesses and New Zealanders with certainty around their obligations. Ongoing litigation in the High Court, where civil claims have been made, is creating uncertainty in business confidence and investment. It risks the development of a new regime that runs in parallel and may contradict the framework that Parliament has already enacted to respond to climate change. Ultimately, if there is a legal uncertainty, there is less investment over time, and that affects us all by making our country less competitive. Madam Speaker, therefore the Government will amend the Climate Change Response Act 2002 to prevent findings of tort liability for activities that cause or contribute to the emissions of greenhouse gas, and through those emissions may cause or contribute to climate change harm. A tort, Madam Speaker, is a civil claim brought in private law in situations when the conduct of one person causes harm or invades the interests of another person. Tort law has primarily been developed through the common law, which arises from decisions made by judges in court rather than by legislation that is developed in Parliament. In Smith v Fonterra, a case, the defendant is asking the court to develop a regime to control and reduce the emissions of 6 of this country's largest businesses. This would be potentially contrary to the regulatory response set by Parliament under the Climate Change Response Act 2002, which sets out our legal framework for New Zealand's regulatory response to climate change. This framework includes a 2050 target for emissions reduction and a regime for setting and meeting successive emissions budgets with a view to achieving that target. Madam Speaker, the Government's view is that greenhouse gas emissions and climate change harm are best regulated by Parliament and the Executive, who take a whole-of-economy approach that carefully considers environmental, economic and social implications, rather than on a case-by-case basis through litigation in the courts. A statutory bar prevents courts from issuing a certain type of finding or considering a particular issue. In this case, the bill will prevent a person or entity from being liable in tort law for climate change or harm caused by greenhouse gas emissions. This will apply to all activities contributing to greenhouse gas emissions directly and indirectly, regardless of when or where they occur. However, the bill is targeted and will only affect tort claims relating to climate change damage or harm arising from greenhouse gas emissions. It will not affect traditional environmental torts, for example, where a factory burning fossil fuels causes harm through odour or ash residue. This may still be covered under the tort of nuisance. The bill will also apply to the proceedings of Smith v Fonterra. I acknowledge that care is needed when deciding whether legislation should apply to existing court proceedings. However, these proceedings are still at the procedural stage and the substantive proceedings have yet to start. And currently, there is no tort liability for climate change damage caused by greenhouse gas emissions, but this is what Mr Smith is asking to be developed. I therefore consider that the application of the bar to existing proceedings that have not been finally determined is necessary. This will ensure that there is no risk of a parallel regulatory regime being developed in future which applies to some emitters and is inconsistent with the Government's regulatory response. As no rights have yet been identified in the existing case, this legislation will not deprive the litigants of the fruit of litigation. The bill clarifies the regulatory framework in which we are operating as a country with regard to climate change. The bill doesn't change New Zealand's climate targets or the approach that the Government has taken. Businesses with obligations under the Emissions Trading Scheme will still be required to meet them. We have a good regime in the Climate Change Response Act and the Emissions Trading Scheme, and we're seeking to make sure this regime is clearly in place without confusion. The bill makes it clear that the response to climate change sits squarely with the elected Parliament and the Executive. Madam Speaker, the bill clarifies the law to ensure that there is certainty around climate change obligations of New Zealand businesses. It also ensures our response to climate change is managed by Parliament and the Executive at a national level rather than on a case-by-case basis through the courts. And on that basis, Madam Speaker, I commend this bill to the House.
The question.
So, what have you gathered from Paul Goldsmith's speech just then before we give down the breakdown of the bill?
I think Paul Goldsmith was admitting he doesn't want the government being taken to court over their part or businesses causing damage to the environment.
I believe, here's the thing I find disgusting is the fact that this bill is to circumvent a case going in front of the New Zealand Supreme Court, the highest court of our land. And that's exactly what it is. And it's great that you didn't pass law under urgency, you let it go to select committee, but you're probably going to end up having select committee submissions being flooded in saying, halt this bill is literally creating a constitutional crisis and basically blurring the line of the separations of powers.
Can I also raise something? It's not just Mike Smith's pending court case. You know where Eastdale is, up in the Hawke's Bay, which the residents can't go back to anymore?
Yes.
I'm wondering what happens if some of the residents want to take someone to court over what happened.
Well, say the forestry companies have been slashed.
Yeah.
Yeah. Are them or their insurers going to be halted in this process?
Because I know some Eastdale residents who've been forced out of there are not really happy.
Yeah.
And I believe the Palmerston North to Gisborne line used to run up that way as well.
Oh, it's basically it's broken to bits from basically north of Bayview. It's been completely it's been washed away.
Yep. And so, in other words, if the residents are not happy, what's their recourse? If you know what I'm saying.
Exactly. Yeah.
Yeah.
Yeah. Okay, so let's break down the bill here. So the purpose of the bill, for the breakdown here, is to amend the Climate Change Response Act 2002, prevent courts from imposing tort liability, civil lawsuits for damage caused by greenhouse gas emissions and climate change. Confirms that climate policy should be determined by Parliament and the government rather than through common law court cases. Why the bill has been introduced? Response directly to the Supreme Court decision in the Smith versus Fonterra. Like to point out there that it hasn't actually been heard in the Supreme Court. The highest court ruling is the Court of Appeal. It has gone to the Supreme Court, and the Supreme Court has allowed it to proceed. Okay, so let's back to the summary, which allows a climate change tort case to proceed to trial. The government argues that allowing climate-related tort claims would create a parallel legal system alongside the New Zealand existing climate legislation. The bill seeks to ensure climate change regulation remains under the Climate Change Response Act rather than being developed through court judgments. Okay, main changes. Change the statutory bar for court claims. A person or organisation cannot be sued in tort for greenhouse gas emissions they produce or contribute to, or climate change effects from resulting from those emissions. Applies to individuals, so that is you and me, to companies such as, say, Fonterra or Z Energy, and applies to the local coffee cart down the road, Being Here Limited, being my company. It applies to public bodies, such as local councils and governments. Not governments, local councils, regional councils. It applies to the Crown, which basically means the Crown is exempt. I wonder if this will actually end up stopping regional councils, while they're still existing, from being able to actually do what their job is, which is called manage the environment as their main contributing. Okay.
Can I also add about Fonterra? They've been condemned by Greenpeace apparently for the use of nitrate, and apparently Greenpeace in early April mentioned that the synthetic nitrate that they use on agriculture has begun to impact the quality of drinking water in rural New Zealand. Apparently.
That's not exactly new. Yeah. Okay, so it covers direct and indirect emissions. The protection applies regardless of whether the emissions are direct, Scope 1 emissions, indirect, Scope 2 or Scope 3 emissions. Don't know what the difference between the two is, but that's all right. Caused by related activity and produced by another party connected to the activity. Applies regardless of location. The statutory protection applies to whether the activity occurs inside or outside New Zealand, emissions occurred overseas, climate impact occurred in New Zealand or overseas. Applies regardless of timing. The protection applies to emissions before the law comes into force, after the law comes into force, and ongoing emissions. So this bill is retroactive. And that is pretty damn concerning, the fact that it's retroactive. What counts as climate change effects? The bill's emissions-related climate change effectively include climate change itself, damage caused by climate change, harm or losses, interference with property, public nuisance, environmental damage, threats to public safety, impairment of health, loss of use of property, and cultural or non-economic harms, including tikanga Māori conceptions of harm. What the bill does not include, what the bill does not protect, the statutory bar does not protect pollution unrelated to climate, for example, smoke, ash, or odour from a factory. So, probably famous in your area, the Seaview sewage treatment plant.
Yeah.
So that would actually be there. Breaches of statutory duty. So if you're literally dumping paint down the stormwater drains, or was it misfiance in public office? Don't know what that means. Existing court claims. The bill applies to the ongoing Smith versus Fonterra proceedings. Any tort claims already filed but not finally decided. So, let's rush to have it. Hey, David Helen Winkleman, you've got, why not sit there and hold Smith versus Fonterra during over the school holidays while we've got a chance? I know it's a bit of we'll catch us on the hoof, but hey, Parliament don't sit until the week after school holidays. Any future proceedings after the law comes into force. There will be no compensation for anyone who is prevented by the new law is not entitled to compensation because of the legislative change. So the fees associated with it would not be on there. Consequential amendment. The bill also amends the Resource Management Act of 1991 to make it clear that the existing common law rights preserved under the Act do not override the new prohibition in the climate-related tort claims. Practical effects. If enacted, the bill would stop climate change lawsuits seeking damages or injunctions against emitters, protect businesses, public bodies, and the Crown from civil liability from arising from greenhouse gas emissions, apply retrospectively to unresolved cases, leave climate regulation to Parliament and the Climate Change Response Act rather than the courts, and it still allows actions from non-climate environmental harms such as smoke, dust, noise, or chemical pollutions, who those claims are otherwise available. While you're mulling on what to decide to say, Jason has got something really to sit down there and actually sound here. The government doesn't give a toss about climate. It's all about the importance of image and the mighty dollar.
Can I say what this bill really is? And Paul Goldsmith should be honest about it. Paul Goldsmith should have simply wrote, the government shall not be held responsible for climate, if you know what I'm saying, or any weather events that displaces people.
Exactly.
That should just be the title of the bill. No need to say tort or whatever, you know what I'm saying.
Well, that's the legal terminology. So that is illegal. So the actions that have been taken in court against Fonterra and Z is climate. That's a climate. So that's tort. That's a tort claim, and that's a legal definition of what it is. So that is a legal terminology that is used when someone sits down there and takes a claim against your actions, and actions such as what Mike Smith is doing.
Can I also mention last year there was a New Zealand Herald article about a person in Eastdale who lives now in a caravan because his house was destroyed by the floods. He wanted the forestry business that was responsible for the slash to be taken to court.
Yeah, and here's the problem. This might sit down there and stop holding those forestry companies for their slash from being accountable, because here's the other thing is, they could say that this bill it provides some immunity which would halt any proceedings, because in a legal sense, if someone claims to have immunity or claims to have privilege, like immunity from a crime or immunity from an action, as been proven with Trump claiming he had presidential immunity, you cannot. You have to halt the proceedings while it goes through its process to sit there and go up through the courts, which could halt actually the proceedings. It's a very touchy thing on there.
Yeah. I'll just also add, Paul Goldsmith is not doing himself any favors with this bill, nor is the coalition government, to be honest.
I completely agree with you there, and this will go down in history.
Yeah.
Okay, well, we've got Deborah Russell here, who is going to be announcing a Labour Party campaign policy in her speech.
Is that the motion be agreed to?
Madam Chair.
The Honourable Dr. Deborah Russell.
Madam Speaker, Labour opposes this bill, and I announce now that in government, Labour will repeal this bill. My colleagues who are lawyers will no doubt take the House through the reasons that on a legal basis that this is very, very bad law. But I wish to speak to some of the reasons that the Minister has given for pursuing this course of action. There were a couple of major reasons that the Minister gave for pursuing this course of action. One was that the impending legislation creates uncertainty for business. But looking through the advice that the Minister was given, looking through the regulatory impact statement and the background advice, officials pointed out that it was not clear that the impending legal action created any more uncertainty than already exists in business. that over time statutory bars tend to be whittled down anyway, so that creates uncertainty. And in fact, they had not even consulted any business to find out whether there would be uncertainty. It is a very thin reason, and one that is not backed up by his own officials. The second major reason that the Minister gave for this particular piece of legislation was that our response to climate change was best managed through the elected officials, through the Parliament and through the Executive. But let's look at this government's record on climate change. They have reversed the ban on offshore oil and gas exploration. They have excluded agriculture from the emissions trading scheme. They have ended the clean car discount. They have gotten rid of the Climate Emergency Response Fund. They've cancelled GIDI, the fund for helping industries transition away from fossil fuels. They've weakened climate reporting requirements for big business. They've cut public transport subsidies for young people. They've backed out of the Beyond Oil and Gas Alliance. They've refused to sign up to the pathway for transitioning away from fossil fuels. They've allowed the emissions trading scheme to fray to the point of collapse. They have diluted the clean car standard. They've cancelled Auckland Light Rail. They've added excessive road user charges to electric vehicles. They've removed regulations for low emissions buildings. They've cancelled the Lake Onslow pumped hydro scheme. They've created an independent panel to review the methane target. They've decoupled the emissions trading scheme from our Paris 2050 targets. They've reduced the barriers for coal mining resource consents. They've changed the Crown Minerals Act to promote oil and gas exploration. They've shut down New Zealand's green investment violence. They've subsidised fossil fuels through a $200 million co-investment in oil and gas exploration. They've changed the deadline for a carbon neutral public service from 2025 to 2050. They've reduced the methane target in the Climate Change Response Act. They've stripped $6 billion out of the National Resilience Fund. They have an appalling record on climate change. And yet that minister says that businesses, that New Zealanders, that ordinary people should rely on the executive and the Parliament to manage our climate change response. And that is why he is engaged in putting a statutory bar on any torts cases. Now, we cannot rely on this government. We cannot rely on this government to address climate change, as is shown by the way that they have littered the landscape with cancellations and with backtracks. We cannot rely on them to do that. So one of the only courses of action then that has to be available to us is through the courts, and they are cancelling that course of action too. What a wretched thing to do. They are cancelling it on the spurious grounds, not backed up by the minister's own officials, that it will cause business uncertainty. And they are cancelling it on the grounds that the executive is the entity best placed to manage our response to climate change. But in that respect, they are an absolute failure. So, Madam Speaker, as I said, the Labour Party opposes this bill and we will repeal it in government.
What do you think about Deborah Russell's, what do you call it, cue cards with the words on both sides?
Yeah, like, can I also add to what Deborah, like, let's say theoretically, my house got destroyed in a storm. This bill not only just protects responsible business, if you know what I'm saying, or the forestry business. Say, for example, my house got destroyed in a storm, and then I have an insurance claim, if you know what I'm saying.
Yeah.
And then suddenly the insurance uses that bill national pass, if you know what I'm saying.
To get out of it.
Yep. What's my next recourse, if you know what I'm saying?
Exactly. Sue the government, sue the Attorney General for not being able to sit there and sue someone.
And so, for example, if I have, say, my house got destroyed in a storm and I live out of pocket, and I can't find
we flying down the Hutt River because that's the one that lived. That's the river that is something that potentially could plausibly happen. Is say a stop bank at Waikato suddenly sits down there and breaks, sits there, picks up all your houses in White Lines West, and then sit down there and have them all flying into the Wellington Harbour.
Yep. And what happens if insurance doesn't want to pay out?
Yeah, exactly. And actually, and under this tort law, will Greater Wellington Regional Council with stop bank failure not be potentially liable? It puts things into a very iffy situation here.
This bill doesn't just protect business; it protects insurance and the regional council. I'm not against the regional council, but this is only a theoretical situation.
Yeah, it could protect them from malpractice.
Yeah.
such as if someone decides to, well, actually, it could be a bit questionable who actually did, but say someone sitting there and basically dismantled the stop banks, and then next minute we end up being flooded. Like, I mean, if they took away all the stop banks along the Hutt River, basically Tighter Drive will be flooded every time like water reaches a certain level down there, considering Tighter Drive is not far off from the level from with the Hutt River at a very peak flowing point. I mean, they already have it with the riverbank market, like the fact that if high water flows are on there, it gets postponed. It has also been said that people who have parked their cars in the riverbank car park and gone floating down the river.
Yeah.
Yeah.
And say, for example, if someone parked at the riverbank car park near Lower Hutt and they lost their car to a flood and they need to replace it and their insurance refuses to pay out, I think that's going to really drive someone mad.
Well, exactly. And actually, that's a good point. Does your insurance policy cover your vehicle damaged in a flood if it's parked in the riverbank car park because it's over the stop bank? That's a good point there, Alex.
Yeah.
And technically, the insurance companies could say no because you're parking over parking in parking on the wrong side of a stop bank.
Yeah. And in other words, this bill protects insurance from taking account from paying out.
Yes, even though technically they'll sit there and try to pin GW for the insurance claim.
Yeah.
Yeah, I know what you're saying. Yeah. So while we have a bit more fire on there, let's see if Steve Abel sits down there and what do you call it, fans the flames.
Steve Abel.
This is a disgusting piece of law, Madam Speaker. It is not a clarification, it is a nullification. It is a nullification of the right of citizens to exercise their equality before the law and hold those who are harming them through their negligence and through their nuisance accountable for the harm that has been caused to that citizen. It specifically extinguishes the right of Mike Smith, who is taking New Zealand's biggest polluter, Fonterra, to court to hold them account for the harm that they are causing to his whānau and his hapu and his iwi. But in extinguishing his right, it extinguishes the right of all citizens to do the same thing in regards to climate change. The existential challenge of our time, Madam Speaker. In Mike Smith's words, the case was always about standing up for our communities. I took this case because these companies have caused enormous climate harm while escaping accountability for decades. Fonterra and other major emitters have already lobbied themselves out of meaningful accountability under New Zealand's climate laws. Now, after fighting me through the courts for 7 years, they are trying to eliminate the right of every New Zealander to challenge them in court at all. This, Madam Speaker, is when Fonterra says jump, the Luxon government says how high. Because this bill has been directly and explicitly lobbied for by New Zealand's biggest polluter to the highest office in this land, the office of the Prime Minister. And Fonterra came to the Prime Minister and said, hey, we don't like this citizen expressing their rights to take us and hold us account for the harm we're causing. Can you please strike out that right? And the Minister there, who shamefully looks at his phone, is doing exactly that right here today in this House of the New Zealand Parliament. And I said in my earlier speech, Madam Speaker, that this government needs to be held to account for the accusation of corruption in this regard. Because at what point does the direct lobbying by a big, powerful company to a politician to extinguish a citizen's rights, at what point do we name that what it really is? The bill explicitly says that a citizen is not entitled to hold the government, a polluter, to account for climate change-related risks or threats to the continuation of a safe and habitable climate system, endangering or impairing the life, safety, health, property or comfort of the public, harm, impairment or loss to the physical or economic existence of that citizen, interference with use or enjoyment of or damage to or loss of property. These are all the consequences of climate change, Madam Speaker, that we know very well. These have been felt by people across the entire country, across the entire world. and they are caused by climate pollution. And there is no regulatory or legislative mechanism that actually holds Fonterra to account for their pollution of methane or their pollution of nitrous oxide. And they make up 25% of New Zealand's total emissions. So Mike Smith went to court, and now this government is saying you cannot go to court. The principle of common law is that we are all equal before the law, Madam Speaker. That principle came in as an alternative to the tyranny of kings, the tyranny of the powerful, the tyranny of the wealthy. This government is reinstating the tyranny of the wealthy. It is reinstating the idea that if you're big enough and you're powerful enough, you can go and tell the government what to do. Most of us, Madam Speaker, most citizens don't have the key to the Prime Minister's office, but Fonterra does, and they even know their own shame is that they hid the fact that they lobbied for this bill. And the Ombudsman has come out and found them guilty to have done that. They hid the fact that they lobbied to nullify citizen rights. It's a shameful day in the House of the New Zealand Parliament, Madam Speaker.
Simon Court.
Definitely feel the fans that are being thrown from Steve Abel.
Could I also say another theoretical situation on what this bill could do? Say, now, I'm not trying to say a disaster. Say, for example, an avalanche happens at Mount Cook. If you know what I mean by avalanche, and it takes out the village beneath it. What do the residents have when it comes to recourse if the insurance doesn't pay out and they have no options left?
Actually, I wonder what happened in... What was the name of the one, the Crown Fiction image on that was the coal slurry damage. I'd like to call it Aberdeen, but it's not Aberdeen, but it's something along those lines. But it was the one where the coal slurry slid down the hill in an avalanche and killed basically buried half the town and killed a bunch of children because it went straight for a school.
Yeah, and I want someone to be helped. I mean,
yeah.
And I want someone, or there'd be options for recourse, if you know what I'm saying.
Pretty much, yeah, exactly, yeah. Yeah. Okay, let's hear from Simon Court on, let me guess, we need a theme song for him, like, guess, 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 guess.
Thank you. I have a far more positive take for those watching and listening at home. The policy that covers New Zealand's emissions, our emissions target, that sets the cost of carbon, is set out in the Climate Change Response Act and in the Emissions Trading Scheme. It's covered by existing policy, Mr Abel. Mr Abel, your grandstanding, your climate alarmism, your donation harvesting doomism, and your cult-like fear-mongering about climate doesn't change the fact New Zealand has well thought-out policies and ways to address climate change in line with our international obligations. And Mr Abel says, what about those lobbying me? They don't need to, Steve. I'm a civil engineer. I understand science. We do not need to be lobbied. And I'll tell you what, all of this narking and nasty commentary and behaviour about that policy guru, Matt Burgess, who came from the New Zealand Initiative. We had the benefit of that gentleman working in the New Zealand government. And I'll tell you what, every time somebody writes to an MP or a minister or a minister's office and shares a problem that their sector faces around flawed policy or regulation or legislation, that's normal and it should be encouraged. And do you know what staff members and ministers' offices should do? They should say, if there's really a problem here, let's fix it. That's the difference between the harping goblins of the climate doom left and this government, which says, yes, we're going to play our part in climate change, but we're not sending New Zealanders to penury. We're not extinguishing the last lamp and going back to live in a cave. We're going to get on with business, with farming, with producing high-quality milk and dairy products that we sell to the rest of the world. And we're going to get our energy out of the ground, whether that's coal, whether that's gas. Hopefully there'll be some nice, juicy, wet condensate coming out with that gas. Debbie Narewa-Paka would know all about that. She's from Taranaki. It's the wet gas that makes the money, Debbie Narewa-Paka. And it makes perfect sense that people who are concerned about an activist, somebody who in their past cut down the tree on One Tree Hill to make some kind of flawed point, I don't know, about sovereignty or whatever it was at the time, is now suing some of our largest corporates with a claim that they've damaged, I don't know, what was it, his mana or the mana of his iwi and hapu or their health, when in fact, what's that, Steve Abel, say it again? When in fact, what is helpful in this bill is making sure, this is what this government is doing, that pending litigation could lead to a finding that causing or contributing to the emission of greenhouse gases results in tort liability. That would create a parallel and contradictory regime to the one provided in, say, the Climate Change Response Act and others. We cannot have activists taking New Zealand businesses to court and then trying to force costs on them that are out of all proportion to their liability. And we know that's out of all proportion, what Mr Smith was trying to do, because these businesses already pay for their carbon emissions under the emissions trading scheme. Furthermore, any emissions that are paid for in New Zealand but are not paid for, equivalent emissions not paid for in another equivalent emitter, just result in carbon leakage. You can squeeze the emissions out of New Zealand, you climate doomers, they're simply going to pop up somewhere else. That is called carbon leakage, and that is what New Zealand law and policy is designed to avoid. So seeking to punish the few rather than accepting there are actually some very effective policies that deal with climate change just ignores reality. ACT supports this bill, and we commend the Minister for bringing it to the House to clarify this.
Now, I love Sonu. Let's see what song it's made. Hold on a moment. Might have to put it like this to make it work.
Both hit the floor, hunger in the wire, hands on the rail, hearts on fire, skin gone thin, eyes wide open, you feel that shake, you feel it smoking. Don't hold back now, let it run. One more breath, then we're done. Gas, 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 gas is moving, gas is moving. Gas, 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 gas is moving, gas is moving.
That one's had enough. Let's see this one.
You came in hard with that empty tank grin. I watched you roll, then you lit it within. Hands on the wheel, I stick straight through. I felt that shake when the whole room moved. Oh, don't let it fade, don't let it stall. Say it like truth, say it through the wall. Gas, 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 gas is moving. Gas is grooving. Gas, gas, keep it coming. Keep it moving. Your voice came soft, but it cut like steel. One little spark, and I knew it was real.
This is another one. Let's see how it goes.
You came in hard with that empty tank grin. I watched you roll, then you lit it within. Hands on the wheel, eyes fixed straight through. I felt that shake when the whole room moved. Oh, don't let it fade, don't let it stop. Say it like truth, say it through the wall. Gas, 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 gas is moving. Gas is grooving. Yeah.
So, what's some light comedy relief at the expense of Simon Court's obsession with gas?
I want to be honest. This is the coalition government is not really doing itself any favors with this.
Well, no. They think they're doing themselves favours. Reality leaders, they're not really doing it. Like, I mean, put it this way. Simon Court can't tell the difference between a Wellington Electricity private-owned lamppost, a Chorus-owned lamppost, or a street, Wellington City Council-owned street lampposts. He seems to conflate them all to be assets of Wellington City Council, despite the fact that they're not.
I agree with what Keith Bridges is saying overall.
I don't know. This might not fit on the screen.
Yeah.
Yeah, unfortunately, Keith, great comment on there. Unfortunately, we won't be able to read out the whole lot of it on there. But if you're on our Facebook page, go and sit there and have a check it out on there. On not sure which Facebook page it came on, whether it was the Autopay podcast or It's in the Bell. But hey, that's all good. Check out both of them and sit down and give a like and follow and check out Kev's comment on there. It's definitely worth the read. Okay, let's see what's coming up from this time from Mark Patterson. And I'm surely we don't need to sit there and make up a song about him.
Before I take the next call, can I just refer members to Speaker's Ruling 55.4, 55.5. I call Mark Patterson.
Thank you, Madam Speaker. I rise on behalf of New Zealand First in this Climate Change Response Tort Liability Amendment Bill, a very important bill, creating a statutory bar for climate change litigation. It restores the sovereignty of Parliament in dictating a climate change response. It adds certainty for business that must operate under New Zealand climate change settings. It has been targeted by activists who are seeking to set up a parallel system which, if allowed to stand, would create a wild west out there in terms of litigation. And it is important this Parliament gets a grip on this situation. Climate change targets are set by government. We have an ETS scheme to reduce emissions, or create incentives to reduce emissions. There is significant, Deborah Russell, investments going into science to reduce our methane emissions. The fast track legislation sees 400 megawatts of generation of renewable energy flooding into our market and under development. We are taking action, but we're taking action driven by government policy, not being driven by activism. This would have had a chilling effect on our business. We're already in danger of deindustrialising in this country because of the high cost of energy. And the irony of Smith taking on Fonterra, the most carbon efficient farmers in the world and the most carbon efficient dairy in the world, we were just going to drive that offshore. In terms of having the keys to the Prime Minister's office, Fonterra, a $25 billion a year company for New Zealand. If they couldn't get access to senior politicians, there is something seriously wrong. This is a very important company for everyone in New Zealand. Fonterra needs to be doing well for New Zealand to do well. So New Zealand First absolutely support this law. It is totally necessary to sort this out. It will create certainty in law. It is common sense, and New Zealand First commend this bill to the House.
They seem to sit there and keep referencing to the part that will cause certainty in law. But is it certainty to be a badly behaved business, doing badly behaved business practices that previously were considered unacceptable?
Can I say this bill pretty much protects bad business practice?
And it protects bad actions. That's the thing there. It protects the bad, and it protects those who need to be hauled over the coals.
Yep.
Yeah. Okay, let's get on to Debbie Narua-Packer and see what comes out from the Taranaki.
Speaker.
Debbie Narua-Packer.
I also stand to take a call on the Climate Change Response Tort Liability Amendment Bill, first reading. Te Pāti Māori also join the sensible members in this House here that can see this bill as atrocious for what it is, and the way that it is proposing to remove any type of accountability. The government is gaslighting members of Aotearoa in saying that this bill is about certainty. It means certainty for some of the biggest polluters of greenhouse gases in Aotearoa, and saying that they can no longer be held liable through the courts
Point
for
of
any...
order, Simon Court.
I don't mean to stop the member in full flight. I'm sure she'll get to say that. But accusing the governing parties of gaslighting impugns the reputation of members by suggesting...
Points of order are heard in silence. Come on.
I'll make the point again. Accusing governing parties of gaslighting impugns the reputation of members because it directly accuses members of not believing what they are saying. And that, Madam Speaker, is a breach of standing orders.
Which standing order is the member referring to?
55. Speaker's ruling 55, Madam Speaker.
Speaking to the point of order, Kieran.
There is a world of difference between suggesting that there is undue influence, as outlined in Speaker's Ruling 55, and pointing out that the government is gaslighting somebody. This is from the same member that in his speech thought he was clever by calling climate change doomsayers and all this nonsense and suggesting that the speech was to do with donations. Now, if he's going to make those sorts of claims, but then cry foul when someone says something as mild as gaslighting, I think that is wasting the House's time.
That is not, in light of the heated debate and the backwards and forwards across the House, I think that's a fair cop on your side. Debbie Nariwa-Peka.
Speaker. And so going back to my comment, and what we are seeing is not only are we hearing from government that activists are not to be respected, that then tells us where this government would have been in the activism of anti-apartheid, in the activism of anti-nuclear, and indeed today in the activism of anti-climate destruction. And what we believe is at the centre of the debate is a credible environmentalist whose waka...
Members, and we have read your submission, but over to you.
Thank you, Kia ora koutou. I'm a lawyer based in Nelson, and so I want to make a couple of points in my oral submission. The first is that, contrary to suggestions I've seen in some quarters, the Supreme Court's decision here is not a novel one. The tort of public nuisance is an old area of law. It's been applied to environmental issues in the past. There are a bunch of cases in Victorian times on water pollution arising from industrialisation. And the cases were quite clear that the fact that you're only contributing maybe a limited amount to the pollution, and there'd still be pollution if you just took away your individual contributions, that isn't a barrier to being found liable for public nuisance. So actually, in my view, the court's decision was quite orthodox in just applying old principles of law to a new context. So I think that that's something to bear in mind when it comes to whether it's justifiable to legislate to override this court decision in this old area of law, when we're talking about one of the greatest challenges we face as a planet and as humanity. The other thing I'd like to say is around the retrospective nature of the legislation. And in this case, it's not just retrospectively taking away people's right to sue and to get a remedy for public nuisance. It's also interfering with existing court proceedings that are currently in existence and before the courts. That's even when Parliament legislates retrospectively, it normally excludes proceedings that are already before the courts. That's because, you know, while retrospective legislation, of course, always raises issues in terms of the rule of law, but there are particularly grave issues in terms of the rule of law and separation of powers when you're interfering with court cases that are in existence before the courts. And so that's the points that I want to make.
Thank you very much. We've got a question from Dr. Deborah Russell.
Thank you, Chair. Thank you, Daniel. Would you see a problem with Parliament legislating after the completion of Mike Smith's case?
Well, I think that would be more satisfactory. You know, that would be a better way to do it. If you felt after the outcome of that case that legislation was necessary, of course, Parliament could legislate, but then it would know what it's actually legislating to. You know, what the actual issue is with the law, because at the moment, all the Supreme Court said is, well, this case can go forward to trial and, you know, we can have a full judgment. It's not untenable. But we don't know whether it will succeed or not. We don't know what the law will look like at the end of that. And actually, you know, interfering with pending cases before the courts is a pretty extraordinary step for Parliament to take.
Thank you.
Fantastic. Well, thank you, Daniel. Nice to see you again. And thank you both for your written and your oral submission. We appreciate it.
Thanks.
Okay, members, we now come to Lawyers for Climate Action. And let's just see who we have got here. We've got Jenny, and who else is going to be with you, Jenny, or is it just yourself?
Laura Mackay. So I don't know whether she's able to be on screen at the same time, but I can hand over to her when I'm finished. That might be.
Okay, we do have Laura on here, so up to you. Jenny, you've got 10 minutes. We have read your written submission, but please do leave some time at the end for questions. Over to you.
Thank you. We'll try to do that. Well, kia ora koutou. My name is Jenny Cooper. I'm here in my capacity as President of Lawyers for Climate Action. And as we were just mentioning, I'm here together with our Acting Executive Director, Laura Mackay. So Lawyers for Climate Action NZ is opposed to the bill. We say it's a disproportionate knee-jerk reaction to one case, which has yet to be decided. It goes against the interests of every single person in New Zealand except the major emitters who lobbied for it. The reason we say that is because everyone suffers the consequences of climate change, such as the damage caused by extreme weather events and sea level rise. But based on this bill, everyone will be left paying for those consequences without any opportunity to seek redress from those most responsible. It is bad law based on bad policy, and it's the result of a deeply flawed decision-making process. I'd like to start with a few comments on the process. First of all, the bill does appear to be a direct response to secret lobbying by Z Energy and Fonterra. It would appear that at their request, the government is seeking to step in to decide private litigation in favour of powerful corporate interests. Now, whatever you think about Mr. Smith's claim, whatever you think about the role of tort law should be in relation to climate change, that sets a dangerous precedent. This bill is an infringement of the rights of Mr. Smith, and it is also directly contrary to the rule of law. Secondly, the process for the introduction of this bill has been unacceptably rushed. There's been no proper consultation, including no consultation with Māori, and the opportunity for public debate has been seriously curtailed. Setting a 10-day submission period, closing at 9 a.m. after a long weekend, sends a clear message that the proponents of this bill have no real interest in public feedback, despite this being a vitally important issue of public interest. So we say that's a serious concern because this bill not only takes away Mr. Smith's claim, but it would effectively impose a total restriction on anyone's ability to bring a claim for damages caused by any event where climate change is a contributing factor. And I'll come back to that, but it does appear that the implications of this don't appear to have been recognised or thought through. And we say that this rushed process is completely unnecessary. Mr. Smith's claim has been on foot since 2000. There has been adequate time to consider its implications. The Supreme Court decision saying it should go to trial was issued 2 years ago. There's no good reason why this issue is now being addressed with urgency. Should I pause for questions? I do have more points to make. What is the procedure?
Make all the points and then we'll have the questions at the end.
Great, thank you. Turning to why it's bad policy. Well, first of all, the stated reason for the bill is to avoid the risk of a parallel regime to the Climate Change Response Act. There is no such risk for the reasons that the Supreme Court held, which is that the Climate Change Response Act does not address issues of compensation, liability for harm, and redress, the issues that Mr. Smith's claim raises and the issues which tort law addresses. So there's nothing in the Act that addresses those issues or that will be contradicted by that. There is nothing in legislation that deals with the question of who is able to claim for compensation and who is liable to pay for compensation for the harm caused by climate change, which includes harm from weather-related events such as floods, droughts, slips, storms, and fires, which we are seeing with increasing regularity. Now, who can claim and who should pay for these losses are difficult and complex questions. It's very arguable that they should be addressed by legislation, but we do not have any legislation that addresses that. Rather than developing suitable legislation to fill this gap, this bill simply says that there is no accountability for major emitters and no way for those suffering from climate harm to seek redress. Secondly, the bill is said to be aimed at ensuring certainty for business. We say it will have the opposite effect, and Laura will touch on that briefly as well. Finally, from me, why the bill is bad law is clear. The drafting process has been rushed. The scope of the bill is extraordinarily wide and likely to have unintended consequences. For example, it protects emitters from liability for any damage to the extent that it was or may have been in whole or in part, directly or indirectly caused or contributed to by climate change. In effect, that means that anyone who contributes to climate change cannot be sued for any damage caused in New Zealand by any extreme weather-related event, such as a storm, a flood, etc., because all of those events will have been at least partly contributed to by climate change. Now, this bar appears to apply regardless of whether the person to be sued's emissions are the reason they are being sued or some other reason. So, for example, if an emitter of greenhouse gases also negligently fails to maintain a stop bank or fails to remove forestry slash and thereby causes a risk of damage to the neighbour's property, based on the wording of this bill, they won't be able to be sued for the damage that may cause if a severe weather event is also a contributing factor to the damage. And I don't believe any consideration has been given to the consequences of that. Finally, from me, before I hand over to Laura, I would ask the members of this committee to step back and reflect on the fact that the bill before them would explicitly protect emitters everywhere in the world from any form of liability to anyone in New Zealand for, quote, threats to the continuation of a safe and habitable climate system. Ask yourselves whose interests such a law would serve and how it could possibly be justified in the public interest. Thank you, and I'll hand over to Laura.
Thanks, Jenny.
Kia ora, Jenny. So there's three more key impacts of the bill I'd like to note. Those relate to the inconsistency of the bill with the Treaty of Waitangi, also with the New Zealand Bill of Rights Act, and also with New Zealand's international obligations. I'm not going to go through our submission, but I do want to highlight a few key points. So first, relating to the Treaty of Waitangi, in addition to the point that Jenny's already made about the rushed and inadequate process, it's important to note that at least according to the regulatory impact statement, there's been no consultation with Māori. That regulatory impact statement itself acknowledges that this is likely inconsistent with the Crown's Treaty of Waitangi obligations. The Crown's provided no good reason for rushing through this bill and no good reason why it's failed to engage with Māori on a bill with such significant impact. I think that's particularly important to note in light of the lobbying for this bill from some of the defendants in the Smith and Fonterra case. As noted in our submissions, if this bill is to proceed, then at a very minimum, a full consultation process should be undertaken, and particularly with Māori. Secondly, in relation to the New Zealand Bill of Rights Act, we've set out in our submission some of the minimum rights that the bill undermines, but one in particular I want to highlight. Under Section 8 of the New Zealand Bill of Rights Act, no one shall be deprived of life except on such grounds as are established by law and are consistent with the principles of fundamental justice. So as noted in our submission, the courts have been steadily developing an understanding of climate change as a threat to the right of life. But in this case, the right to life is actually explicitly recognised in the bill because it bars a range of emissions-related climate change effects, including endangering or impairing the life, safety, health, property, or comfort of the public. It's really difficult to understand why unproven concerns about certainty for business would be prioritised over the right to life for New Zealand citizens. Given that the justifications for this bill have no basis, and also given the significant constitutional risks, the grounds for this bill are clearly not consistent with the principles of fundamental justice that's required by Section 8 of NZ Bora. Thirdly, I just want to highlight specifically the bill's inconsistency with New Zealand's free trade agreements. That's particularly so the EU-New Zealand Free Trade Agreement and the UK-New Zealand Free Trade Agreement. Both of those free trade agreements contain non-regression clauses. So for example, under Article 19.24 of the New Zealand EU Free Trade Agreement, a party shall not weaken or reduce the levels of protection afforded in its environmental or labour law in order to encourage trade or investment. So what's extraordinary then is that the government's been quite clear that the purpose of the bill is to encourage investment, and that clearly engages this article. It's important to note that this bill is not an abstract risk to this free trade agreement. There's mechanisms within the EU through which EU civil society can and already does raise breaches, and New Zealand's backtracking has already been raised within the EU Domestic Advisory Group and within the UK. This creates significant risk for New Zealand exporters. So finally, I just want to emphasise that point that this cumulative inconsistency with so many key international obligations, particularly our free trade agreements, seriously threatens not only New Zealand's clean green reputation, but also our reputation as a stable democracy with a strong rule of law and access to justice. That has the potential to create more uncertainty for businesses and international investors than a court ruling that would have gone through a long, independent, considered and evidence-based process. Thank you.
Thank you, Laura, and thank you, Jenny. We do have a couple of people with questions, but unfortunately we have met our full 10-minute allocation for you, so I'm sorry we won't be able to have them, but we do appreciate you both submitting to us today and also for your written submission on the bill as well, so thank you.
Jenny, I'll drop you a note.
Thank you very much. Now,
Mr. Chair, I wonder if they're still there. This is one of the major groups involved in this area. I'd seek leave for just a couple of minutes of questions.
Well, unfortunately, Jenny's just dropped off. Duncan, Laura,
I'm still here.
Happy to allow one question either from Deborah or Steve, but as I do say in my introductory remarks, 5 or 10 minutes depending on it, and please do allow time for questions. So Steve or Deborah, who would like to ask? Looks like it's you, Steve.
Yeah, okay. Mine's a pretty quick one. Your submission's excellent. You acknowledge there's no regime for compensation or liability currently, and also that there are real complexities. In extinguishing this right of people to take tort claims, is this a big missed opportunity to use the knowledge and the expertise and the intelligence of the courts to find a way through using the development of common law? Aside from all the moral principles overridden, isn't this a big missed opportunity for us to actually use the courts to find us a way through?
Yes, absolutely. And the point I'd just like to make is that the courts are well experienced in doing that. So that is the whole purpose of the tort law and the common law, is to find remedies to these types of problems. Another really important point is that the Supreme Court expressly recognised the importance of tikanga in the development of this. And this statutory bar expressly forbids that from proceeding. So it halts the court's ability to develop the common law as it relates to tikanga Māori as well. So I would agree with you, Steve.
Thanks, Steve. Thank you, Laura and Jenny. Really appreciate your time today. Members, just before we have Fonterra speak to us on their submission, we'll just ask if possible to keep our cameras on where we can, just so our submitters know that we're here and present and listening to what they have to say. Okay, we now have Simon and Charlotte from Fonterra. Thank you for your written submission. We have read it. You have 10 minutes. As I do say to others, please do allow some time at the end of those 10 minutes for us to ask questions. Over to you.
Well, kia ora, good afternoon. Thank you very much. I'm Simon Tucker, Fonterra's Group Director of Global External Affairs, and joining me is our Director of Sustainability, Charlotte Rutherford. And thank you for the opportunity to speak today. To be clear at the outset, Fonterra supports this legislation. This is an important issue for our business, for our farmer owners, and we believe for New Zealand as a whole. Fonterra and 5 other companies are facing a lawsuit where the High Court is being asked to override Parliament's legislative framework for managing greenhouse gas emissions. The lawsuit seeks to order us to immediately cut greenhouse gas emissions to net zero. In practice, if this were to happen, we would need to immediately cease operations. This would have devastating economic, environmental and social impacts, as explained in our written comments. Analysis commissioned by several of the businesses involved, including Fonterra, found that the impact on New Zealand's GDP from this lawsuit in the first year could be more than twice the GDP decline New Zealand experienced during the COVID-19 pandemic in 2020. Fonterra believes strongly that Parliament should set the framework for how New Zealand achieves its emissions reduction goals, not the courts. We do not believe a court case brought by a private individual which attempts to create a parallel judicial emissions regime is the right way to address such a fundamental public policy matter. Our view about the severity of this issue is long-standing, as is our view that this is an issue for Parliament to resolve. As you would expect, given the seriousness of this for Fonterra, for our farmer owners and for New Zealand, We have shared these views publicly and with stakeholders from across the political spectrum over several years. We do acknowledge that in one case, while working on this issue, a Fonterra staff member sent a document to a Beehive staff member's personal email address. This was inappropriate and contrary to our internal policies. This should not distract us from the key issue. It is Parliament, not the courts, that should set emissions reduction targets for New Zealand. Before I close my comments, let me just emphasise that Fonterra's support for this bill should not be mistaken for a lack of commitment to climate action. Fonterra has credible emission reduction targets in place that have been internationally assessed as being aligned to limiting global warming to 1.5 degrees. We are investing hundreds of millions of dollars to continue our significant decarbonisation program. For example, we are now coal-free in the North Island. In fact, since 2018, shifting our manufacturing assets off fossil fuels alone has had the same emission reduction impact as taking almost 200,000 cars off New Zealand roads. We are also working closely with farmer shareholders and other partners to address on-farm emissions and hit our Scope 3 targets. This includes Fonterra being the largest private sector investor in AgriZero NZ, with over $50 million committed. Fonterra is proud of its world-class approach to emissions reduction and remains committed to reducing our impact on the environment. In closing, we would urge the committee to support this legislation to ensure a nationally coordinated framework for New Zealand's response to climate change. Thank you, and happy to answer any questions.
Thanks, Simon. And just before I go to questions, just wanted to see, Charlotte, do you have any comments you would like to make?
Nothing additional. Happy to move straight to comments. Thank you.
Thank you. We'll start with Dr. Deborah Russell.
Thank you, Chair. Hi, Simon and Charlotte. Nice to see you again. A couple of things I want to talk about. One is, Simon, you said in one scenario, we would have, if the court case was upheld eventually, we would have to immediately stop operations. It's a bit hyperbolistic, isn't it?
Well, that is what is the main central plank of the plaintiff's case. If he didn't want to stop our operations, he shouldn't have made that the central plank of his legal case.
Okay, I just feel as though that's, anyway, that's by the by. Look, the other thing I really wanted to talk about was our trade agreements and the extent to which our actions like this might further create concern around whether or not we are meeting some of the obligations in our free trade agreements, particularly with the UK and the EU. Have you done any analysis of that?
We have done some looking at that, and I understand the government has as well. To be honest, we're not particularly concerned about that in this situation, Deborah, because as we understand those trade agreements, it's about New Zealand fulfilling its obligations, for example, to the Paris Accord. And, you know, I think it's pretty clear that Parliament has passed the Climate Change Reduction Act, which will seek to achieve that. I would also note, as I did in my comments, that, you know, we have set emissions reduction targets as a business, which are also consistent with limiting global warming to 1.5 degrees. So it's not an issue that we are concerned about in this instance.
Okay, thank you.
Thanks, Deborah. We've got a number of people with questions. We'll go to Steve Abel.
Thank you very much, Mr. Chair. Let me know if I'm cutting out at all. When did you first lobby the government to extinguish the right of not only Mike Smith, but all New Zealanders to take Fonterra to court for the harms caused by your climate pollution?
I think going back to the initiation of this case, we were pretty public, Steve, in our comments to the media, certainly to any politician who would listen to us, that we thought that this case was trying to do business that very properly believed should be under the jurisdiction of Parliament. We've made no secret of that position, and we've talked to political stakeholders across the spectrum over several years on that basis.
I wonder, how do you address the articulations of deep concern that that level of direct lobbying to the Prime Minister's office expresses an obedience to vested interests of this government that raises the accusation of corruption? And how does that reflect on Fonterra as such a major company in New Zealand directly lobbying the Prime Minister's office with private emails?
I mean, to be honest, we speak to the government, any government, elected government in New Zealand, literally hundreds of times a year on issues. We're a big business, vertically integrated across the New Zealand economy. You know, you want to talk about education and training, you want to talk about trade and geopolitical risk, you want to talk about energy, transportation, railways, ports, infrastructure, education. You know, we have interests in all of those issues, and we firmly believe that government decision-making is best enabled by having good possession of the facts of both to help them make good decisions and to understand the impacts of them. So, you know, this case was seeking to essentially force New Zealand to cease, to stop Fonterra, to cause us to cease operations. And we thought it was important that the government understood how seriously that would impact our farmers across New Zealand, our regional communities, and the New Zealand economy. So we were pretty clear about why we thought it was an important issue.
Thank you.
My final one, Mr. Chair, if that's all right, is that
sorry, Steve. Sorry, Steve. There are a number of other people with questions, so I will need to go to them in fairness. We'll go to Carl Bates.
Thanks very much, Chair. Just in terms of the importance of Fonterra to New Zealand, what amount of taxation does Fonterra pay, and do you have any estimate of what your wider dairy or farmer providers pay into the system?
It's a fair question, Carl. I have to say I don't know off the top of my head how much tax is paid. I mean, I would just observe, among other things, you know, Fonterra is responsible for very nearly a quarter of New Zealand's total exports, that foreign exchange coming in. We know, for example, I think it was last year we paid out $16 billion to our farmer owners. We know that they spend much of that into regional New Zealand. So it does have a very positive impact on the New Zealand economy.
So if Fonterra was to cease, all of the government's activity and work across its environmental activity would be put at risk by that export earnings not happening and that contribution into the New Zealand taxpayer also not earning, I would imagine?
Yeah, I think certainly if we had to cease operations, there'd be a lot of money, a lot of jobs. I mean, I think the other thing that we would highlight is if New Zealand stopped producing dairy, that dairy would be produced in some other part of the world. So somewhat ironically, that would almost certainly happen with a higher carbon footprint.
So what's the importance of having a clear pathway and confidence that that's not a risk Fonterra or its farmer producer base would face or could face?
Well, I think it comes back to the fact that it's Parliament that really is the appropriate forum for these massively complicated national questions to be resolved.
Okay, well, thank you, Simon, and thank you, Charlotte, for joining us this afternoon and for your written submission.
Mr. Chair, I wonder if we could allow a little leeway on Fonterra, given they're the main player in this piece of legislation, to ask a couple more questions.
We have already given them 13, 14 odd minutes, which is over their 10-minute allocation. Unfortunately, we'd be here for the rest of the day, unfortunately, Steve. I am trying to be as fair as I reasonably can, and hence why I gave questions to both you and Deborah to begin with. But I'm doing my best, But thank you, Simon and Charlotte. Appreciate your time this afternoon. We're now going to move to David. David, great to see you. You're with us. David, we've read your submission. You have 5 minutes. Please do leave some time for questions from members.
Tēnā koutou katoa. Thank you for the opportunity to speak today. My name is David Lachlan. I'm a registered architect based in Whangaroa, Raglan, and I appreciate the opportunity to briefly expand on my written submission. When I first read this bill, I found myself asking a very simple question. What problem is the bill trying to solve? The answer I came to was that it seeks to prevent or significantly reduce climate-related tort claims. That concerns me. Not because I expect a wave of litigation, but because accountability is one of the foundations of a fair society. For a long time, our legal system has recognised a simple principle. If someone's actions may have caused foreseeable harm, those affected should have the opportunity to ask a court to examine the evidence and decide the case on its merits. This bill would remove that opportunity for an entire category of claims before the facts can even be considered. As an architect, I'm required to think well beyond the present. The buildings I design may still be standing in 50 or 100 years' time. Every decision carries consequences, and accepting responsibility for those consequences is part of my profession. Climate change asks us to think in exactly the same way. It asks us to consider not only what is convenient today, but what we leave to those who come after us. Much of my life has been spent being in or on coastlines, forests, and rural landscapes across Aotearoa. Those experiences have reinforced something I believe deeply. Land and water are never simply economic assets. They hold ecological relationships, cultural histories, and communities that have developed over generations. When those relationships are damaged, the effects are rarely confined to one place or one generation. For that reason, I don't believe this bill will encourage better environmental decision-making. Instead, I'm concerned it sends the message that reducing legal accountability is an appropriate response to increasingly complex environmental challenges. New Zealand has generally sought to strengthen responsibility where significant harm may occur. In my view, this bill moves in the opposite direction. For those reasons, I respectfully ask the committee to recommend the bill not proceed. Ngā mihi nui. Thank you.
Thank you, David. I will just look to see if any members have a question here. Not at this time, and that's no reflection of your written or oral submission, David, and we do thank you for joining us this afternoon, so thank you very much.
Okay. Thank you.
Thank you, David.
We now come to Z Energy, and we will just get them to come up online. Fantastic. Hi, Patricia, we can see you. That's great. We've got you down for 10 minutes. We have read your written submission, but please do allow some time for members to ask questions. I'm sure there will be some, but we're over to you both.
And thank you for the opportunity to submit. My name is Lindis Jones. I'm the Chief Executive of Z Energy. With me is Patricia Green, Z's General Counsel, who will take the committee through our submission in more detail. We support this bill for 3 reasons. First, climate policy should be set by Parliament, not the courts. Climate change presents some of the most difficult choices our country faces. How we reduce emissions affects jobs, household costs, energy security, investment, and economic resilience. Those are questions of public policy that should be balanced by elected representatives on behalf of all New Zealanders. Second reason is that while climate litigation can have a certain appeal, it is ultimately a poor substitute for climate policy. Faced with a challenge as significant as climate change, it's understandable to want a simple answer or a single party to hold accountable. But New Zealand's energy transition will not be delivered company by company or court case by court case. It requires a coherent framework that balances competing interests, weighs difficult trade-offs, and applies consistently across the economy. We already have that framework in the hard-fought-for Climate Change Response Act and the Emissions Trading Scheme. Third, certainty matters. New Zealand needs significant long-term investment to support both energy security and the transition to lower emissions forms of energy. Clear, stable, and durable policy settings give businesses the confidence to make these investments over very, very long time horizons. The reason we support this bill is not simply because Z is a defendant in the Smith versus Fonterra litigation. The issue at stake is much larger than that. Clear, stable, and durable. Cool. I'll start again. The reason we support this bill is not simply because Z is a defendant in the Smith v Fonterra litigation. The issue at stake is much larger than that. Also, we're not here to comment on any individual or details of that specific litigation. Even if we weren't involved in those proceedings, we would still support the bill because we believe climate policy works best when it is applied consistently across the economy rather than individually through court cases focused on a small number of individual companies. But also, let me be clear, our support for this bill should not be mistaken for a lack of commitment to climate action. We support New Zealand's transition to a lower emissions future and are investing in that transition today. Supporting this bill is about how climate policy is made, not whether emissions should be reduced. The fundamental question before the committee is not whether climate change requires action. It does. The question is who should determine New Zealand's pathway forward. And we fundamentally believe that responsibility sits properly with a democratically elected parliament. Thank you for your time. I'll hand to Patricia.
Thank you. From a legal perspective, the claims before the courts remain novel and unresolved. The litigation seeks to establish forms of climate-related liability that have not previously been recognised by New Zealand courts. More recently, the remedies sought have expanded to include immediate net zero obligations for the defendants. We have presented the committee with evidence about the potential consequences of those remedies. Independent modelling indicates that the remedies sought against the defendants could reduce New Zealand's GDP by at least $21.9 billion over 5 years. If similar obligations were extended across other businesses and sectors, the impact could be substantially larger again. This highlights the nature of the claims before the court. They are not directed at a single activity or a discrete harm. They seek outcomes with potentially economy-wide implications. There is also an important issue of certainty. Businesses make long-term decisions about investment, infrastructure, and employment. A stable and predictable legal framework helps provide the confidence needed to make those decisions. Where lawful activities may become subject to new and uncertain forms of liability, that uncertainty can affect long-term planning and investment. That is why we consider it important that the bill applies to current proceedings as well as future claims. Without that clarification, uncertainty could continue for many years while the litigation proceeds through the courts. The bill provides certainty about the role of tort law in addressing climate change by preserving the existing role of the courts in enforcing the statutory mechanisms through which climate-related issues can continue to be considered. We're now happy to take any questions.
Thank you, Lindis, and thank you, Patricia, for your submission. And balance of fairness, we'll start our questioning with Steve Abel.
Thank you, Mr. Chair. It's very kind. There is currently no law that requires you to reduce your climate pollution or remedy anyone for the harms caused by your climate pollution. Is that your understanding?
So in terms of, so just having sound issues at our end, Steve. So in terms of the first thing I'd say is the products that we sell and the emissions they create, we don't deny. However, how we go about reducing those emissions in amongst all the other emissions that are produced in the New Zealand economy is a complex set of choices, and there are already rules and legislation set out in the Climate Change Response Act. Just unilaterally choosing one company or one sector runs the risk of adverse impacts across society and the economy.
Do you not think that lobbying directly to extinguish the democratic right of all New Zealand citizens to hold you accountable for the harms caused by your pollution has the very nasty taint of problematic influence of vested interests on our democracy? And that's exactly why the public is so disturbed by this law.
I think, Stephen, this is not about whether emissions should reduce. This is not about whether we as a country should deal with the challenges of climate change. We absolutely should and have. It's how we go about doing that. These challenges in front of us as a country are complex and require trade-offs. And those trade-offs are best made by elected officials, not by individual judges or courts that don't have all that information or responsibility available to them.
Because those elected officials can more readily be influenced by big, powerful companies like your own. Is that what you're saying?
I reject that framing.
All right, Dr. Deborah Russell.
Actually, I've heard a few questions, so I'll just stand down in favour of Camilla, otherwise we may not get to her.
Okay, Camilla Belich.
Thank you. I just wanted to ask, why did you specifically lobby the government to introduce a law that would not allow Mr. Smith's existing proceedings to proceed, rather than lobbying the government to wait until after the High Court determined Mr. Smith's case?
Oh, so the case in front of the courts at the moment started in 2019. It's set down to in front of the court in 2027, and undoubtedly there's likely to be a series of appeals after that. That'll take us well into next decade. That's a long time for significant uncertainty in terms of how we can progress the investments needed to help our customers transition. And that level of uncertainty we think is untenable, where the government has the opportunity in front of them now to make a choice to reinforce the Climate Change Response Act in the coordinated, efficient way that gives us the best chance as a country to deal with the challenges in front of us in terms of reducing emissions.
Quick supplementary, Mr. Chair. Just in terms of that answer, wouldn't it have been better to actually see if what you were trying to prevent was actually ordered by the courts, rather than preemptively asking the government to extinguish those rights? Because it might be that the uncertainty that you're worried about would never actually eventuated, and as you say, it was unlikely to happen until many years into the future.
Yes, so many years into the future, and that's a lot of uncertainty and challenge for several large companies across New Zealand that would just like to get on and deliver for our customers now, while helping our customers transition to a lower carbon future. It's not only the uncertainty, but the significant expense that goes with that. And we've already got, this isn't a discussion about whether we should transition or lower emissions or not. We are. It's actually what's the most efficient, effective way to do that on behalf of all New Zealanders. And I just can't believe under any circumstance that sits with the courts to make that call on behalf of us all.
Okay, time for one final question from Carl Bates.
Thanks, Chair. Just in regards to the challenges that have been raised around the lobbying activity that's taken place, would it surprise you to hear that as parliamentarians we are lobbied by a whole range of organisations, individuals, businesses on a daily basis? And it wouldn't be a surprise that some of those discussions lead to parliamentary legislation being introduced to the House?
I accept that assertion, Carl, but I also want to point to that the discussion around the lobbying and the presentation of evidence and information to the government has got away from the substance of this discussion, and that's unfortunate.
Exactly. Agree with you.
Thank you very much, Lindis and Patricia. We really appreciate your time this afternoon and for joining us. So thank you. Okay, members, we now move to Port Stafford Limited and JAFL, and we've got Tony and Bridget joining us this afternoon. Both are online already. So as you'll know, we've read your submissions. Great to see you both. Please leave a little bit of time at the end for any questions that members may have. Over to you.
Thanks, Tom. As you have explained, we are appearing on behalf of Port Stafford Limited and Givealittle, who represent over 3,600 investors who sought relief in the Horton and Saunders cases, more commonly known as the Feltex litigation. I am the Managing Director of Franks Ogilvie, a commercial public law firm here in Wellington, and appearing with me is Tony Gavigan, who is the Director of Port Stafford and Givealittle. This submission supports this bill. Smith and Fonterra was a strikeout decision. Ultimately, the Supreme Court did not finally determine whether there would be climate tort liability. It held that there were claims that should be allowed to proceed to trial in circumstances where Parliament had not clearly displaced tort liability in the climate field. This bill basically supplies the clarity that the court said was missing. It confirms that emission-related climate change effects are to be dealt with through the Climate Change Response Act and public regulation, not private tort litigation. It is not Parliament defying the courts. It is Parliament doing only what Parliament can do, which is setting a general rule for a systemic problem. If it was to be applied only prospectively, as some have claimed it could, it would not address that live uncertainty that Smith and Fonterra has created. We also note that the drafting is broad because the public choice and the policy choice here is broad. Tort law is not to be the mechanism, as this bill sets out, for allocating responsibility for emissions-only related climate change effects. Now, you may be asking, what is the relevance of the Feltex litigation and why we're presenting today? The Feltex litigation is a practical comparator to these circumstances. Briefly, for those members not familiar with Feltex, this was a major investor representative action arising from the 2004 public offer of shares in Feltex Carpets. Thousands of shareholders alleged that the prospectus was misleading, and when the shares were issued at $1.70, Feltex later failed and investors suffered substantial losses. The case was, in brief, managed in two stages. At the first stage, shareholders obtained a partial success, basically at the Supreme Court, finding that one allegation of misrepresentation was established concerning a 2004 revenue forecast in that prospectus. Stage two would have dealt with reliance, causation, loss, and remedy, but it never happened. What, as this case shows, is that there was a procedural and systemic legal problem that was left to judge-made law without an adequate statutory framework. I'm going to turn to Tony now to provide you with his personal experience of how that affected him and other investors.
Hey, just on mute, Tony. We can't hear you, I'm sorry.
In the interest of time, it might be best if I provide, these are Tony's words, not my own, but just providing, and if Tony is able to resolve his tech issues, he can jump in. So Tony was involved in the Feltex representative litigation for many years, as expected, and for him it taught him what judge-made law means in practice when thousands of people are caught in a systemic claim without a clear statutory authority. It involved thousands of investors. The prospectus, in his opinion, was misleading. And this was established in one part, as we said, by the Supreme Court. And it was meant to go to stage two, including issues of remedy. So noting importantly that this was a right was established and it didn't actually ever receive a remedy. Stage two never happened. The investors got the significant finding, but this caused a significant access to justice failure. And it became part of the process of forging New Zealand's judge-made class action regime that we see today. In this case, private litigants should not have had to carry the cost of building legal machinery that Parliament should have supplied. And behind that failure is those thousands of investors. This is not an abstract about civil procedure, although that we could go into the depths of that. It was about a Supreme Court finding that had no practical path to remedy, and this is how it connects to this bill. Tony has applied that this is why the bill matters to him. It shows that Parliament is prepared to say that this field should not be left to judge-made law, and he supports that in the climate context. He also asked the committee to note, and you'll see that in the written submission, that Feltex raises the same broader institutional problem in representative actions, litigation funding, and fair trading remedies. In an exceptional case where investors suffered total or near total loss after investing basis on an untrue registered prospectus, Parliament should consider whether a buyback or whole-made remedy should be available. Tony absolutely accepts that this is separate from the subject of the climate bill that is currently before you, but shows that the principle should apply. When judge-made law has produced systemic uncertainty or injustice, Parliament should and can legislate. I'm not sure, Tony, whether you've managed to get sound.
I think I have. Can you hear that, Bridget?
We can.
Thank you very much. I've got little to add other than to say that in the Feltex case, there was actual harm. We've been in the process since 2008. That's an extraordinarily long period of time, and we have not achieved justice.
Thanks, Tony. Thank you, Bridget. We do have time for questions. First person with their hand raised was Carl Bates. You're just on mute, Carl. Okay.
Oh, that was the hand not down from last time. Apologies.
Camilla Bellich.
Thank you. Thanks for your submission, both of you. In your submission, you state that the Parliament should not shy away from corrective action when there has been a decision by the courts. And I just wondered, in this case, it appears to me that the courts have not been able to make a determination. And so isn't it a bit premature to suggest that Parliament is making corrective action when the case is yet to be determined? Or maybe you have a view on the timing of the case that you would like to share.
I think Bridget should address that. That's more of a legal question.
I think there has been a determination that it is open to the courts to find a climate change tort liability. And I think the point made earlier by other submitters is that the wheels of justice are incredibly slow, and in that time you create significant uncertainty and significant cost. Therefore, it is appropriate for Parliament to determine at this stage that they wish to intervene and correct where the decision so far of the court.
Camilla, do you have a supplementary, or you're okay?
So good, Jim, Mr. Chair.
Question from Steve Abel.
Thank you very much, Mr. Chair. Look, in terms of the slowness of the wheels of the courts, isn't that the exact problem we're facing with climate change? The painfully slow lack of action from the state, which has caused someone to take a civil claim. And here we have billions of people caught in an existential threat. Shouldn't we be using the full faculties of our society's machinery in terms of the estates of the courts and the Parliament to find ways through and allow such an important tort case to seek out whether there is a right of remedy for a private citizen to play out? Isn't that exactly why we should let this run its course? And if the court oversteps, the Parliament can step in and amend that.
If I could,
sorry, Tony, you go ahead.
if I could respond to that, this bill will pass with urgency and the certainty will exist. That just does not happen in the legal system where, as Davey Salmon said to me a few years ago, if you can get one major aspect of a major case through the Supreme Court per annum, you're doing really well.
But this certainly exists for who? Not for those suffering the existential harms of climate change.
Well, Parliament's elected by the people of New Zealand, so we elect the people who will represent our views. And I think the views that we've heard so far from the people who also support this bill cover tens of thousands of New Zealanders.
And billions of dollars of capital commercial interest.
Yes, for sure, and that's what keeps us alive. And we can prove in the Feltex case, by analogy, there has been actual harm. At a risk of being seen to be a heretic, there's many issues about the connection between the parties that are being looked at and the alleged harm.
Thank you, Tony, and thank you, Bridget. Appreciate both of you joining us this afternoon for your written and your oral submission. Thank you very much. Thank you, members. We now come to Oliver. Hi, Oliver. Thank you for joining us. We have received and read your written submission, so thank you very much. You have 5 minutes. Please do allow some time for questions as well. Over to you.
Thank you. Can you hear me okay?
We can.
Excellent. Well, my name is Oliver Hales. I'm an international law lecturer currently based at the London School of Economics. So thanks for the opportunity to present. I will leave a few moments for questions at the end. So I'm presenting my view in opposition to this bill. We all know that Mike Smith won his appeal, and now you're being asked to stop the case going to trial. Let me begin by pointing out that this type of bill would breach one of the oldest rules of international law if it were to affect a foreign national doing business in New Zealand. For example, many years ago, an American gold miner doing business in South Africa won his case before the South African High Court. Then Parliament passed a law which declared his mining licenses invalid and prevented him from claiming any remedy before the courts. Subsequently, an international tribunal held that this act of Parliament, quote, did violence to fundamental principles of justice recognized in every enlightened community. And we call this a denial of justice. Now, of course, Mr. Smith is a New Zealand citizen, but I want you to hold in mind this key point that you're being invited to treat him worse than the international minimum standard that is expected by overseas investors. In fact, the bill is inconsistent with New Zealand's international obligations in at least 3 key areas. So first, the bill is inconsistent with the climate obligations confirmed by the International Court of Justice and welcomed by New Zealand recently in the UN General Assembly. A bill to bar tort liability of this type seems to fall short of the duty to use all available means to regulate high-emitting companies, which would include maintaining access to justice. Second, the bill is inconsistent with human rights obligations. And indeed, the UN Human Rights Committee, in a case involving New Zealand, has confirmed that a country legislating to prevent a pending case would breach the right to a fair and public hearing. And that's exactly what this bill does, which would expose New Zealand to possible censure from a universal human rights monitoring body, if indeed an individual communication were to be brought before that forum, which might be something to think about for this Justice Committee. Third, the bill is inconsistent with some of New Zealand's trade agreements, which prevent the weakening of environmental law for the purpose of encouraging investment. The Minister has said that's the very point of this bill. So in other words, the bill exposes New Zealand to complaints from, say, the EU and other trading partners because it distorts the level playing field between these trading partners. So to conclude, the bill is meant to give businesses certainty and to reduce their legal risk. Instead, in my view, it increases New Zealand's own legal risk, including through possible international proceedings, and its reputational risk in diplomatic and economic relations. More generally, this denial of access to justice through legislative interference signals, I think, a sovereign risk of regulatory turbulence when future governments are obliged to change tack, which of course would undermine the very investor confidence that this bill is meant to protect. So thanks for your attention. I look forward to any questions you might have.
Thank you, Oliver. We have a question from Dr. Deborah Russell.
Thank you, Oliver. It's a really interesting submission. I just want to clarify, you're at the LSE, so why are you commenting on this law in particular? What's your interest in it? Aside from the obvious international law implications.
Oh, well, of course, I am a New Zealand national. I've been out of the country for about 8 years, though I am returning soon. And I have an academic interest in international law, focused on energy investment, environmental disputes. And I thought there was an international dimension to this issue that might otherwise go underexplored.
Yeah, thank you for giving us your expertise on it. Appreciate it.
And a question from Rima Narkley.
Thank you, Mr. Chair. Hi, Oliver. Kia ora. Thanks for your submission. I just want to ask, so would you say that emissions-related climate harm is a really important and profound subject matter?
Emissions-related climate harm, certainly it is an important and profound subject matter, yes.
And such a profound and important matter should be made, decisions about it should be made by a court, not by Parliament, since it's so profound and important?
Well, I think the character of harm to the climate system from greenhouse gas emissions has called for this duty of due diligence in all states to use all means at their disposal to regulate the conduct, in particular, of private emitters. Yeah.
Thank you, Oliver. Really appreciate you joining us. I'm sure it's the early hours of the morning where you are, but thank you very much for your written and your oral submission as well.
Thank you.
Okay, members, we now have Business New Zealand, and we're going to have Catherine and Ben joining us. Catherine's online already, which is great. Catherine, you've got 10 minutes. We've read your written submission. Please do leave some time at the end for questions that members may have. Over to you.
Thank you very much. And it's just me, Catherine Beard, Director of Advocacy for Business New Zealand. Thank you for the opportunity. Business New Zealand supports this amendment bill. This kind of litigation needs to be ruled out once and for all by Parliament. Failure to do so leaves every business in New Zealand at risk of being sued for greenhouse gas emissions, particularly the energy-intensive trade-exposed firms that need to be globally competitive to stay in business. Climate change is a global problem and needs a global and a country-level response, which is how it is being addressed internationally. If New Zealand shut down completely and ceased all commercial and industrial activity, it would have little impact on global emissions, since we comprise 0.17% of emissions. We already have a legislative and cross-party response to emissions reductions in the Climate Change Response Act 2002 that has us on an emissions reduction path to 2050. We have an emissions trading scheme that puts a price on all emissions and fuel. This is a least cost approach to emission reductions, which is not only important to keep our businesses viable, but to keep the cost of living reasonable as well. I would suggest that any political party that tried to take a high cost approach to emission reductions would not last long in government. If the New Zealand Parliament allowed a system whereby businesses that are already paying for emissions were also able to be sued through the courts, we would become a very damaged economy very quickly. And I can supply the Select Committee with 2 different economic reports to back this up. No other country in the world would let their businesses be sued in the courts for greenhouse gas emissions when they already had a legislated approach. It would be economic lunacy, frankly, and they would move quickly to fix it. The Select Committee should also take into account carbon leakage, which is what happens when the cost of emission reductions in one country is significantly higher than other competing countries. Businesses can simply shift production to other countries with a lower cost approach to emission reductions. Often this is worse for greenhouse gas emissions, as the production of goods may be more carbon intensive, and we've not only lost jobs and goods being made domestically, but the climate is worse off as well. If we don't stop this kind of litigation, New Zealand will be very unattractive to foreign investment as well. If Z Energy was shut down, for example, there would be one less competitor in that market, and no international business would be keen to take their place. Thank you.
Thank you, Catherine. Fantastic. You left plenty of time for questions, and we've got a question from Todd Stevenson.
Thank you, Catherine. A couple of things you mentioned. You mentioned having this parallel, basically the Climate Reduction Act, and then particularly the potential to be sued in the courts as well, would lead to a damaged economy, I think was your words. Can you outline what that would look like practically?
Oh, look, it would be very significant, particularly when, one of the companies in the gun for this is one of our biggest exporters and employers in New Zealand. We've actually done a bit of analysis on what would happen just if we priced agricultural emissions as an example. And regional New Zealand is actually really hard hit. So, you're talking, just looking at the numbers, 54,000 jobs in key upstream and downstream industries nationally are vulnerable. And on-farm employment in sheep, beef and dairy employ a further 44,000 people. So you're talking 100,000 jobs just if you put a price on agricultural emissions. And a lot of the impact of that is actually closure of the meat processing and the dairy processing companies. So a lot of these energy intensive businesses are regionally based, and they're also big employers.
And just one quick follow-up, I might, Mr. Chair. You also mentioned, obviously, and we've actually heard evidence this morning that the court, if this court case went on, it could take many years to resolve, and that can create some uncertainty. In your experience, Catherine, how do companies make investment decisions, and what kind of timelines are they looking at, and what kind of certainty do they need?
Well, look, I think one of the downsides of this kind of litigation dragging on for years is it's a distraction to the businesses, but it's a huge cost. Millions and millions of dollars are spent on lawyers' fees and court time and all of that kind of thing. We think we've got a productivity problem in New Zealand. We need to be spending all that money on innovation and R&D and growing our businesses. We already have a system to reduce greenhouse gas emissions. This would be doubling up and would be very detrimental.
Thank you.
And a question from Carl Bates.
Thanks very much, Chair. Thank you, Catherine. In your experience, who ultimately pays these costs that these companies are incurring from having to defend these actions? And what impact does it have on the New Zealand consumer if a business such as Z Energy was to fail in terms of where they would get that product from?
Well, look, everything ultimately flows through to consumers, and that is actually why dealing with climate change globally is such a wicked problem, because politicians tend to like to promise the public and voters that this will be painless and low cost and a better future. And yes, we will get to a better future, but it's actually a wicked problem because it's expensive to get there in the short term. So that's why it really matters that we take a really thoughtful, gradual reduction to 2050 that businesses can afford, because they pass those costs on to consumers. So, and if you lose one of your energy suppliers, you've just reduced competition. So there's less competition, and your fuel prices are probably going to go up.
Thank you. And a final question from Dr. Deborah Russell.
Oh, thank you, Catherine. You talked about uncertainty for business. What kind of uncertainty is climate change creating for business?
Look, climate change is a thing that businesses have to deal with, but we have to remember it's a global phenomenon. Nothing we do in New Zealand is going to stop the march of the temperatures and what's happening on our coastal areas. It's a global problem. We've all got to work together on it. But actually, no country on its own is going to solve the problem, and particularly not a small one down where we're based geographically. So we have to do our part. I think that's the reason that we've got so much of
stuff around climate written into our trade agreements. So if we don't meet our climate commitments, how's that going to work in terms of uncertainty for business around our trade agreements?
Look, I'm really confident that New Zealand's doing a good job vis-a-vis other countries. I spent 6 years working on climate change policy back in the 2000s, and I've looked at a lot of the other approaches to emission reductions being taken internationally. I think New Zealand has one of the most comprehensive emission trading schemes in the world. The European Union, for example, excludes a lot of the energy intensive industries from their scheme. So I think New Zealand's absolutely pulling its weight and doing as much as any other country. And I'm confident too that our businesses have been on a, I said I've been doing this issue since the 2000s. They've all reduced emissions enormously. And I do have a report that shows how they stack up against their international competitors, and it's good. So,
it's not so much the international competitors, it's the commitments that are written into our trade agreements with such as the UK and the EU, where we can't go backwards in terms of any climate work.
But we're not going backwards because we already have a legislative approach to 2050, which is what all the other countries are doing as well. What you're doing in introducing court cases, which are random, is you're basically doubling up on the commitment.
I disagree.
Thank you very much, Catherine. Really appreciate both your written and oral submission today. So thank you very much.
Thank you.
Thank you, members. We're now going to come to Cody. And I think Cody is online with us already. There he is. Great to have you with us. We have read your written submission. We have you for 5 minutes, and if you can just leave a little bit of time at the end for some questions, but over to you.
Tēnā koutou katoa. I worked at the Marsden Point refinery from around 2007, have lived nearby in Ruakaka and One Tree Point, and am a father of 4. I witnessed emergency shutdowns, major flaring and leaks. I saw how quickly operations could become dangerous. I understand local pollution and climate change are different legal issues. I am not claiming these incidents prove Mike Smith's case. These taught me that the regulations do not remove every risk or answer every question of responsibility. Families and communities still need independent legal accountability. The defendant companies argue before the Supreme Court that this legislation exceeds the court's competence and should be left to Parliament. The Supreme Court unanimously reinstated the claims. It did not decide Mike Smith would win. Applying the strikeout test, it decided the claims were not bound to fail, and that tikanga responsibility amendments require evidence at trial. That matters because tort law is common law. Judges have always developed it case by case through evidence, procedure, and legal principle. That does not mean judges set national climate policy. Parliament sets targets and regulatory schemes. Court decides whether one person was legally wrong, and whether the law provides a remedy. The common law has repeatedly adapted to new technologies and harms. Climate change raises difficult questions of cumulative harm that calls for judicial examination, not prohibition. Parliament had not excluded that role. The Climate Change Response Act created regulation, while Section 23 of the Resource Management Act preserved independent common laws and rights. This bill closes that pathway before the court that perform its function. I accept that Parliament is sovereign, but legal power does not answer whether this use of that power is justified. The bill reaches past conduct, identifies Mike v. Fonterra by name and court number, terminates unfinished proceedings, removes damages, declares the injunctions, covers existing and future torts, and denies compensation. Under Section 5 of the New Zealand Bill of Rights Act, Limits on rights must be demonstrably justified and no broader than responsibly necessary. Regulatory standards principles also required scrutiny of retrospective consultation alternatives and proportionally and the weakness is minimal impairment. The Parliament could let the trial finish. Legislation prospectively preserve, control non-monetary remedies, provide a replacement remedy, or require independent review. When ACC displaced personal injury torts, Parliament supplied replacement compensation. This bill removes every meaningful tort remedy and replaces it with nothing. The government says the bill creates business certainty, but officials found no measurable impact on business confidence, identified no public material suggested the decision was discouraging investment, and did not consult the parties. High admitting sectors, the wide business community, or Māori. The bill may instead create disputes over related activities, indirect effects, overseas conduct, and the boundary between local pollution and climate harm. Officials were advised that statutory bars may reduce clarity and that litigation would likely continue as people test the bar's scope. Business depend on stable law and confidence that existing disputes will be determined by courts rather than changed through case-specific interventions. Section 274 applies regardless of whether another law applied, whether it was obeyed, or whether enforcement occurred. It does not legalize a breach, but it gives the same climate tort immunity to complaint and non-complaint businesses. If regulation is the complete alternative, why does immunity remain when that regulation was breached? There is also a serious transparency issue. A 6-page proposal concerning Smith v. Fonterra sought regulation preventing climate tort claims and expressively included Mr. Smith's proceedings. It relied on sovereign risk investment, funding, and insurance claims, but identified no modelling, cancelled investments, withdrawn lender or insurer that had changed position. The bill adapts the same central mechanism and rationale, then goes further. It expressly protects an overseas person using the Overseas Investment Act definition. It also protects the Crown Ministry and government departments. I am not alleging criminal corruption or claiming I can prove who drafted the bill. The document created a legitimate appearance of targeting lawmaking requiring independent scrutiny. Who requested those protections and what independently verified evidence supported them? Tikanga is directly affected. The bill places tikanga Māori conceptions of non-physical and non-economical harm inside the prohibition. He Hunga Riora Māori said tikanga requires an evidential inquiry and that tikanga evidence would be critical at trial. The bill prevents that inquiry. It may be argued that causation is difficult. New Zealand's global share is small. the ETS regulates emissions or litigation could affect jobs. Those matters are for trial. Mike Smith must still prove standing, harm, duty, causation, and an appropriate remedy. Courts can refuse, narrow, or suspend an injunction, grant only a declaration, award costs, or control proceedings. Allowing this trial does not make every admitter liable. It allows the common law safeguards to operate. My request is simple. Allow the trial to proceed. If Mike Smith cannot prove the case, the court can dismiss it. If the trial reveals a genuine conflict with Parliament framework, Parliament can legislate afterwards, prospectively, and on actual findings. I am not asking judges to set New Zealand climate policy. I am asking that they be allowed to perform their constitutional role, hearing evidence, determining legal responsibility, and developing the common law carefully on one case at a time. I am not asking Parliament to decide that Mike Smith is right. I am asking Parliament not to declare him wrong before his evidence has been heard. As a former migratory worker, nearby resident and father of four, I do not believe families, communities, responsibilities, businesses should not lose equal access to law because the harm is difficult to the defendant and powerful. If this case is weak, let it fail on the evidence. Do not extinguish it before the evidence is heard. That is not regulatory certainty. It is respective immunity. Thank you.
Thank you very much, Cody, for your submission and for joining us this afternoon. We have gone significantly over time, so we thank you for joining us. Thank you.
Thank you.
We now come to Sam Bookman, who is going to submit to us for 5 minutes. Thank you, Sam, for your patience. Have 5 minutes. Please allow some time for questions at the end. Over to you.
Hi, kia ora koutou. I'm Sam Bookman. I'm a lecturer at the University of Melbourne, where I study and teach both tort law and climate change. And I just want to make 3 key points. So the first is around the issue of parallel regimes. I just want to stress that, in my experience and expertise, it's very normal for public and private law regimes to operate in tandem. I think this concern about a parallel regime of regulation is somewhat overblown. One of the reasons for that is in order to precisely to protect individual rights and balance those against the public interest and incorporate them together. So the RMA, which has been in place for decades, expressly preserves tort law for that very reason. Public law sets overall obligations to society. Private law governs those relationships between parties. So for instance, a factory that complies with resource permits may still be liable if it pollutes a neighbour's water. Likewise, the ETS regulates New Zealand's kind of headline emissions and everyone's responsibility in reaching them, not what happens when someone is harmed. So in environmental matters, these regimes work best when they operate together. Secondly, the role of Parliament. So, these regimes do collide sometimes. Courts are not perfect. Micro-level decisions don't always produce ideal macro-level outcomes. And then deciding what to do then is, of course, Parliament's role. But at present, we're not seeing any collision between those 2 regimes. We don't actually know what tort liability for climate harm would even look like. And there's no regulation under New Zealand's existing public law for climate harm or remedies at all. The only economic modelling we've seen is that of Fonterra's, and that's based on the most extreme assumptions about the litigation's outcome, which I'll talk about more in a moment. Where genuine collisions do need adjustment or overhaul, as New Zealand has seen with ACC, resolving those is a complex policy task that takes years, takes extensive consultation and evidence. This bill is not about Parliament answering those questions. It's about shutting down the only active decision-making process that we have ongoing on these processes and deciding that private emitters don't pay a share of responding to climate harms and doing so in an incredibly rushed process. Finally, I want to say a little bit more about what the Smith and Fonterra litigation actually seeks and what its potential impacts are on New Zealand, because I think there's been some pretty wild speculation about that in some of the previous submissions. So Mr. Smith's case seeks a range of different remedies. One of those is a form of immediate injunction. In my view, it's pretty unlikely that a court would award that remedy. Of course, Parliament can respond to that kind of remedy if it were to eventuate. I think it's far more likely to adopt other remedies that don't have that kind of doomsday effect claimed by Fonterra. I'd just be very clear that no one's suggesting Fonterra cease all operations tomorrow, such as obligations to reach net zero by 2020 or start reducing emissions. Nor are Fonterra or others uniquely disadvantaged internationally. Their competitors overseas face very similar cases and obligations. The suggested by Business New Zealand that it's lunacy to allow these cases to proceed is just not borne out. In the United States and in Europe and the United Kingdom, these kinds of cases go hand in hand all the time, and it's the same kind of accountability sought by litigants in those countries as well. So I'll leave it there and happy to take questions.
Thank you, Sam. We have a question from Dr. Deborah Russell.
Thank you, Sam. I see that you're a New Zealander, and so appreciate you having your input onto this. I just want to go to those two things you touched on just most recently. You said that what Fonterra said earlier, that they'd have to stop operations immediately, is actually hyperbole. You think is that an okay assessment of it?
I think that's right. I mean, look, it is one of the remedies sought in the litigation is an immediate injunction. I think it is extremely unlikely that a court would award that. The signals that we've saw from the Supreme Court was definitely much more of a focus on declaratory rather than injunctive remedies. I think, the focus of remedies that we see in public nuisance cases is much broader and more creative than that. And I think it's far more likely that any one of the other 5 or 6 remedies that they have sought in the alternative are more likely. In the event that a court did issue a remedy that had the inevitable consequence of Fonterra ceasing operations, then we can see how fast Parliament can move to address those issues. I just think that's enormously speculative at this stage to suggest that's what's going on.
Thank you. And I see you teach in tort law and climate change. Do you know of other cases around the world where tort law has been used successfully in a climate case or that are underway?
So there's a range of cases underway, particularly in North America and in Europe. In Europe, some of those cases have been found, liability has been established at a trial level, though not upheld. And usually what happens precisely in those cases is courts come to a conclusion that the kind of injunctive relief, extreme injunctive relief, is not appropriate. And what's needed is some kind of more declaratory, creative approach. Those cases remain ongoing, and I think they provide a very fruitful dialogue for the establishment of policy in this area.
Thank you.
Thank you, Sam. We have met our allocation of time. I'm sorry, Carl, but we appreciate you joining us this afternoon and for your written submission too.
Thank you.
Okay, members, next submitter is Ling Yi Wong, and he is with us now. Ling Yi, thank you for joining us. You have 5 minutes. We have read your submission, and if you can just leave some time at the end for questions.
Thank you. Tēnā koutou katoa ko Ling tōku ingoa. So I agree with the submission made by lawyers for climate action. I just want to make 3 points. First is a fresh point, and I want to clarify 2 points I made in the written submission. So first, I see that the bill is analogous to the statutory bar in tort to seek compensation in personal injury under Accident Compensation Act. However, that bar is accompanied by ACC itself. The idea is that instead of the court deciding which person causing personal injury paying who, ACC, that means the government, will pay instead, and the government pays for the cost through ACC levy, so no one is out of pocket unfairly. Going back to this bill, given that every household suffers material injury because of climate change, for example, direct out-of-pocket expenses due to climate change-related flood, or through increase in house insurance premium, what the bill does is statutory bar anyone seeking compensation in tort from those who cause climate change. There is no ACC equivalent in this bill to compensate households for their out-of-pocket expenses. So this government even explicitly exempt agricultural sector from the emission trading scheme, so there's even less avenue to pay for climate change-induced damages. Therefore, I do not see the fairness in this bill. So this is the first point. The second point I want to reiterate is that the bill takes away the autonomy of the court. The Smith and Fonterra decision is not saying that the respondents definitely have to pay. The court is simply saying that there's a case for them to answer, and it is still an open question who has to pay and for how much. This bill, however, bars the court from even investigating an open question. So in this sense, I would say that this government is behaving like a nanny state. The third is that I do not see a democratic mandate given to national New Zealand First all act to enact this bill. So I do not see from the policy platform in 2023 or in the coalition agreements a promise to enact this bill. So given the substantive nature of this bill, as a lot of submitters has already mentioned, I think the government needs specific democratic mandate from the electorate to enact this bill. So I would recommend putting this bill on hold until the government has sought such mandate in the coming election. So thank you very much.
Thank you, Ling. I will just see if any members have a question for you. Does not appear to be the case. Thank you so much for your written submission and joining us this afternoon as well. Members, our next submitter is not here at present, so we are going to move forward to Robert, and if they turn up, then we will go back to them. So we'll just have Robert promoted. Hi, Robert. Thank you for joining us this afternoon. We have read your written submission. You have 5 minutes. We do ask that you leave some time at the end for questions. We see you've got yourself on mute. If you wouldn't mind just unmuting so we can hear what you have to say. Over to you. We can't hear you, Robert, if you are trying to speak. Okay, while we try to see if Robert can sort out his sound issues, we might see if Vernon is online. He is. Fantastic. Hi, Vernon. Thank you for joining us. Let's see if we can get your sound issues. Oh, great. We can see and hear you. That's fantastic. You have 5 minutes. We've read your submission. If you can just leave some time for questions, please. Over to you.
Kia ora koutou. I'm an associate professor at the Faculty of Law at the Auckland University. Before I joined the academy, I was in private law practice, 14 years as an RMA lawyer with clients covering the whole field, major emitters, environmental groups, Crown entities, infrastructure providers and others. So at Auckland Law School, I teach public and environmental law. As noted in my submission, I was one of a group of practitioners and academics asked to provide input to this idea of a statutory bar on climate tort claims in July of last year. And I've included in an appendix to my submission key points from a briefing paper that I sent to officials. If the committee hasn't looked over it already, I would ask you to do so. It won't take long. It sets out the substantive reasons why I think the amendment bill misses the mark, why the fear of allowing the Mike Smith case to go to trial, the frankly hyperbolic and implausible disaster scenario pitched by Fonterra today is misplaced, and why, in my view, the best way to proceed would be to let the case go to trial. As Cody said, let's see what the judge says. And as Sam noted, it's always open to Parliament to respond legislatively once the outcome of the case is known. Fonterra is not going to go bust. Parliament would not let that happen. But to stop the case now in its tracks would remove what should be seen as a brilliant opportunity for the government, for you as lawmakers, to address what I describe in my submission as a major information asymmetry between large emitters and regulators, to secure robust information about the ability of large companies to reduce their emissions, the kind of information that you really only get through the discipline of a court hearing, with briefs of evidence sworn under oath, lawyers from both sides cross-examining witnesses, and the cold logic and the scrutiny of an independent judge delivering a reasoned ruling. But I don't want to use any more of my 5 minutes on substance. I'd like to talk about process, and I'd like to talk about good lawmaking. One of the major contributions of the coalition government this term has been to put the process of lawmaking under the microscope. National and Act's coalition agreement included a joint commitment to improving the quality of regulation by increasing transparency and accountability of lawmakers, and this culminated in the passing of the Regulatory Standards Act last year. Of course, there are different views on the RSA, and it's not perfect by any means, but it tries to impose a discipline on lawmaking, setting down in a statute a set of principles for responsible regulation, touching on rule of law, preservation of property rights, obligations for good lawmaking that I highlight in paragraph 6.4 of my submission. The RSA doesn't just list these principles, it puts in place process requirements to make sure that these norms of good lawmaking are complied with. So the Chief Executive of the sponsoring government entity, the Ministry of Justice here, has to produce a consistency statement testing a bill against each of the principles. And then the Minister has to respond to that statement. And third, a new entity, the Regulatory Standards Board, is charged with assessing bills against the framework. Now, has that happened here? Well, no, not systematically or publicly at least. And that's because those process obligations sit in a part of the Regulatory Standards Act that came into force on the 1st of July, and the amendment bill was introduced 2 days before on the 29th of June. The process obligations conveniently don't kick in. The machinery for good lawmaking championed by National and Act, passed by Parliament, doesn't apply because the amendment bill now before you was slipped in 2 days before the opening whistle of the RSA regime. Now, that doesn't stop you as committee members from playing your own role in this lawmaking process. Whether or not a majority of the committee agrees with my and others' substantive concerns with the bill, I urge you to seriously consider whether you are in a position to recommend that the amendment bill be passed. Without the benefit of an independent assessment of the amendment bill's consistency with the principles of responsible regulation in the RSA, there is a strong case, in my view, for recommending that further consideration of the bill be delayed until that process has occurred and the outcome made publicly available and reported to the committee. Kia ora.
Thank you, Vernon. We have time for one quick question from Dr. Deborah Russell.
Thank you, Vernon. In the papers that were released alongside when the bill was tabled in Parliament, we got access to the advice that had been given to the Minister, including a consultation with experts like you and others. But the way it was reported was in terms of some people said this, some people said that. We couldn't get a sense of the weight of evidence on either side. Do you have any insight into what most constitutional law experts would have said, or what the weight of evidence was around this proposed legislation?
Yeah, well, look, I can't speak for others. I can only speak for myself. But my strong sense is that from a constitutional law perspective, there are serious shortcomings with the process that has been adopted by the executive branch in relation to that bill. From my perspective, speaking with colleagues, there are serious concerns about the constitutional propriety of this bill, the interference with live court proceedings, interference with rules of good lawmaking, as I've described and as I say in my submission. So although naturally there's going to be a range of views on this, from a constitutional and public law perspective, there are serious problems with the bill.
Thank you.
Thanks, Vernon, and thank you very much for joining us this afternoon. We really do appreciate it.
Kia ora.
Okay, now members, we come to Robert. Robert, we can see and hear you this time, which is fantastic. We have read your submission. You have 5 minutes. Please do allow some time for questions.
Thank you. I'm a retired English solicitor. I'm not in practice, but I have practiced for 50 years, and some of my work was concerning European law. So I thought I'd stick to that. The basic point I want to make is that if this bill goes through and this tort is not actionable in New Zealand, plaintiffs who want to sue New Zealand companies will go forum shopping, and they will get a response from other jurisdictions if there is no remedy to be had here. What the international norm will be in relation to the particular tort of emitting greenhouse gases is yet to be determined. It will emerge. But we do have the European Communities Directive 2024/1760, which requires a company of a certain size in the EU to take steps to identify its adverse impacts to the environment, including by way of climate change, and to do what it can to minimize them. And that includes pressing other contractors in its chain of activities to do the same. Now, New Zealand exports a lot of stuff to the European Union, and it is extremely likely that European companies doing that will be subject to the European law. So there's a ready forum for disgruntled people going to be available in 2029 when this comes into force. So my essential point is that this bill is going to be ineffective to get the result that is required. There's also the liability that it's going to be repealed. It's not a popular act. There are constitutional objections to it. The interference with live litigation, as the last speaker mentioned, is constitutionally wrong. I can't think of a British government that's done it since James I tried it on in 1607. But this government has done it twice. The first with the Credit Contract and Finance Act of last year, and now this one. And this is not a good look. New Zealand should not be telling the world that politicians can be persuaded to interfere with live litigation here. That is the essence of what my paper says.
Fantastic. Thank you, Robert. I will look to see if any members have a question. We do, from Dr. Deborah Russell.
Thank you. I wonder if you'd just like to remind the committee what happened to James I.
James I was newly come to the Scottish throne, and he tried to try a case himself. He said, well, I'm a king, I'm a perfectly sensible bloke, I'll try this case, and he did. And the Chief Justice didn't like that, and judicially reviewed his decision, judicial review being the modern term for it, but he just simply struck out the king's decision. The king was terribly upset and said this is treason, and the Chief Justice said, well, you may be the king and you may be terribly wise, but you're not a lawyer, and decisions shouldn't be made by politicians or people like you who don't actually do it for a living. And the king backed off, and I don't think any British government's tried it since. And certainly I don't think the New Zealand government should be doing this. You've got a perfectly good set of judges. You're a respected common law jurisdiction. You really can't not have a tort dealing with this important issue.
Thank you.
Thank you, Robert. Appreciate you joining us this afternoon and for your written submission as well. Thank you very much. We now come to Jane Kelsey. Jane, great to see you and have you with us. We have you down for 5 minutes. We have read your submission, but please take it from here.
Kia ora. I'm a retired emeritus professor of law from the University of Auckland. My areas of specialisation include law and policy, te tiriti o Waitangi, and international trade agreements. So firstly, I'd like to reinforce the points that have been made about the constitutional significance of what is being done here, both in terms of te tiriti o Waitangi and the balance of powers, but also the impacts on future measures on the climate crisis. Because the time is short and time to analyse the bill has been exceptionally short, I just want to focus in particular on the trade agreements area. In my opinion, this bill puts the Crown in breach of its commitments, certainly under the Trade and Sustainable Development chapter of the Free Trade Agreement with the European Union, with potential implications as well that I haven't been able to examine in depth on the Free Trade Agreement with the United Kingdom, but also potentially raising investor-state disputes if the right to sue is reinstated at the detriment of an investor that has access to ISDS under one of New Zealand's agreements, such as Canada under the CPTPP. So let me just explain what I think the implications are that the committee needs to consider here, which are not just legal, but they are reputational, they are diplomatic, and they're potentially economic. So as a context to the issues in the EU FTA, in particular in Chapter 19, What we've seen from the current government is a series of aggressive measures that have wound back cumulatively the commitment of New Zealand to the NDCs and obligations under the Paris Agreement. We've also seen in this legislation in particular an attempt to reduce risks and create incentives for investors, including foreign investors, to the detriment of climate action. That approach evidentially has been pursued despite advice in the regulatory impact statement. The regulatory impact statement recognising that the Crown has not met its treaty obligations and not met the quality assurance criteria that are required for such legislation. It also comes in the wake of the disclosures of the non-disclosures of the Official Information Act information from the Prime Minister's office. This has real consequences in terms of the obligations, in particular under Article 19.2 of the Trade and Sustainable Development chapter of the EU FTA, what we call the non-derogation or the non-regression rules, which is basically not weakening the current levels of protection afforded in environmental law in order to encourage trade or investment, and not through cumulative actions weakening the commitment of New Zealand to achieving its Paris objectives. The fact that the advice has in fact on the agreements has been redacted from the risks suggests that there is a lot of smoke to go with the fire. So I want to link my submission to another submission that you have received from Fernando Hernandez from both ends in the Netherlands. And this shows us where this potential breach may lead. Both ends is a member of the Domestic Advisory Group established under the New Zealand EU FTA. The Domestic Advisory Group has a responsibility to oversee the implementation compliance with the Trade and Sustainable Development chapter in that FTA. They discussed, the EU's Domestic Advisory Group discussed New Zealand's backtracking at its recent meeting in May. And they reminded the European Commission that New Zealand had in fact supported at the United Nations the endorsement of the ICJ's advisory opinion in relation to climate change and hence the relevant jurisdiction. Now, under that chapter, the Domestic Advisory Group can lay a formal complaint through what is called the single entry point. It is pretty clear, I think, from the interventions that we've seen that whilst the European Commission itself may not challenge New Zealand's non-compliance with that chapter, civil society groups in Europe may well do so by initiating a complaint through the single entry point under that chapter. That will have significant legal, diplomatic, and even economic consequences if this act proceeds, because a breach can, in relation to the Paris obligations, even lead to the reduction or suspension of New Zealand's tariff concessions under the agreement. And so I want the committee to be very well aware that if this bill passes, it will likely have very significant consequences.
Thank you, Jane. Really appreciate your submission. We've got time for one question from Huhana London.
Kia ora whai, Jane. I just wanted to follow up with you from a taha Māori perspective and around the te treaty breaches that you've referenced and the risk that this bill poses to the Crown Māori relationship, as well as the ripple effect that this decision will have around lawmaking and the judiciary moving forward.
Kia ora, Huhana. Yes, as you will know, I've been an expert witness in the Waitangi Tribunal's climate change inquiry, which has been looking on behalf of Ngā Toki Whakarururanga specifically at the implications of the trade and investment agreements, both the ISDS and the fact that these commitments New Zealand has made include commitments that relate to its obligations to Māori, both in terms of process and substance in relation to the climate crisis. And the fact that the RIS made it clear that certainly in terms of the process, this bill was non-compliant with Te Tiriti, but also the fact that the legislation that the litigation that Mike Smith is bringing is sourced in tikanga and sourced in the Crown's treaty obligations. And so I would expect, going back to my point about the domestic advisory group process in the EU, the equivalent domestic advisory group here, which has Māori members on it, including Tanya Pōwhare from Ngā Toki Whakarururanga, that those issues will be provided as supplementary to whatever action or complaint is taken in the European Union.
Thank you, Jane. Really appreciate you joining us this afternoon and for your written submission as well. Thank you.
Kia ora.
Members, we now come to Dr. Dean Knight. Dean, we've got you for 5 minutes. We've read your submission. Over to you.
Kia ora to committee. As you'll know, I'm a Professor of Law at Te Herenga Waka, Victoria University of Wellington, specialising in constitutional and government law. And can I start by saying that it goes without saying that under the principle of legislative supremacy, Parliament has the authority to legislate to override the common law as it seeks to do so with this bill here. The question, though, for the committee and the House is whether the exercise of that legislative authority is appropriate, wise, and properly respects other constitutional principles and traditions. My submission is that it does not, and the bill should be rejected or amended, especially to carve out and save Smith's current proceedings. And the 2 points I make are interrelated, one on matters constitutional, one on the underlying policy. From a constitutional perspective, and I start with those concerns, nullifying Smith's current common law claims is objectionable, constitutionally objectionable, because the retrospective effect of nixing the claims undermines the rule of law, because interfering with the judicial process in this way is contrary to the separation of powers and breaches the principle of comity, because taking away Smith's day in court is contrary to his right to justice, and because not preserving the fruits of any victory is contrary to the usual traditions of fairness as reflected in our practice of legislative design and quality. And as an aside, if this bill was introduced 2 days later, once the Regulatory Standards Bill had taken effect, as Professor Rive explained, we would have had a very grim consistency accountability statement admitting to breaches of the principles of the rule of law, good lawmaking, and responsible regulation. Now, if I turn to the policy underlying the bill, the putative rationale is weak and premature. Claims of a need to override the common law to ensure regulatory coherence and to confirm the executive and the legislature's role of developing and setting and implementing regulatory policy are, in my view, dubious and overstated. The short point is that legislation and the common law can generally, and can in this case, work in tandem. Concurrent legislative and common law regulation is not unusual, and I instance a couple of examples in my written submissions. And importantly too, here, the current statutory regime does not cover the field or speak to the damage to individuals the common law claims seek to address. In any event, the nature and reach of the current common law claims are not yet known and still face some hurdles to be realised, and you've heard some about that earlier. The strongest prospects, in my view, lie with the existing and well-established tort of public nuisance, as addressed heavily by the Supreme Court in its ruling. I think the so-called novel claims of climate change cause loss has very low prospects for success. And you've heard also about the prospects of different relief from earlier submitters. And here I caution about being distracted by the novelty of the latter. I think that's a red herring. The principal basis of the claim is in public nuisance and involves the application of pre-existing doctrine to past facts in the usual way that the common law adjudicates in tort claims. Importantly, the weak and, in my view, wafer-thin policy basis for nixing claims means there is insufficient justification for departing from usual constitutional expectations about not legislating over top of live court proceedings. And in my view, the bill should be rejected. But if not, as a minimum, Smith's current proceedings should be excluded from the proposed statutory bar. And I've also floated, if that's done, whether the statutory bar itself should be time limited in order to allow the effect of Smith's claim to be considered once it is determined. Finally, can I close by recording my concern about the expedited lawmaking and select committee process? It's shoddy lawmaking, unjustified procedural and participatory shortcuts without justification that has become all too common and I think are a stain on our democracy. Kia ora.
Thank you very much, Dean. First question from Carl Bates.
Thanks, Chair. Thanks, Dean. In your experience, what would the cost of a court case like this generally be to the defendants?
Oh, it's been over 2 decades since I've been in practice. You know, the costs will be commensurate with the degree of the claim, the complexity of the claim, and those sorts of things. I couldn't offer a view on that.
Okay, fine. And in your understanding of the sort of outcome that could be achieved if the defendant was to lose, what do you see as the potential costs to that company?
I don't know. I mean, I'm not a. I mean, you've heard some earlier submitters talk about the likelihood or the possibility of particular remedies being granted or not. There's obviously the hurdles of liability first. I don't know. We don't know because that hasn't come to pass. It's all premature. But I expect that it's not as grave as some of the hyperbole that's been suggested here earlier.
Okay. The final question: if you know those things, then isn't it entirely appropriate for Parliament to say we don't want to take this risk, we don't want this effect to occur on the New Zealand economy, even if it's slim? And there's two very different sides to that argument. Isn't it entirely appropriate for Parliament to say we're going to remove that risk so that we can actually focus on doing the work to reduce climate change effects in New Zealand?
Well, I guess my submission is that the constitutional costs of doing so well outweigh that risk. And the best thing is for let the case to run, and then allow the courts and the Parliament and the Executive to be in dialogue about the nature of responsibility for these types of liability.
Thank you, Carl. We'll go to Dr. Duncan Webb, and that'll be the last of our questions.
No, thank you. I really only have one question. It's around the idea of a citizen having the right to litigate a claim in the civil courts and the concept of a right to justice. You alluded to it, but I think it's actually at the core of your objections. Can you just expand on the concept of a right to justice as a foundation of the rule of law and why this case is particularly problematic?
Yeah, well, I think it is one of those high points of the right to justice, and that's part of the rule of law, the ability to go to an independent courts to ask for the law to be tested, to be adjudicated based on past facts. You know, that's a fundamental feature of our rule of law, ensuring that we're a rule-abiding society and so forth. And it's been fundamental. I know that that, for example, when the Labour government legislated away the foreshore and seabed claims several decades ago, that there was quite a bit of opposition from the parties in government who are now promoting this bill. You know, so it's a well understood principle that, you know, there's a procedural and substantive aspect of the ability of someone to go to a court and ask, the law should be supreme and should be applied here.
So what constitutional position we ended up with if governments of any colour legislate to whenever they don't like a piece of litigation?
Well, it becomes lawless, you know, because the law that can be applied will be the whims of Parliament. And one of the ideas of the rule of law as a system is we have a system of laws that should be faithfully applied, and people should have the benefit of that. And the benefit of processes like independent courts will allow that to be adjudicated and held to their side.
Thank you very much. Thank you, Dean. Really appreciate your written submission and joining us this afternoon as well. Members, we now have a break till 2:50, so 6 minutes, and I'll see you back online for our submissions from Dunedin Museum of Natural Mystery.
We got old rules in a new day scene, same big principles, different machine. The how keeps changing, tech moves fast, so we check the settings, cut the deadwood past. Special vote stacking like a tower of bricks, playing enrollments, doing overtime tricks. Used to be 2 weeks, now it's 3. If we do nothing longer, you'll see. So we tighten the timing, smooth the lines, start the process earlier, read the signs. 13 days before the big show starts, get your name right where the roll book charts. 13 days, 13 days. Get enrolled before the deadline gates. 13 days, 13 days. Is it speed or democracy at stake? No treats at the ballot, no chips, no tea, no freebies near the box, keep it clean. 13 days, 13 days. Tell me who wins when the rules all change. Auto updates, moving addresses along, go data, keeping details strong. Roll stays current between each race, less last minute chaos, faster pace. Advanced voting, 12-day run, make it formal, job gets done. No costly letters sent by post, more modern system, cut the toast. And prisoners sentenced, no vote while inside, consequences land on the other side. Serious offending held to account, serve your time then re-enroll back on the mound. Mental health detention kept the same, 3 years plus, that's still the frame. And promoted details, safer to share, less risk, less harm, more fair. 13 days, 13 days. Get enrolled before the deadline gates. 13 days, 13 days. Is it speed or democracy at stake? Treats at the ballot, no chips, no tea, no freebies near the box, keep it clean. 13 days, 13 days. Tell me who wins when the rules all change. You should be ashamed, 'cause here's the truth. You made it harder for everyday youth under urgency. Rights get clipped, democracy's ladder missing rungs that slipped. They say timeliness like it's the crown, but it's people showing up, don't shut them down. 100,000 turned up last time, now you call them drop kicks in the grave. If your first vote's turned away at the door, you don't come back, seen that before. So I push this if it won't speed the count. Feels like tilting the field, stacking the mound. They had other options, read the page, but chose the cut, set the stage. Harder to vote, easy to claim, but we see the game behind the name. 13 days, 13 days. Who gets locked up when life derails? 13 days, 13 days. Is it order or a vote or jail? Oh, negotiate weeks for a coalition seat, but won't spare a few days for democracy.
you, kia ora koutou. I'm a lawyer based in Nelson.
Questions from members, and we have read your submission, but over to you.
Thank you, kia ora koutou. I'm a lawyer based in Nelson. And so I want to make a couple of points in my oral submission. The first is that, contrary to suggestions I've seen in some quarters, the Supreme Court's decision here is not a novel one. The tort of public nuisance is an old area of law. It's been applied to environmental issues in the past. There are a bunch of cases in Victorian times on water pollution arising from industrialisation. And the cases were quite clear that the fact that you're only contributing maybe a limited amount to the pollution, and there'd still be pollution if you just took away your individual contributions, that isn't a barrier to being found liable for public nuisance. So actually, in my view, the court's decision was quite orthodox and just applying old principles of law to a new context. So I think that that's something to bear in mind when it comes to whether it's justifiable to legislate to override this court decision in this old area of law when we're talking about one of the greatest challenges we face as a planet and as humanity. The other thing I'd like to say is around the retrospective nature of the legislation. And in this case, it's not just retrospectively taking away people's right to sue and to get a remedy for public nuisance. It's also interfering with existing court proceedings that are currently in existence and before the courts. That's even when Parliament legislates retrospectively, it normally excludes proceedings that are already before the courts. That's because, you know, while retrospective legislation, of course, always raises issues in terms of the rule of law, but there are particularly grave issues in terms of the rule of law and separation of powers when you're interfering with court cases that are in existence before the courts. And so that's the points that I want to make.
Thank you very much. We've got a question from Dr. Deborah Russell.
Thank you, Chair. Thank you, Daniel. Would you see a problem with Parliament legislating after the completion of Mike Smith's case?
Well, I think that would be more satisfactory. You know, that would be a better way to do it. If you felt after the outcome of that case that legislation was necessary, of course, Parliament could legislate, but then it would know what it's actually legislating to. You know, what the actual issue is with the law, because at the moment, all the Supreme Court said is, well, this case can go forward to trial and, you know, we can have a full judgment. It's not untenable. But we don't know whether it will succeed or not. We don't know what the law will look like at the end of that. And actually, you know, interfering with pending cases before the courts is a pretty extraordinary step for Parliament to take.
Thank you.
Fantastic. Well, thank you, Daniel. Nice to see you again. And thank you both for your written and your oral submission. We appreciate it.
Thanks.
Okay, members, we now come to Lawyers for Climate Action. And let's just see who we have got here. We've got Jenny. And who else is going to be with you, Jenny, or is it just yourself?
Laura Mackay. So I don't know whether she's able to be on screen at the same time, but I can hand over to her when I'm finished. That might be.
Okay, we do have Laura on here, so up to you. Jenny, you've got 10 minutes. We have read your written submission, but please do leave some time at the end for questions. Over to you.
Thank you. We'll try to do that. Well, kia ora koutou. My name is Jenny Cooper. I'm here in my capacity as President of Lawyers for Climate Action. And as we were just mentioning, I'm here together with our Acting Executive Director, Laura Mackay. So Lawyers for Climate Action NZ is opposed to the bill. We say it's a disproportionate knee-jerk reaction to one case, which has yet to be decided. It goes against the interests of every single person in New Zealand except the major emitters who lobbied for it. The reason we say that is because everyone suffers the consequences of climate change, such as the damage caused by extreme weather events and sea level rise. But based on this bill, everyone will be left paying for those consequences without any opportunity to seek redress from those most responsible. It is bad law based on bad policy, and it's the result of a deeply flawed decision-making process. I'd like to start with a few comments on the process. First of all, the bill does appear to be a direct response to secret lobbying by Z Energy and Fonterra. It would appear that at their request, the government is seeking to step in to decide private litigation in favour of powerful corporate interests. Now, whatever you think about Mr. Smith's claim, whatever you think about the role of tort law should be in relation to climate change, that sets a dangerous precedent. This bill is an infringement of the rights of Mr. Smith, and it is also directly contrary to the rule of law. Secondly, the process for the introduction of this bill has been unacceptably rushed. There's been no proper consultation, including no consultation with Māori, and the opportunity for public debate has been seriously curtailed. Setting a 10-day submission period, closing at 9 a.m. after a long weekend, sends a clear message that the proponents of this bill have no real interest in public feedback, despite this being a vitally important issue of public interest. So we say that's a serious concern because this bill not only takes away Mr. Smith's claim, but it would effectively impose a total restriction on anyone's ability to bring a claim for damages caused by any event where climate change is a contributing factor. And I'll come back to that, but it does appear that the implications of this don't appear to have been recognised or thought through. And we say that this rushed process is completely unnecessary. Mr. Smith's claim has been on foot since 2000. There has been adequate time to consider its implications. The Supreme Court decision saying it should go to trial was issued 2 years ago. There's no good reason why this issue is now being addressed with urgency. Should I pause for questions? I do have more points to make. What is the procedure?
Make all the points and then we'll have the questions at the end.
Great, thank you. Turning to why it's bad policy. Well, first of all, the stated reason for the bill is to avoid the risk of a parallel regime to the Climate Change Response Act. There is no such risk for the reasons that the Supreme Court held, which is that the Climate Change Response Act does not address issues of compensation, liability for harm, and redress, the issues that Mr. Smith's claim raises and the issues which tort law addresses. So there's nothing in the Act that addresses those issues or that will be contradicted by that. There is nothing in legislation that deals with the question of who is able to claim for compensation and who is liable to pay for compensation for the harm caused by climate change, which includes harm from weather-related events such as floods, droughts, slips, storms, and fires, which we are seeing with increasing regularity. Now, who can claim and who should pay for these losses are difficult and complex questions. It's very arguable that they should be addressed by legislation, but we do not have any legislation that addresses that. Rather than developing suitable legislation to fill this gap, this bill simply says that there is no accountability for major emitters and no way for those suffering from climate harm to seek redress. Secondly, the bill is said to be aimed at ensuring certainty for business. We say it will have the opposite effect, and Laura will touch on that briefly as well. Finally, from me, why the bill is bad law is clear. The drafting process has been rushed. The scope of the bill is extraordinarily wide and likely to have unintended consequences. For example, it protects emitters from liability for any damage to the extent that it was or may have been in whole or in part, directly or indirectly caused or contributed to by climate change. In effect, that means that anyone who contributes to climate change cannot be sued for any damage caused in New Zealand by any extreme weather-related event, such as a storm, a flood, etc., because all of those events will have been at least partly contributed to by climate change. Now, this bar appears to apply regardless of whether the person to be sued's emissions are the reason they are being sued or some other reason. So, for example, if an emitter of greenhouse gases also negligently fails to maintain a stop bank or fails to remove forestry slash, and thereby causes a risk of damage to the neighbour's property. Based on the wording of this bill, they won't be able to be sued for the damage that may cause if a severe weather event is also a contributing factor to the damage. And I don't believe any consideration has been given to the consequences of that. Finally, from me, before I hand over to Laura, I would ask the members of this committee to step back and reflect on the fact that the bill before them would explicitly protect emitters everywhere in the world from any form of liability to anyone in New Zealand for, quote, threats to the continuation of a safe and habitable climate system. Ask yourselves whose interests such a law would serve and how it could possibly be justified in the public interest. Thank you, and I'll hand over to Laura.
Thanks, Jenny.
Kia ora, Jenny. So there's three more key impacts of the bill I'd like to note. Those relate to the inconsistency of the bill with the Treaty of Waitangi, also with the New Zealand Bill of Rights Act, and also with New Zealand's international obligations. I'm not going to go through our submission, but I do want to highlight a few key points. So first, relating to the Treaty of Waitangi, in addition to the point that Jenny's already made about the rushed and inadequate process, it's important to note that at least according to the regulatory impact statement, there's been no consultation with Māori. That regulatory impact statement itself acknowledges that this is likely inconsistent with the Crown's Treaty of Waitangi obligations. The Crown's provided no good reason for rushing through this bill and no good reason why it's failed to engage with Māori on a bill with such significant impact. I think that's particularly important to note in light of the lobbying for this bill from some of the defendants in the Smith and Fonterra case. As noted in our submissions, if this bill is to proceed, then at a very minimum, a full consultation process should be undertaken, and particularly with Māori. Secondly, in relation to the New Zealand Bill of Rights Act, we've set out in our submission some of the minimum rights that the bill undermines, but one in particular I want to highlight. Under Section 8 of the New Zealand Bill of Rights Act, no one shall be deprived of life except on such grounds as are established by law and are consistent with the principles of fundamental justice. So as noted in our submission, the courts have been steadily developing an understanding of climate change as a threat to the right of life. But in this case, the right to life is actually explicitly recognised in the bill because it bars a range of emissions-related climate change effects, including endangering or impairing the life, safety, health, property, or comfort of the public. It's really difficult to understand why unproven concerns about certainty for business would be prioritised over the right to life for New Zealand citizens. Given that the justifications for this bill have no basis, and also given the significant constitutional risks, the grounds for this bill are clearly not consistent with the principles of fundamental justice that's required by Section 8 of NZ Bora. Thirdly, I just want to highlight specifically the bill's inconsistency with New Zealand's free trade agreements. That's particularly so the EU-New Zealand Free Trade Agreement and the UK-New Zealand Free Trade Agreement. Both of those free trade agreements contain non-regression clauses. So for example, under Article 19.24 of the New Zealand EU Free Trade Agreement, a party shall not weaken or reduce the levels of protection afforded in its environmental or labour law in order to encourage trade or investment. So what's extraordinary then is that the government's been quite clear that the purpose of the bill is to encourage investment, and that clearly engages this article. It's important to note that this bill is not an abstract risk to this free trade agreement. There's mechanisms within the EU through which EU civil society can and already does raise breaches, and New Zealand's backtracking has already been raised within the EU Domestic Advisory Group and within the UK. This creates significant risk for New Zealand exporters. So finally, I just want to emphasise that point that this cumulative inconsistency with so many key international obligations, particularly our free trade agreements, seriously threatens not only New Zealand's clean green reputation, but also our reputation as a stable democracy with a strong rule of law and access to justice. That has the potential to create more uncertainty for businesses and international investors than a court ruling that would have gone through a long, independent, considered and evidence-based process. Thank you.
Thank you, Laura, and thank you, Jenny. We do have a couple of people with questions, but unfortunately we have met our full 10-minute allocation for you, so I'm sorry we won't be able to have them, but we do appreciate you both submitting to us today and also for your written submission on the bill as well, so thank you.
Jenny, I'll drop you a note.
Thank you very much. Now,
Mr. Chair, I wonder if they're still there. This is one of the major groups involved in this area. I'd seek leave for just a couple of minutes of questions.
Well, unfortunately, Jenny's just dropped off. Duncan, Laura,
I'm still
Laura
here.
Happy to allow one question either from Deborah or Steve, but as I do say in my introductory remarks, 5 or 10 minutes depending on it, and please do allow time for questions. So Steve or Deborah, who would like to ask? Looks like it's you, Steve.
Yeah, okay. Mine's a pretty quick one. Your submission's excellent. You acknowledge there's no regime for compensation or liability currently, and also that there are real complexities. In extinguishing this right of people to take tort claims, is this a big missed opportunity to use the knowledge and the expertise and the intelligence of the courts to find a way through using the development of common law? Aside from all the moral principles overridden, isn't this a big missed opportunity for us to actually use the courts to find us a way through?
Yes, absolutely. And the point I'd just like to make is that the courts are well experienced in doing that. So that is the whole purpose of the tort law and the common law, is to find remedies to these types of problems. Another really important point is that the Supreme Court expressly recognised the importance of tikanga in the development of this. And this statutory bar expressly forbids that from proceeding. So it halts the court's ability to develop the common law as it relates to tikanga Māori as well. So I would agree with you, Steve.
Thanks, Steve. Thank you, Laura and Jenny. Really appreciate your time today. Members, just before we have Fonterra speak to us on their submission, we'd just ask if possible to keep our cameras on where we can, just so our submitters know that we're here and present and listening to what they have to say. Okay, we now have Simon and Charlotte from Fonterra. Thank you for your written submission. We have read it. You have 10 minutes. As I do say to others, please do allow some time at the end of those 10 minutes for us to ask questions. Over to you.
Well, kia ora, good afternoon. Thank you very much. I'm Simon Tucker, Fonterra's Group Director of Global External Affairs, and joining me is our Director of Sustainability, Charlotte Rutherford. And thank you for the opportunity to speak today. To be clear at the outset, Fonterra supports this legislation. This is an important issue for our business, for our farmer owners, and we believe for New Zealand as a whole. Fonterra and 5 other companies are facing a lawsuit where the High Court is being asked to override Parliament's legislative framework for managing greenhouse gas emissions. The lawsuit seeks to order us to immediately cut greenhouse gas emissions to net zero. In practice, if this were to happen, we would need to immediately cease operations. This would have devastating economic, environmental and social impacts, as explained in our written comments. Analysis commissioned by several of the businesses involved, including Fonterra, found that the impact on New Zealand's GDP from this lawsuit in the first year could be more than twice the GDP decline New Zealand experienced during the COVID-19 pandemic in 2020. Fonterra believes strongly that Parliament should set the framework for how New Zealand achieves its emissions reduction goals, not the courts. We do not believe a court case brought by a private individual which attempts to create a parallel judicial emissions regime is the right way to address such a fundamental public policy matter. Our view about the severity of this issue is long-standing, as is our view that this is an issue for Parliament to resolve. As you would expect, given the seriousness of this for Fonterra, for our farmer owners and for New Zealand, we have shared these views publicly and with stakeholders from across the political spectrum over several years. We do acknowledge that in one case, while working on this issue, a Fonterra staff member sent a document to a Beehive staff member's personal email address. This was inappropriate and contrary to our internal policies. This should not distract us from the key issue. It is Parliament, not the courts, that should set emissions reduction targets for New Zealand. Before I close my comments, let me just emphasise that Fonterra's support for this bill should not be mistaken for a lack of commitment to climate action. Fonterra has credible emission reduction targets in place that have been internationally assessed as being aligned to limiting global warming to 1.5 degrees. We are investing hundreds of millions of dollars to continue our significant decarbonisation program. For example, we are now coal-free in the North Island. In fact, since 2018, shifting our manufacturing assets off fossil fuels alone has had the same emission reduction impact as taking almost 200,000 cars off New Zealand roads. We are also working closely with farmer shareholders and other partners to address on-farm emissions and hit our Scope 3 targets. This includes Fonterra being the largest private sector investor in AgriZero NZ, with over $50 million committed. Fonterra is proud of its world-class approach to emissions reduction and remains committed to reducing our impact on the environment. In closing, we would urge the committee to support this legislation to ensure a nationally coordinated framework for New Zealand's response to climate change. Thank you, and happy to answer any questions.
Thanks, Simon. And just before I go to questions, just wanted to see, Charlotte, do you have any comments you would like to make?
Nothing additional. Happy to move straight to comments. Thank you.
Thank you. We'll start with Dr. Deborah Russell.
Thank you, Chair. Hi, Simon and Charlotte. Nice to see you again. A couple of things I want to talk about. One is, Simon, you said in one scenario, we would have, if the court case was upheld eventually, we would have to immediately stop operations. It's a bit hyperbolistic, isn't it?
Well, that is what is the main central plank of the plaintiff's case. If he didn't want to stop our operations, he shouldn't have made that the central plank of his legal case.
Okay, I just feel as though that's, anyway, that's by the by. Look, the other thing I really wanted to talk about was our trade agreements and the extent to which our actions like this might further create concern around whether or not we are meeting some of the obligations in our free trade agreements, particularly with the UK and the EU. Have you done any analysis of that?
We have done some looking at that, and I understand the government has as well. To be honest, we're not particularly concerned about that in this situation, Deborah, because as we understand those trade agreements, it's about New Zealand fulfilling its obligations, for example, to the Paris Accord. And, you know, I think it's pretty clear that Parliament has passed the Climate Change Reduction Act, which will seek to achieve that. I would also note, as I did in my comments, that, you know, we have set emissions reduction targets as a business, which are also consistent with limiting global warming to 1.5 degrees. So it's not an issue that we are concerned about in this instance.
Okay, thank you.
Thanks, Deborah. We've got a number of people with questions. We'll go to Steve Abel.
Thank you very much, Mr. Chair. Let me know if I'm cutting out at all. When did you first lobby the government to extinguish the right of not only Mike Smith, but all New Zealanders to take Fonterra to court for the harms caused by your climate pollution?
I think going back to the initiation of this case, we were pretty public, Steve, in our comments to the media, certainly to any politician who would listen to us, that we thought that this case was trying to do business that very properly believed should be under the jurisdiction of Parliament. We've made no secret of that position, and we've talked to political stakeholders across the spectrum over several years on that basis.
I wonder, how do you address the articulations of deep concern that that level of direct lobbying to the Prime Minister's office expresses an obedience to vested interests of this government that raises the accusation of corruption? And how does that reflect on Fonterra as such a major company in New Zealand, directly lobbying the Prime Minister's office with private emails?
I mean, to be honest, we speak to the government, any government, elected government in New Zealand, literally hundreds of times a year on
questions from members, and we have read your submission, but over to you.
Thank you, kia ora koutou.
It's a good and reasonable thing to ask the question and allow that to play out.
Do we have any more time, Mr. Chair?
Just one short question.
Thank you. Thanks, Doctor. And so, but am I to understand that in the absence of there existing a strong policy framework from the current government or the government of the day, then we default to this decision making via court cases?
Well, it's not my area, but my understanding is that citizens have always had a right to, when they are experiencing harm from others, to find ways to try and minimise that harm. And if governments choose not to do it, then it seems reasonable to see, how that harm can be minimised.
Thank you.
Thank you very much, Christina. Thank you both for your time and for your written submission.
Thank you. Bye.
Right, members, we're going to go to Kaitiaki Whangaroa, who are going to join us. Just going to bring them online now. Here we go. Hi, Bridget. Thank you for joining us this afternoon. We have read your written submission. We have you down for 10 minutes. If you're able to switch your camera on and unmute yourself, please do just leave a little bit of time for questions as well.
Kia ora, Nice Manuel is actually speaking on behalf, and I'm here to support her. Has she been led into the room yet?
She has. Yep, she's just there now. There she is, just unmuted.
Kia ora tātou. We'll take, obviously, our submission as read. Tēnā tātou. Thank you for the opportunity to speak to our submission today. My name's Nice Manuel, he ori ahau o Whangaroa, and I'm speaking on behalf of Kaitiaki Whangaroa. We are here to ask the committee to reject the Climate Change Response Tort Liability Amendment Bill in its entirety. Our central message is this: communities already living with climate harm should not have the courthouse doors closed before the evidence is even heard. For Whangaroa, climate change is not a future possibility or an abstract policy debate. It is being felt now in our rohe by our whānau and our marae. Nationally, about 750,000 people and 500,000 buildings worth more than 145 billion are already near rivers and coastal areas exposed to extreme flooding. In Northland, Te Tai Tokero, climate projections show more intense storms and rainfall events, hot days increasing from about 25 days now to around 90 days a year by 2090, and rising sea levels increasing the risk of coastal hazards and erosion. We see those risks locally in flooding, slips, coastal erosion, rising seas, damage to infrastructure, and increasing pressure on our whenua, moana, wāhi tapu, mahinga kai, papakainga, and mokopuna. These are not only environmental impacts, they affect safety, identity, tikanga, whakapapa, and our ability to carry out our responsibilities as kaitiaki, as mana whenua. The bill asks Parliament to take an extraordinary step. It would prevent affected people, iwi, hapu, whānau, marae, and community organisations from asking a court whether particular conduct that causes or contributes to greenhouse gas emissions can give rise to legal responsibility. That is not a small technical change, it is a blanket legal shield. At the same time, New Zealand's own official emissions data shows that gross greenhouse gas emissions from industries and households were 78,778 kilotons of carbon dioxide equivalent in 2023, with industries responsible for nearly 90% of that total. In that context, communities should not be denied the ability to ask whether serious climate harm can attract legal accountability. The bill would decide before the facts are tested that communities cannot even bring the question before a judge. We are particularly concerned that the bill appears directed at stopping Alpha Nonga Mike Smith's claim in Smith versus Fonterra, Mike is one of our kaitiaki o Whangaroa, and his long-standing mahi within our community gives this issue real and personal significance for us. In February 2024, the Supreme Court unanimously allowed his claim to be reinstated and proceed to trial. That does not mean he has won. It simply means the courts should hear the evidence. If major emitters have not caused legal harm, the courts can say so. But Parliament should not step in now to prevent the case from being heard at all. The retrospective effect of the bill makes this even more concerning. It would reach back into active proceedings that have not yet been finally determined, including Mike's case. A person who has relied on the law, gone through the courts, and reached the point where the Supreme Court has allowed a trial should not have that pathway removed after the fact. This matters because sea levels around parts of Aotearoa have risen about twice as fast in the last 60 years as they did in the previous 60 years, and NIWA has reported on this. It weakens access to justice, that's the point. It also risks undermining confidence in the ordinary role of the courts. For kaitiaki whangaroa, this is also a te treaty, tikanga and kaitiakitanga issue. Our responsibilities to protect whenua, moana, awa, ngahere, taonga and whakapapa, and for our mokopuna, are not separate from law and justice. They are central to how we understand harm and accountability. Article 2 of Te Tiriti affirms tino rangatiratanga over our land, kainga and taonga. A bill that removes legal pathways for protecting climate-affected taonga weakens those protections and makes it harder for hapu, iwi and kaitiaki to uphold tikanga relationships. We also reject the idea that climate regulation means common law rights must disappear. Regulation and court accountability can work together. The courts are able to consider evidence, tikanga duties, remedies, and the limits of tort law. Allowing a case to be heard does not create automatic liability. It simply preserves the right of affected communities to seek answers. Our recommendations are clear. Reject the bill in its entirety. Preserve Mike's right to have his case heard and determined by the courts. If the bill proceeds, remove its retrospective application, protect the ability for whangaroa iwi, hapu and whānau and marae and kaitiaki to bring claims concerning whenua, moana, awa, ngahere, mahinga kai, wāhi tapu, taonga, tikanga interests, whakapapa and future generations. And ensure that any lawmaking in this area is consistent with Te Tiriti o Waitangi me he whakaputanga. To conclude, this bill is not only about emissions, litigation or technical legal rules. It is about whether communities already facing climate harm can seek justice. It is about whether the courts can hear evidence before rights are taken away. We ask the committee to reject this bill in its entirety. Ngā mihi nui kia koutou.
Fantastic. Thank you so much for your submission. I will just see if there are any members who have a question. Does not appear to be the case. That is no reflection of the quality of your submission, and so we really are grateful for you joining us this afternoon. So thank you very much.
Ngā mihi kia koutou.
Thank you. We're now going to go family estate of hereditary chiefs, and we're going to have Honi Wedamu Tauhepa, who's going to be joining us. Hi, Honi. We have you down for 10 minutes. Hopefully you are able to hear us. If you can just unmute yourself. We have read your submission, and please leave a little bit of time at the end for questions as well. Over to you.
Oh, kia ora. The submission this submission is to oppose the bill. In respect of the narrative, first in law, first in time. First in time, first in law. Tēnā koutou katoa. My name is Hone Wirimu Hohepa. I am part of a registry of plus 2.3 million land interest. This represents the 1835, 1840, 2026 family estate of hereditary chiefs of birth and tribal nations. I appear before this committee having been appointed to a voluntary position as a scribe At the 150th commemorations of the 1835 Declaration of Independence in Waitangi on the 28th of October in 2015. In my view, this legislation raises constitutional and treaty issues that deserve careful consideration. My submission is founded on the principle that the Treaty of Waitangi was breached on the first day of signing by replacing the 1835 flag of King William IV Protectorate of Māori maritime law with the 1606 Union Jack flag of Queen Victoria. Since this historical crime took place, a second most historic crime eventuated after the invasion of Aotearoa was in 1852. However, I believe the 1840 Treaty of Waitangi established an enduring relationship between the Crown and Māori concerning the governance, protection, and stewardship of the lands, waters, and natural environment. Climate policy directly affects whenua, forests, waterways, coastal environments, customary interest, and the ability of future generations to exercise kaitiakitanga. For that reason, I believe Parliament has an obligation to ensure the legislation affecting greenhouse gas emissions is developed consistently with the principles of the Treaty of Waitangi and with meaningful engagement with Māori. I also wish to place on record my view that the constitutional developments following the enactment of the New Zealand Constitution Act 1852 fundamentally altered the relationship and established under the relationship established under the treaty. I recognize that this interpretation is not accepted legal position of the Crown, but I respectfully submit that these constitutional questions remain unresolved for many Māori and continue to influence discussions about treaty justice and constitutional reform. In my view, these historical matters provide important context for considering legislation that affects long-term stewardship of Aotearoa New Zealand's resources. Accordingly, I ask the committee to ensure that the treaty implications of this bill are fully examined. Māori rights, interests, and responsibilities as kaitiaki are given consideration. The bill does not diminish existing treaty obligations, and Parliament continues to engage openly on constitutional questions arising from the Treaty of Waitangi. The legal argument opposing the greenhouse gas emissions bill. I oppose this bill because, in my view, it raises constitutional and treaty issues that have not been adequately addressed. So I leave it at that for now.
Thank you very much. I will just see if there are any members who would like to ask you a question. Does not appear to be the case, but we thank you so much, Hone, for joining us this afternoon and for your written submission as well. So thank you for your time.
Thank you very much. Mātua kia koutou katoa.
All right, members, we will move to Deirdre. Hi, Deirdre. Thank you very much for joining us this afternoon. We have read your written submission. We have you down for 5 minutes. Please do leave just a little bit of time at the end for some questions.
Well, thank you. First, thank you very much to the committee for putting in the time to listen to all of us, and it's really important, and I appreciate the work that you're doing. I would ask you to reject this bill in its entirety. I think it opens a backdoor bill to the concentration of power, and so it would be disingenuous of us to continue with it for a number of reasons. New Zealand is famous for its relational law and its connections and communication, and also its relational approach to business. But most What we're seeing here is a parasitical business model, and that is detrimental, especially in a country the size of New Zealand. So small things can have bigger influences here than we realise, and the long-term implications of those things are bigger than what we realise. We don't have a mandate for this. We don't have time to look at the complexities around this, to really properly listen. And that's why we need to uphold the rule of law and allow the law and the courts to do its job properly, and listen to all the submission, or listen to all the people who are called to speak, and they have the time and energy and are built to get to the truth of what's going on. Let them do their job, and let us stand back, and then if need be, at the end of it, then Parliament can step in if it's absolutely necessary. But until it's done its job. Pardon?
Carry on.
So until it's done its job, let it run its course. We are at the risk of breaking lots of international law understanding, and allowing ridicule for New Zealand and wrecking our reputation internationally, because we'll be seen as a country where our politicians can be bought by big business. And I'm sorry, I can't find a nicer way to say that, but that's how it's been interpreted in the few discussions that we've had so far, because it's been on. And also doing something like this under urgency is kind of disrespectful. We haven't got a mandate. It isn't something that any of the elected parties stood on and that we've had time to discuss. So therefore it would be respectful to step back. We are only one of 8 million species. We are not the big be all and end all of everything, and nor is business. There are other ways of looking at how we live our lives and how we are going to bring forth what needs to be brought forth. And it also completely ignores the Treaty of Waitangi, which is one of the founding documents here. And if we're really wanting to work in a collaborative, communicative world, we need to build our relationships, not destroy them. And so I would ask respectfully that you throw out this bill, and that we work together to find cooperative, creative business solutions rather than reinforcing parasitical business solutions. Thank you.
Thank you very much, Deb. Thank you. I'll just see if any members have questions for you. Does not appear to be the case. Just wanted to say thank you so much for your written submission and for joining us this afternoon as well. Okay, we are going to move to Tony Ward. I'll see if Tony is online. All right, I think we're just trying to sort Tony out at the moment, so we're going to go to Alyssa. Hi, Alyssa. Thank you very much for joining us this afternoon. We've got you down for a 5-minute submission. We have read your written submission, but please do leave a little bit of time at the end for any questions the members may have. Over to you.
Tēnā koutou, tēnā koutou, tēnā tātou katoa. This amendment is an attempt by our government to stamp its own authority above the Supreme Court, and it's therefore unlawful. This is one of many actions taken by this government to remove existing legislation and initiatives that aim to reduce New Zealand's greenhouse emissions. It is particularly disturbing that media uncovered that briefings to Parliament were directly written by New Zealand's greatest emitters. Good lawmaking incentivises best outcomes. By protecting business from any liability for significant emissions, there is no incentive for any behavioural change that may result in emission reduction. If significant emitters were penalised according to their impact, then reparations could support our climate climate response, making New Zealand more resilient. In its eagerness to be seen as good for business, this government prioritises short-term financial gain without demonstrating responsible oversight and protection for all life and future generations. Humans are already impacted by climate change. We see that people are needing to relocate because of destruction from weather events of greater ferocity associated with climate change. With our human ability to modify habitat, we are one of the world's most resilient species. But with our capacity to create emissions, we are one of the most harmful. Climate change, it will, the poorest people and the least resilient species will struggle the most and have the worst outcomes. So if as humans we continue with unfettered emissions, many other life forms will disappear as they, unlike us, are unable to go elsewhere or adapt to environmental change. This is expected to include crop foods, and it's likely to result in significant starvation events for ourselves and for all species. As a result of the things I've shared with you, I request you withdraw this bill and enable the Mike Smith climate tort case to proceed. Thank you for this opportunity. Any questions for me?
Fantastic. Thank you very much. I'll just look to see if any members of the committee have questions for you. Does not appear to be the case. Obviously, no reflection on the quality of your submission, and we really appreciate you joining us this afternoon as well. So thank you.
Thank you.
All right, members. Tony Ward has joined us. So we're going to go to Tony. Hi, Tony. Thank you very much for joining us this afternoon. We've got you down for a 5-minute submission. We have read your submission, and please do just leave a little bit of time at the end for us to ask any questions.
Okay. I don't want to reread or represent my petition. I just want to highlight what I consider to be the most important issue going on here. And that amounts to the legislation giving the minister the right to make sole conditions. That's the first thing. The second thing is that this bill itself is only in existence because corporate companies contacted the government, exerted their, I wouldn't say right, but their ability to manipulate and present legislation without the public knowing, and then going on to present legislation which reaffirms that and puts the decision-making process into the hands of the minister. I see this as a complete violation of equality under the law. It means that corporate organizations have immediate ability to change and modify and present and organize legislations that ordinary citizens like myself don't have. And I find that a completely unacceptable and anti-democratic thing to do. Other than that, the legislation itself is a backward step. I think it removes all kinds of opportunities for the Maori community to have input, something that we've built up over the last 40 years. I came to New Zealand in 1942, so I've been here 44 years. And I'm proud over that time to have been a part of the building of a bicultural society that I think most New Zealanders are proud of. This bill removes that. It's a backward step over and above everything else. So I'm quite happy to answer questions if you have them. I don't want to talk about my my written presentation. I've done that, you've seen it. And I just wanted to reaffirm the two most important things.
Fantastic, Tony. We appreciate you joining us. We do have a question from Carl Bates.
Yes.
Thanks very much, Chair, and thanks, Tony, for your submission to this committee today. You've highlighted this issue around, or perceived issue, around the way parliamentarians become aware of legislation. And as an elected MP, I'm dealing even today with suggestions from constituents and businesses in my community about changes they should see in the law. Why is there any problem with businesses and constituents and voters approaching politicians and proposing changes to the law?
Nothing. The only thing that's wrong here is the lie. They did it secretly, they did it behind doors. The Prime Minister denied ever having seen it. I find that really hard to believe. Either he's incompetent and doesn't know what's going on in his own office, or some other thing is going on.
So that doesn't change whether or not the law actually needs to change.
Oh, I think
sorry,
go on.
So that doesn't change whether or not the law actually needs to change, doesn't change the whether or not it's an appropriate issue to raise, and doesn't change whether or not Parliament has the ability to change it. Your only concern is that there was a miscommunication around the process.
No, that's not my only concern. My only concern is that what is happening is a withdrawal of democratic rights for every New Zealand citizen. And we will be unable to challenge any company that comes along to do any dreadful thing in New Zealand. No member of the public will be able to challenge that. And I really object to that.
Okay. Fantastic. Well, thank you very much, Tony, for joining us this afternoon and for your written submission as well. We do appreciate it.
That's okay.
Okay.
Thank you.
Thanks, Tony. A couple of our next submitters aren't here yet, but Kat is here so we're going to jump to Kat. If we can just promote Kat, please. Good afternoon.
Kia ora koutou.
Thank you for being with us early. We do appreciate it. We like it when people turn up nice and early. We have you down for 5 minutes. We have read your written submission and just leave some time for questions, but over to you.
Sure, thanks very much. Tēnā koutou katoa. My name is Kate McInnes. I am Professor in the School of Biological Sciences at the University of Auckland. I'm also a lead author for the Intergovernmental Panel on Climate Change, Assessment Round 7, which is happening now. As a member of Working Group 2, I've been compiling information on the climate change impacts, vulnerability and adaptation options for Aotearoa New Zealand. And this includes assessing policy. I don't speak on behalf of the IPCC today, but I have drawn on the knowledge that I've been developing through this process to come to my conclusions, and I strongly oppose this bill. I have three main points to raise today. The first is that extreme events are going to continue to get worse. The second is that there are also a whole lot of hidden climate change impacts that we're just really not thinking enough about. And the third is that the current policy options are not fit for purpose. So first, climate change is here and now. We will continue to see devastating impacts of extreme climate events, including cyclones, floods, droughts, fire weather and heat waves here in Aotearoa. These cause economic and non-economic losses. In the worst case scenarios, we see loss of human life. This is absolutely tragic, and we saw that in January this year in Mount Maunganui when the landslides occurred in January. Other non-economic costs include impacts on health, culture, identity, social cohesion, biodiversity and ecosystems. And let's talk about economics, because that seems to be a big focus here this afternoon. Earlier, we were given the number of $21.9 billion over 5 years as being the cost, the potential cost of this court case. And that number was given by Patricia Green, I believe is the counsel for Z. So that's the number she gave earlier this afternoon. If we compare that to the cost of Cyclone Gabrielle, Treasury estimated that cost $14.5 billion. and Auckland Council estimated a $4 billion cost for the Auckland anniversary floods. Together, those are almost the amount, just those two events, almost the amount that the people are talking about in terms of what this might cost economically. We are simply not factoring in the cost of climate change to our communities, to Aotearoa. But of course, the events that occur do happen naturally, but climate change is making them worse. So attribution studies help us understand what that climate change contribution is. And as an example of that, modelling of 2 drought events that occurred in the period 2007 to 2017 showed that those drought events costed a total of almost $5 billion to the economy. And the attribution analysis showed that 20% of that could be put towards climate change. So $1 billion of that $5 billion was because of the climate change. So as we move into the future and we have more and more of these extreme events, we will also see them compounding. We will have floods following droughts. We will have fires following droughts. We will have fire then flood. We will have successions of extreme storms, one after the other, and we will not have time to recover between them. The cost of these will mount, and it will not just be economic, it will be so many different things that we can't even really perceive just yet. So that's the extreme stuff. There's also the hidden stuff. So an example of this is we had a warm start to winter this year, and this can cause crop failures. So many of our important crops rely on cooler conditions to stimulate flowering. So the kiwi fruit industry is particularly vulnerable to these warm winters. The cost of that is enormous. Are we factoring that against these decisions that we're making? Other vulnerable crops are apples, potatoes, and a range of other foods. And these kinds of impacts are happening but just not given as much profile as the extreme events. We also know that a lot of the impacts of climate change are quite complicated and will exacerbate other issues. So things like invasive species impacts, pests and diseases are examples of those. So coming then to the policy options, the emissions trading scheme is the current kind of main policy lever that we have, but that is not fit for purpose. What has happened is that we've seen a big increase in planting of pines across the Motu because of that, and pines are highly flammable. As the fire weather gets worse, we will see worse fires across the country. And modelling a couple of years ago suggested that within this century, parts of New Zealand could see the kinds of conditions that caused the Black Summer fires in Australia of 2019 and 2020. And these events could happen every 3 to 20 years, depending on what kind of part of the country you're looking at. So these severe fires are in our future, absolutely and definitely. And so all of the carbon that's tied up in those forests, well, most of it will be lost back to the atmosphere. So the ETS is not doing what it's supposed to do. And we also know that rural and Māori communities are particularly exposed to all of this. And each of these events also then leads into cascades of impact through natural systems, well-being of individuals and communities, economic impacts, and societal and community change. So in conclusion, the current policies are not fit for purpose, and we need every single lever available to us to be addressing this. We need to be looking at how to be reducing emissions, and we need to be holding corporations to account. Thank you.
Thank you, Kate. We do have time for just a couple of questions. We'll start with Todd Stevenson.
Thanks for your presentation. Putting aside whether we agree with you about whether the current kind of policies are working or not, but you talked about attribution, and isn't that really one of the issues here? I mean, we're all responsible for emitting greenhouse gases in some way. And then, as you said, there's lots of complex outcomes. So don't you think that's why it's better to have whether you agree with it, and you've suggested there is more that could be done in a kind of parliamentary government response, but isn't that the reason it needs to actually be led by a government and by parliament? Because we're all responsible, the outcomes are complex, and attribution is very difficult.
The attribution is quite clear, and our largest emitters are the main ones leading to that attribution. So I think the largest emitters need to be held to account. Are they being held to account? No, I would say.
So you can tell me that you could specifically tell me what Fonterra, for example's attribution to specific events across New Zealand are.
No, you know it doesn't work like that.
Oh, well, that's my point. Well, that's my point.
Yeah, but we
right?
do know that, say, Fonterra, you've mentioned Fonterra, they are the largest emitter. So therefore, they have a big responsibility to play in these attribution processes.
But we can't attribute specific emitters to specific. This
It's
is
not
the
like
issue,
the
right?
carbon comes out and goes, oh, okay, we're
No.
going to have it, we're going to cause this one, we're going to cause that one. We can look at proportionality, and I think that's the important point here. The large emitters are having the biggest impact. We can say that for sure.
But that's why I think
Thank
a
you.
government response better.
Thanks, Todd. We'll go to Dr. Deborah Russell.
Thank you. Thank you, Kate, for all the work that you're doing. The government, as one of its justifications for this piece of legislation, says that it thinks we're better off having a legislative approach and the executive doing the work to ensure we deal with climate change. Do you think this government's record is sufficient to hold that up as a reasonable thing to say?
Well, all I can say is from my analysis, we're not doing enough. And so that's why I'm saying we need every lever that we can. And, let's not try and close off the levers that are available to us. And that's why I think this bill is not appropriate.
Thank you.
Thank you, Kate. Really appreciate you joining us this afternoon, and thank you for your submission as well. Okay, members, we'll go to our next submitter, and we'll just see if the clerks can get them promoted. Fantastic. Thank you very much for joining us this afternoon. We have you down for a 5-minute submission, and we have read your submission, but please do leave just some time at the end for questions. Over to you.
Kia ora, can you hear me?
We can.
Beautiful. Kia ora koutou. My name is Anya. I'm a disabled person and I've had a long-standing interest in the kind of intersections of disability and climate justice in particular, but more broadly, just as a human being and the well-being of our communities and the well-being of the tile. So I oppose this bill. I recommend it be withdrawn. Reasoning for that is that I see it as a huge overreach of government power, which is not only about saving the government money, but also saving large corporates money. Even foreign-owned corporates are in scope there, at the expense of our tile and our communities. And so if there was ever an example of government-sanctioned kind of profit over people and planet mentality, this would be that example. I want to talk about where climate breakdown itself, or climate change, comes from, because it's born out of the very same ideologies that is giving a free pass under this bill to corporates and governments to pollute at will, essentially, without accountability. So if we look back to the kind of ideologies that have enabled climate change, the sort of colonial plunder and dispossession of land is certainly one. The extractive practices of the fossil fuel industry, who have known since as early as about the 1960s at least, about some of the impacts of their actions, and now the impacts are so clear to see, and yet profit keeps being this kind of overriding ideology above them. So that aspect of where climate breakdown itself came from, that is being enabled by this bill. So this bill is not neutral. It will enable more climate breakdown, essentially, because of its foundation, its philosophy. Now, who is most impacted by climate change? We know this. It's marginalized communities, it's frontline communities in the global south, in the Pacific, our disabled communities, Indigenous communities, rural communities, and the tile itself, obviously. And so all of these communities and places are the ones the most to lose because of this bill. We need comprehensive climate legislation, yes, but it's the type that would enable accountability, that would be based on the well-being of the tile, of the TDC, and of human rights. So in conclusion, a government that cares about its people should not be afraid of accountability and should instead welcome it. happy to take questions.
Thank you, Anya. We've got a couple of questions. We'll start with Ricardo Menendez-March.
Good, Anya. Thank you so much for your submission. Others have commented around the intent of this bill. You've talked a bit about accountability. What do you see are the risks for the government if this bill was to proceed in terms of climate policy or impact on communities?
Even here in Aotearoa, we're seeing the impacts of, repeated flooding and repeated climate events across the country. And so it's very clear to see that already in terms of people's housing, people's well-being, the actual taiao that people are really connected to and connected to the whenua, particularly for Māori communities. All of that is being undermined by climate change. And this bill is basically saying, well, that's fine.
And we do have time for one more question. I did see Dr. Deborah Russell had her hand raised. Oh, okay, she's quite all right. Thank you, Anya. We really appreciate you joining us this afternoon. Thank you.
Thank you.
Okay, we're going to be moving to Energy Resources Aotearoa with John. Thank you, John. Great to have you joining us this afternoon. We have read your written submission. We have you down for 10 minutes. Please do allow a bit of time at the end for questions.
Great, thank you, Chair, and thank you, Committee, for the opportunity to speak to our submission. I'm John Carnegie. I'm Chief Executive of Energy Resources Aotearoa. A little about who we are. We're New Zealand's peak energy advocacy organisation, representing the entire energy value chain from producers to distributors, sellers and users. And we exist to enable constructive collaboration across the energy sector as we collectively strive to address complex and multidimensional issues such as climate change impacts. Our members have a common interest in the robust public policy settings, and our focus is advocating for systemic solutions across the energy sector and the wider economy. We support this bill. We agree that the proposed statutory bar against private tort liability will provide the legal certainty that domestic and international investors require. These reforms strengthen the existing regulatory scheme set out in the Climate Change Response Act, the CCRA, and reinforce New Zealand's bipartisan political commitment to clear and stable climate change policies as set out in the CCRA and on which the business community relies. This predictability has in fact driven the sector to move significantly towards emissions reduction. We believe that climate change action is too complex and policy-laden for the courts. Climate action involves trade-offs between emissions reduction, energy security, economic competitiveness and affordability. Deciding one company's share of global climate harm involves complex choices about productivity, energy use, emissions reduction, and how costs are shared across society. And those trade-offs require democratic accountability and the ability to adapt over time. Courts cannot provide either. It is a question that should be considered and determined by Parliament, which is better placed to do so. Parliament has done that through the CCRA and will continue to adapt to those policy challenges through legislative mechanisms over time, and businesses both support and rely upon its robust and reliable statutory framework. If the CCRA needs strengthening to address accountability for climate harm, Parliament is the right place to do so with proper deliberation, consultation and democratic mandate. And that is exactly what this bill seeks to do and why we support it. However, while supportive of the bill, we do not think that it adequately addresses the range of risks to business certainty. Energy projects require large capital commitments, and the assets often operate for decades. Investors need to understand the obligations that will apply before they commit time and money to proposals. Unclear liability makes planning harder, raises the cost of allocating capital, and weakens New Zealand's case for investment against countries with more settled rules. And that investment supports employment and the delivery of secure, affordable energy. A higher cost of capital either stymies investment, creating scarcity, as we have seen play out in New Zealand over recent years, or if it proceeds, it costs consumers more. Neither outcome is desirable. And the downstream impacts of this uncertainty should be in no doubt. Investment risk is not imagined, and we have experienced it firsthand. It plays out in the form of investor flight and permits relinquished, and the cessation of exploration drilling, reduced investment in natural gas supply that increases coal-fired generation, leaves less support for the development of new intermittent renewable generation, and pushes electricity prices higher than otherwise. These outcomes make emissions reduction and electrification harder. But to reduce uncertainty regarding climate change obligations, it is essential to maintaining New Zealand's reputation as a stable, rules-based destination for international investment and meeting our climate goals. But we agree that the proposed statutory bar against private tort liability will provide, to some extent, the legal certainty that domestic and international investors need. However, the bill does not fully address the risk of climate-related litigation uncertainty for public decision makers. As seen in the Supreme Court decision Climate Clinic, there is still uncertainty about climate change considerations when making statutory decisions relating to businesses that are otherwise acting under the CCRA. And we urge the committee to close this gap. And to do so, we recommend that one targeted amendment is made to Section 3 of the CCRA. This would amend the purpose provision of the CCRA to state that the Act provides New Zealand's complete regulatory scheme for climate change, including activities that cause or contribute to emissions or climate effects, where a relevant statutory scheme is not otherwise explicit. Now, we believe that this was Parliament's intention when almost unanimously passing the CCRA into law, and our proposed amendment is offered by way of a rectification of an earlier omission. Parliament would remain free to require climate change to be considered under another law. However, any additional obligation would need to be stated expressly in that legislation. Ministers and other public decision makers could then apply the legislation Parliament has passed almost unanimously without having to infer further climate duties from the CCRA. Separately, we consider that the Climate Clinic case has also given rise to other risks that Parliament should also address to clarify the meaning of the benefit of New Zealand and the Crown Minerals Act and limit that test to economic considerations. However, this work goes beyond the immediate amendments sought through this bill. So while we support the objectives of this bill, Smith is a novel claim, and we believe that Parliament has been surprised with it proceeding despite there being a statutory scheme to address climate change responses set out in the CCRA, and additional changes required to meet the needs of our sector and achieve the bill's stated objectives. The proposed amendment to Section 3 would address the uncertainty created by Climate Clinic. Further climate obligations would apply only where Parliament has expressly included them in the specific legislation. Business and investors, along with public lawmakers, could then make long-term decisions using the rules in the CCRA that are clear before capital is committed. That supports investment, employment, secure and affordable energy, and New Zealand's progress towards lower emissions. Again, I thank the committee for the opportunity to present our submission, and I look forward to answering any questions you may have in the remaining time.
Thank you, John. We've got a number of members with questions. We'll start with Dr. Deborah Russell.
Oh, thank you. I'll actually just bump it straight to Duncan.
We'll go to the other doctor, Dr. Duncan.
Okay. Thank you. Look, I was particularly interested to hear you say you thought Parliament was the right place to do this because of the process of deliberation and consultation. I'm just wondering, in terms of social licence and so on, are you disappointed that this is a bill that's had 10 days to submit, was introduced under urgency, and has been tarnished with some pretty unfortunate lobbying, which was not done transparently as found by the Ombudsman. Would you have preferred it to be done in a bit more robust process?
No, well, Duncan, thanks for your question. We believe that all processes should be robust and provide sufficient time for due consideration.
Yeah, so do you think it would be a good idea if we took a bit more time over this? And I mean, you've only had 10 days to put together your submission, as has anyone else. It's not really enough, is it?
Well, that's a decision for Parliament and the business committees of Parliament to decide, not for me.
Well, you've just made the point that you want Parliament to do it because you think it's a better deliberative mechanism, and it's doing this in a very rushed process that's been heavily criticised. Is it your view that this process is appropriate for the step that's being proposed?
Look, Duncan, it's not up to me to form a view on that. That's the decision taken by the business committees of Parliament.
Thank you.
You came
Duncan,
here and
we've
said
got
you think it's a
questions
good
from a number of
process.
us. Excuse me, Duncan. We've got questions from a number of other members, so I will share.
I can see why he's avoiding the point.
Thank you. Todd Stevenson.
Thanks, John, and thanks for your specific amendment that you put in your submission. We'll make sure we look at that. I have another question. It's really about this, how basically international investors and some of the organizations you represent view climate litigation risk, and really what does that do to their investment decisions and thinking about New Zealand if they're going to invest here?
Yeah, thanks, Todd. Look, as a matter of principle, reducing uncertainty is essential to maintaining a reputation as a stable, rules-based destination for international investment. And it's important to point out meeting our climate goals. So we agree that the proposed statutory bar against tort liability will provide the legal certainty that investors need to consider, and that the additional amendment we propose will do likewise for public law. And of course, in the energy sector, this is particularly relevant because it involves long-lived assets and where capital commitments are large and where investors require confidence that the rules governing their obligations will not shift easily, quickly, or in fact in capricious ways. And these features are critical to maintaining New Zealand's energy security and affordability, and supporting the growth of renewables and avoiding also the use of coal while keeping downward pressure on prices. But I think the point that I made in my submission is that investment loss is not a theoretical consideration. We've experienced it firsthand how easily New Zealand's attractiveness as a destination for international investment can be damaged. When the offshore exploration ban was introduced in 2018, investors fled. Highly prospective permits like the Bark and Wary prospects, which were being ready for exploration investment, were handed back. More coal is now being used to fuel our electricity sector. Electricity prices have risen on average, causing factory closures and production losses. This is what we have actually observed, and that is what regulatory shock looks like in the energy sector. And so climate litigation has already been treated as a material investment risk globally for the sector. And, New Zealand, the other point is New Zealand doesn't operate in isolation from those investor expectations.
Thank you. And we've just got one final question from Carl Bates.
Chair, sorry, it keeps stalling. Chair, thank you for that. My question is, would any longer time for this to be going through Parliament have changed your view or your submission, John?
Good question, Carl. No, it would not have.
Thank you.
Thank you.
All right, thank you very much. And thank you for joining us this afternoon, John. We really do appreciate it.
Thank you very much.
We now have Raphael online, who was supposed to be with us a little bit earlier. So we're just going to promote him. We're just going to go to Raphael before we go to Ted. Hi, Raphael. Thank you for joining us this afternoon. We have read your submission. We've got you down for 5 minutes, and if you can just leave a little bit of time at the end for any questions, and if you can just unmute and put your camera on, please.
Hey guys.
Good stuff. We're in your hands.
Are you there? Can you hear me all right?
We can.
All right. Yeah, I just want to talk just briefly on my submission and that today. Yeah, I don't support the bill. In terms of, you know, like the transparency and accountability, it's almost you could say another fast track bill, basically. You know, so you can yeah, to me it's like another fast track bill. It's quite concerning that you know, yeah, it's quite concerning. This bill in terms of transparency and accountability for you know, organisations or companies that that have investments in New Zealand. I think that's yeah, it's, what do you call it? It's with yeah, I just I don't agree with it for one reason. And I see this every day. It's like when I drive on State Highway 1, I see truck tire tread all over the sides of the roads, and there's no accountability for those companies that are driving those trucks that allow all that tread to end up on the side of the road in our waterways. You know, and it's things like that where there's no accountability and there's no transparency through the different stages, whether it be through regional council, district council. There's no accountability under the Resource Management Act for this mess that's been left. Our country is like this country is endemic, basically, in terms of the environment that we have in our country. It's not like any other place in the world. So, you know, it's up to us citizens to protect our environment in the best way possible. And to have a corporate company like Fonterra go through back channels and avoid the actual, you know, proper consultation, and that's kind of backward democracy, basically. You know, we've gone to the highest Supreme Court, and now we're going to a bill to throw it all out the window, basically, and allow this to continue. And I just think that's not in the best interests of us Kiwis that work on the front lines, that work in the trenches, you know, cleaning up the mess. I've worked on environmental projects, and I'm working on catchments, you know, with regional councils to deal with these sort of problems that are coming from big corporate companies, like forestries. You know, where I'm based at the moment, forestry is one of the biggest here in the north, is the forestry industry and the farming industry, and a lot of that slash, that black water, it ends up in our shorelines, on our coastal lines. And yeah, there's no accountability for any of those companies that are producing that waste. You know, and we need some transparency there. And if we can't get it, you know, openly and transparently now, then there's no hope for us to actually get some decent democracy happening in terms of the environmental impacts that are happening on a daily basis now with our country here in New Zealand. That's all I've got to say, guys.
Thanks, Raphael. I'll just see if there are any members who have a question for you. It does not appear to be the case, but really appreciate you submitting to us today, and thank you for your time.
No worries.
Thank you. Okay, we're now going to move to Tony. Sorry, not to Tony, to Ted. My apologies, Ted.
Thank you. And
Thank you for your patience. We have read your submission, Ted. We've got you down for 5 minutes. Just leave some time for questions. Over to you.
Thank you. Thanks for this opportunity to speak. Yeah, I think it's kind of strange that while this is being framed as providing business certainty, what's actually happening is that the rule of law is being broken. The concept in law that you don't have retroactive legislation is being broken by this. Like, to me, it's the most profound danger to business certainty that you could possibly have. It just seems really weird. Like, I actually agree that we have major climate change issues. We have a lot of issues facing us. But this constitutional danger of retrospective laws and this losing the separation of powers, losing the role of the courts, I think is a huge danger. It's a danger to business and it's a danger to everybody. It's a danger to us as individuals. Yeah, the extraordinary breadth of the statutory shield, like the new section 274 in the Act that's proposed, it's just over the top so far as I'm looking at it. I won't get into the customary legal framework, but I see it that we're in like one of the most complex, well, definitely the most complex time in human history. We have a monetary system that is based in scarcity. It's based in value and exchange. And if you think about that, if you think about oxygen in the air, it's arguably the most important thing to any of us. But in a market, it has zero value. That wasn't an issue when the only thing that was abundant was air. But we now have automation and advanced AI, and we now have the technical capacity to meet the needs for a reasonable abundance of everything for every person on the planet. But the economic system requires scarcity. So that is the most profound issue of our time. We have AI. I think it very likely, probability greater than 90%, that we will have AI smarter than all of humanity within the next 3 years. That is a huge, huge issue. We need to address climate change. It's a very real issue, but we also need to have fundamental changes to our economic system and the way we do business so that we have a positive future for the environment, for non-human life, and for all of humanity. And I think this bill is entirely orthogonal to that. I think it needs to be rejected in its entirety. And I don't think Mike's got a chance of proving tort law. I think it's just a crazy approach. Yeah, I'm happy to take questions. Thank you.
Thank you, Ted. I'll just see if there are any members who have a question for you. Doesn't appear to be the case, but we're really grateful for your written submission and for joining us this afternoon. So thank you very much.
Thank you.
Okay, members, we are now going to have the Environment and Conservation Organisations of New Zealand, Barry and Kath. Hi, Kath. How are you?
I'm well, thank you.
Is Barry joining you?
Yes, he is.
Okay, we will have likely promoted him. We just need him to accept. All right, what we'll do, Kath,
We'll get started anyway.
we
I
will.
think.
Yeah, we've got you down for 10 minutes. We've read your submission and just leave some time for questions.
Yes, thank you very much, and we very much appreciate being able to address you. We've introduced ECO in our submission. I would say, though, that we have immense experience in this whole area of climate change. we were alerted to it in the early 1980s, and I personally was quite closely involved as a senior lecturer in public policy and in economics in the development of the ETS and some of the other measures. ECO thinks this bill should be withdrawn. Like many others, the bill offends us, and it offends, in our view, quite a number of constitutional principles, and it also seems to reflect a willingness by ministers to actually give in to vested interest, and the sort of cloak and daggerish way in which this proposal was advanced is pretty offensive in our view, of large moneyed interests trying to get in on the ground floor. We particularly oppose the cloak of immunity that it offers to everyone who is a climate polluter, and we deplore the intervention for its retrospectivity, but also for the fact that it does not respect the separation of powers and the judiciary, and that, in our view, is not acceptable. We find that it also would remove the incentive to not pollute because there's no holding to account via the courts for this. I'm a public policy expert myself, and it's apparent to us that the regulatory and policy approach has not been strong-minded and has not worked. And to remove the one final sort of way of holding both the government and polluters to account is to leave us all worse off, but also to open the door by others who would inflict public harms to being lobbied, for them to lobby officials and ministers. We know that the officials in this particular case said, don't do it. This is not a good approach. We know that the ministers have actually thumbed their nose at that advice. Of course, they have an entitlement to make their own views, but when all the experts and all the officials and the public are saying this is grossly unfair and it's improper and it's unconstitutional, then we think the government should listen. And we urge all of the MPs from all parties, and we're non-partisan, to resist this and to say no to this bill. It doesn't just deprive Mike Smith of his right to pursue a tort, but it deprives all of us. And it suggests that this is going to be, this sort of underhand lobbying is going to be an avenue that any polluter or causer of public harm can pursue. That makes the capture of ministers by vested interests particularly likely to want for it to get worse, and we think it's inconsistent with Te Tiriti o Waitangi and the sort of general lack of consultation and the lack of helping or taking time to have hearings of length is an aggravating factor. We think the idea that there should be only one avenue for taking action on climate change or for trying to regulate climate change is completely wrong. And we think that the bill has, and the authors of the bill have not, in fact, picked up the many opportunities that are available to reduce emissions, which is something that they should do. New Zealand is a signatory to the Open Government Partnership, which is a multilateral agreement, and there's nothing open about this, and that open government partnership calls for inclusion and openness in policy making. Yeah, we endorse the submission by Lawyers for Climate Action, and also Jonathan Boston's presentation is very good. I'll leave it at that, and you may have questions.
Thank you, Kath, and I'll just see whether Barry might have anything further he'd like to add.
Yes, thanks. And thanks to the committee. Sorry, I've had a bit of problems connecting. Yeah, this bill actually opens a Pandora's box for future governments, which probably the proponents of this bill should think carefully about, because it opens the opportunity for future governments to basically get rid of resource consents and other things that businesses may have on the basis of the taking action, which isn't the normality of law, which is what this bill is removing. Thanks.
Thanks, Barry. Thanks, Kath. I'll just see if any members have questions for you. Doesn't appear to be the case. We're really grateful for your written submission and for presenting to us this afternoon as well. So thank you very much.
Thank you very much. Thanks. Good luck.
Okay, members, Alistair is our next submitter, so we'll just have Alistair promoted. Hey, Alistair, thank you for joining us this afternoon. We can see that you've accepted. If you just don't mind switching on your camera and unmuting yourself. We have read your submission.
Sure, sure.
We've got you down for 5 minutes, so please do just allow a little bit of time for questions. Over to
No,
you.
thank you for the opportunity to submit. I'm submitting as a private citizen. I'm not a member of any particular organization, but I have a lot of concern about climate change and its effects even now. I mean, we're seeing these around the country, and we're seeing just how destabilizing they are for small communities, for example, rural communities like Nawi on the south coast of the North Island, where people rely on their bridge to get out of go into town, and if the bridge is being sort of washed away, what are they supposed to do? It really, I think it's unsettling for people regardless of where they live in the country, and hopefully we have a shared understanding now of what the effects of climate change are going to be, because this is only the beginning. I also have 2 young grandchildren. I've had a lot to do with them just in the last week, and when I look in into their eyes, they are so trusting and so innocent, and I find it hard sometimes to look them in the eye, because I think, what are they going to ask me or about me and the action that we took as polluters, as people who've caused a lot of the climate change in the first place, but our relative inaction in trying to reverse it. So that motivates me to speak today, and I really want to be able to hold my head up those grandchildren. So on the one hand, we see the threat coming down the line towards us. On the other hand, New Zealand has been noticeably slow in adapting and responding, both at a national scale, but also individual businesses and individual people. Of course, we do see people around us who are responding and are doing things, and undoubtedly some of the companies have things that they can point to, which are responses and investment that is helping to improve the situation. The trouble is the scale of it. We haven't really quite grasped, and it's significant that New Zealand we're still 20% above our annual greenhouse gas emissions in 1990, whereas, for example, the whole of the EU, 40% below. They have managed to reduce their 1990 emissions, or the emissions from 1990 until now by 40%. We're on the wrong side of the ledger. So that's something that we collectively need to take action on at all levels, government, companies, and individuals. And from my reading of Mike Smith's bill, rather his the case that he's brought, he's really just trying to point that out. And what he's asking for is for the big emitters of greenhouse gases in New Zealand to get with the program in terms of our Paris commitments, to be reducing their emissions of greenhouse gases in step with that. That seems to me a very reasonable and well-founded argument that he's put forward. And it's one I think that really deserves to be heard by the public at large. In fact, he's speaking on behalf of all of us. I certainly feel that he's speaking on my behalf, on the behalf of my children and grandchildren, but also I think all of us as private citizens. Really does all. And so to see him potentially being silenced, even when the Supreme Court has given him the green light to proceed with this case, seems to me would be to silence all of the people that he speaks for. And that really does undermine the kind of vibrant, robust discussion that we need, especially when, as we've seen, New Zealand is a laggard in the area of climate change. We, as a country, we need to pull ourselves together and to start pulling our weight. And that requires each of the companies involved to do the same. They need to be pulling their weight, and be seen to be pulling their weight. That's something New Zealanders, I think, inherently understand and respect, and want to see that happen. So the government, therefore, needs to act in the public interest more broadly, whereas, unfortunately, it appears to be siding with these large companies. It has its own reasons for these, no doubt largely economic, but the impression that is given is that they're not on the side of ordinary people affected by it, and that they are going over the top of the Supreme Court, which you would hope would have supremacy, if you like, in this area, that its judgment would be respected. So for that reason, I really urge the committee to think about this and to point these things out to the government, because Mike Smith deserves to be heard. The case that he is putting is a case on behalf of all of us, and not just.
Thanks. Thank you, Alistair. Really appreciate both your written submission and for presenting to us this afternoon. We have reached the allocated time.
Yes, sure.
But thank you very much for coming before us this afternoon.
All right. Thank you for the opportunity.
Thank you. We're now going to come to Environmental Law Initiative. Hi, Eliza. We have you here on behalf of the Environmental Law Initiative. We have read your submission. We have you down for 10 minutes and just leave some time at the end for questions. Over to you.
Thank you so much. And I'll try and keep this fairly brief and leave plenty of time for questions. So I'm here today representing the Environmental Law Initiative. We're a small charity focused on improving the outcomes for New Zealand's natural environment through stronger environmental laws that are applied robustly. I won't repeat the full written submission, but I want to focus on 3 key areas. The first is the poor lawmaking process that has been used in relation to this legislation. The second is that the rationale is not made out. And the third is some general comments on the role of tort law and particularly in protecting matters of public interest and the role of Parliament in addressing the same matters. So beginning with the poor lawmaking processes, my organisation, ELI, had put in Official Information Act requests regarding any meetings that may have been had on the issue of the Smith and Frontiers proceedings, and we did not receive the full information that those meetings had occurred, and there were written materials provided, and an ombudsman inquiry was taken out and found in our favour. In that context, it is tremendously concerning that there is such a short amount of time allocated for the Select Committee to consider this legislation, and such a short window for submissions and for submitters to be presented. And that alone is sufficient reason for the Select Committee to recommend that this bill not be proceeded with, that if any changes are to be undertaken, that it should require a longer level of consideration. I'm seeing a hand up. Do we have questions sort of as they come, or also?
We'll have the questions at the end, so just carry on with your submission.
Thank you. And I think that's something that is very worthy for the Select Committee to note. This is not a situation where something has been considered thoroughly and there has been plenty of time for public input. It has all been rather rushed with a fig leaf of rationale based on business certainty. So I'll come now to that rationale, because I think this is an area where it's really beyond spurious to say that certainty requires such a significant intrusion into the ordinary processes of civil litigation, targeting a particular litigant and preventing a substantive claim from being heard after a Supreme Court decision said that claim should be able to proceed. And the main thing that I think the Select Committee on this should be cognizant of is that climate change itself creates a very large measure of uncertainty. In order for there to even be a slight chance of a tort claim succeeding, there has to be harm. Now, the harm that is occurring due to greenhouse gas emissions and a failure to bend those down sharply enough. And it's happening already. It's getting worse. We've seen just over this weekend the residents of Wairoa having issues with the river bursting the banks again for the second time in only the last 3 years. We're now at a point where I've actually lost count of the number of extreme weather events New Zealand's had just this year. And this isn't overstating it at all. The level of harm is already really significant. These events are happening faster and faster than most people anticipated would be happening by the mid-2020s. So the question of whether any of that harm may give rise to tortious liability is a live one. And that's a live question whether or not Parliament enacts a statutory bar. So by enacting a statutory bar, it's not creating certainty, it's just deferring the point of time at which the courts are able to consider that. And in a context where the opposition parties have already committed to repealing the legislation, there really can be no rationale for this based on certainty. Because what it does is it just sort of presses pause on developing this through the courts and then reaching a point where Parliament can create a considered response to address any of the broader social or public policy implications of a finding of tortious liability. So I think that's important to be clear that that rationale is really full of holes. The third point I'll be making is around the role of tort law and Parliament more generally. I think this is quite crucial because the Minister's statements at the introduction of the bill and also the general policy statement really presents it like this is some sort of exceptional situation that we are facing as an issue being addressed with the courts that has already been addressed through legislation. It's not exceptional at all. It's quite run-of-the-mill. Tort law usually proceeds in parallel to the development of more sort of detailed and comprehensive legislative response on the same issues. I point to several examples of that in my written submission, including the quite obvious and famous one in New Zealand of the accident compensation regime, which we've got the most extensive bar on bringing a tort claim in any common law country because we can't claim a personal injury in New Zealand. What we have instead is a comprehensive form of recovery for both accidental and non-accidental injuries, whether or not they would have been creating tort liability. Another example is in relation to leaky homes. The Supreme Court decision in Sunset Terraces found that there was liability for building consent authorities. There's been several years of genuine, deep public policy consideration on how best to address that. But that's all in the context where the court has been able to consider the boundaries of liability, and then Parliament has been able to take that as the status quo of the law once there's been proper due consideration of it, and then think about the appropriate response. And so if we carry that across to an example such as the present, what we would expect to see in a sort of an ordinary good lawmaking approach is let this play out at the courts, and then once there is a decision, if that gives rise to areas which require a legislative or regulatory response, that's the point at which it can be made with proper public consultation. Instead of really assuming that the possibility of any liability attaching for climate emissions in itself justifies preventing the courts considering it. So I can see 2 hands up, so I will pause now and take any questions.
Thank you very much, Eliza. We'll start with Dr. Lawrence Sunan.
Thank you so much, Chair, and thank you for that submission, Eliza. I've got 2 questions. The first one is just a confirmation. So based on your submission, in terms of the poor lawmaking process, this also fundamentally challenges the principle of comity and the rule of law. Would that be, in terms of the process?
I think it's extraordinary to see a Supreme Court decision that says a case should proceed to a substantive hearing and then Parliament effectively overrule that Supreme Court decision. I think that's quite out of step with the normal operation of the boundaries between the courts and Parliament.
My second question, maybe you may be able to answer. Earlier in the day, we've heard from Jane Kelsey around the potential implications this will have to our NZEU FTA, which will have tangible economic impact. What do you make of the idea that this potentially violates some of our trade agreements?
Yeah, I think that's an important question. So I think there's the EU FTA and there's also the UK FTA, and they have very similar provisions around effectively obliging both parties not to wind back any of their steps on climate protection. I think, and New Zealand and the UK in particular, we're both Commonwealth countries, so there's, I think, a particular issue with that one. There have been a number of areas where the government has already wound back climate, and we're now reaching, I think, a tipping point of cumulative impact of that and potential action by either the EU or the UK. I think the key point there is that the economic harm that would occur to New Zealand from any sanctions on our exports of agricultural products and other products would far outweigh the cost of taking stronger action on climate change. And in particular, this case doesn't create any immediate costs to the broader economy. It's costs to the litigants, obviously, but there is really no real risk in just letting it play out and then seeing what sort of legislative response might be called for based on, for example, areas that the court might identify as being matters that Parliament should consider.
Thank you. And just a quick question from Dr. Deborah Russell.
Thank you. Eliza, thank you for your submission. In the papers that were released with the bill, we got a back trail on the consultation that the Minister had engaged in, and it was very targeted, selected consultation with some lawyers. Were you amongst those people consulted on the development of this bill?
No, we weren't, and we weren't aware that it was being developed until the information was publicly released, despite having a sort of an interest that should have been known to the Prime Minister's office because of our requests, which were not completely answered.
Okay, thank you.
Thank you very much, Eliza. Thank you for joining us this afternoon and for your written submission as well.
Thanks very much.
Members, we're now going to take a break till 4:55 and then we will come back for the last of our submissions for today. Thank you.
We got old rules in a new day scene. Same big principles, different machine. The how keeps changing, tech moves fast. So we check the settings, cut the deadwood past. Special vote stacking like a tower of bricks. Lane enrollments doing overtime tricks. Used to be 2 weeks, now it's 3. If we do nothing longer, you'll see. So we tighten the timing, smooth the lines, start the process earlier, read the signs. 13 days before the big show starts, get your name right where the roll book charts. 13 days, 13 days. Get enrolled before the deadline gates. 13 days, 13 days. Is it speed or democracy at stake? No treats at the ballot, no chips, no tea, no freebies near the box, keep it clean. 13 days, 13 days. Tell me who wins when the rules all change. Auto updates, moving addresses along. Go data, keeping details strong. Roll stays current between each race. Less last minute chaos, faster pace. Advance voting, 12-day run. Make it formal, job gets done. No costly letters sent by post. More modern system, cut the toast. And prisoners sentenced, no vote while inside. Consequences land on the other side. Serious offending held to account. Serve your time, then re-enroll back on the mound. Mental health detention kept the same. 3 years plus, that's still the frame. And promoted details, safer to share. Less risk, less harm, more fair. 13 days, 13 days. Get enrolled before the deadline gates. 13 days, 13 days. Is it speed or democracy at stake?
Of public submissions. Clerks, if you can bring Samantha Reid in, please. Hi, Sam. Thank you for joining us. If you're able to just unmute yourself and switch your camera on if possible.
Is my camera not on?
It's not, unfortunately, but we can hear you.
Hang on. Can you see
There
me?
we go. We can see you now. We have read your submission. We've got you down for 5 minutes. Just leave some time at the end for questions. Over to you.
Fantastic, thank you. Tēnā koutou I te committee. Ko Samantha Reid-aho. Ngā mihi nui kia koutou for hearing my submission today. I won't repeat my written submission. Instead, I want to speak directly to what this bill means for ordinary people, for our constitutional balance, and for the integrity of climate governance in Aotearoa. First, this bill removes the ability of people harmed by climate-related conduct to seek redress. That is not a technical adjustment to tort law. It is a fundamental shift in how the state treats those who suffer loss. When Parliament tells victims there is no pathway for you, it is not regulating climate change, it is withdrawing justice. In Te Ao Māori, we speak of manakitanga, kai tiakitanga, care, protection, responsibility. A system that denies the right to be heard does not reflect those values. Second, the bill creates a constitutional imbalance. Courts are not obstacles, they are partners in accountability. Removing judicial oversight in an entire area of harm is unprecedented. It risks a precedent where Parliament can extinguish remedies whenever they become politically inconvenient. That is not the tikanga of our constitutional tradition. Ko te tika me te pono. Justice and truth require that courts remain able to perform their role. Third, this bill sends a troubling message about whose interests are being protected. Communities facing climate harm, Maori land blocks, coastal settlements, low-income households are left without remedies. Meanwhile, industries whose conduct contributes to that harm receive statutory protection. That is not te tiriti o Waitangi in practice. Active protection means ensuring vulnerable communities retain access to justice, not removing it. Fourth, the bill undermines public trust. People already struggle to understand climate governance. When Parliament removes the courts entirely, it signals that accountability is optional for those with influence. That corrodes confidence in both the legal system and the democratic process. Finally, I ask the committee to consider the long-term consequences of climate change. Finally, I ask the committee to consider the long-term consequences. Climate change demands courageous, principled governance. This bill does not meet that standard. It protects the powerful, abandons the vulnerable, and weakens the constitutional safeguards that uphold the rule of law. I respectfully implore you to withdraw the bill in full. Ngā mihi nui.
Thank you, Sam. Now I will look to see if there are any members with questions. Does not appear to be the case. We're really grateful for your written submission and for presenting to us this afternoon as well. So thank you very much.
Thank you very much.
Okay, now we're going to have the Animal Justice Party, Aotearoa New Zealand. Great, thank you very much for joining us this afternoon. We have read your written submission. We have you down for 10 minutes. If you can just leave some time at the end for questions from any members. Over to you.
Thank you, Chair. And thank you all for the opportunity to speak today. I'm Karen Singleton. I'm the Policy President for the Animal Justice Party, and I'm joined by Danette Weriter, who is the co-leader for AJP. So I want to be upfront. Neither of us are lawyers. We've approached this submission as lay people with expertise in animal welfare, protection and justice. We also want to note that only 10 days were given for this submission, with oral submissions called the very next day of it closing. That's an extremely tight time frame for a bill this significant, and we don't think it really gave the public enough time to respond properly. So the Animal Justice Party opposes this bill and we call for it to be withdrawn. What stands out to us most is how broad the bill's protection is. It doesn't just shield one type of emitter. It protects virtually anybody responsible for emissions, including government departments, ministers of the Crown, foreign-owned companies, and operating here. In substance, this bill protects polluters at the expense of everyday New Zealanders who are left with no way to seek compensation or hold anyone accountable for climate-related harm. Now, we've heard today a lot of submitters talk about certainty, but there's no real certainty to be had in a world facing climate crisis. What this bill offers might be certainty for a small group for a limited time, but it's not certainty for the country. From a justice perspective, what we do understand is this: what counts as harm worth taking seriously isn't a fixed notion. It's decided by government through regulation and legislation, and those decisions aren't made in a vacuum. The people and industries with the most resources and influence often have the greatest ability to shape where those lines get drawn, sometimes in ways that keep their own activities out of reach of any meaningful accountability. This bill seems a clear example of that in action. It decides a whole category of harm caused by emissions, will never again be tested in court, no matter how serious or how clearly linked to a specific source. That's not a small or minor choice. It's a decision about whose harm gets taken seriously and whose doesn't. So courts exist precisely because law doesn't always keep pace with harm. They're one of the few places where that gap can be tested. This bill closes that door, not just for future cases, but for ones already underway, like Smith versus Fonterra, a case that's been going through the courts for a few years now. We've also seen it argued that courts aren't equipped to deal with something as complex as climate change, but our own Supreme Court has already rejected that idea when it allowed the Smith versus Fonterra case to go ahead. It pointed out that courts have adapted before to industrial pollution, water contamination, multiple polluters causing shared harm. It didn't see climate change as fundamentally different, just bigger in scale. So we don't see why that reasoning should change now. And I'll hand over to Danette if you're there.
Kia ora. It's also worth remembering that a lot of serious harm happens through completely normal, everyday, even legal business practice. And many of today's business models have been built around harmful environmental practices into how they operate as standard, not as an exception. That doesn't make the harm any less real, and it doesn't make the consequences any less foreseeable. This bill looks to us like an attempt to run away from accountability for that harm, rather than face it. Now, we care about this because animals, wild and farmed, don't get a vote. They don't get a say in Parliament. Climate change is already reshaping their lives, warming seas, changing rainfall, shrinking habitat, and it compounds other pressures that they're under too. The courts are one of the only places where harm to them and to the environment they depend on can still be raised, even when politics moves too slowly to act. Removing that option doesn't make the harm go away. It just makes sure that no one can be held accountable for it. We'd also ask the committee to think about who this bill actually protects. It's not about communities facing flooding or drought. It's not about the insurers left holding more risk. It's about the industry and companies whose emissions are the reason we're having this conversation at all. Shielding the parties most responsible while leaving everyone else to carry the cost doesn't strike me as a reasonable use of Parliament's time. So in closing, the question isn't whether Mike Smith will ultimately win, it's whether he should be allowed to have his case heard. If the defendants believe they've done nothing wrong, why not let the case be heard? Why not let the evidence be tested? Justice should be allowed to take its course. Now, listening to Fonterra's submission today, it struck me that they were simply arguing their defence, but this committee isn't a court. If Fonterra believes that evidence is on their side, they should let justice take its course and present that evidence at trial. And is the possibility of economic impact enough to stop a court case? This assumes very blindly that the economic cost of environmental harm doesn't matter, when in reality it could be far greater. We ask the committee to think about your legacy with this decision. Do you want to be remembered for preventing a court from tearing evidence, or for allowing justice to take its course? Today, it's climate change. Tomorrow, it could be something else, and it's a very dangerous precedent to set. We'd ask the committee to think about what happens to the harm that falls outside today's law. If this bill passes, there's simply nowhere left for them to go. Given the short time that the public has had to respond, we also ask the committee to consider whether more time and more scrutiny is warranted before a change like this is made. We ask you to reject this bill. Kia ora.
Thank you, Danette, and thank you, Karen, both for your submission. We do have a question from Dr. Lawrence Sunan.
Thank you, Chair. Kia ora, Danette and Karen, thank you so much for your submission. I'm really interested in knowing, in terms of the climate impact on animals, and you mentioned farmed animals in your submission. Would you by any chance have some key stats, for example, on the recent harm, either physical, injury, or even potentially death from recent climate charged weather events? Would you have any data on that, or know of any stats?
Not specifically on weather events, though they're pretty common in the news at the moment. So, you know, you can look at the news and see a weather event and see the impact on farmed animals. I don't have those numbers on us.
Thank you. Sorry, it was a very specific question.
Yeah.
Yeah.
Doesn't appear we have any other questions, so we just thank you both for your written submission and presenting to us this afternoon as well.
Great,
Thank
thank
you.
you.
Thank you. All right, we come to Extinction Rebellion Ōtepoti, and we've got Jen, and Jen presented to us yesterday as well. Great to have you back, Jen. Hey, Jen, nice to see you again. Thank you for being here.
Hello,
You know
hello.
how this works. You've
Yeah,
got 10 minutes. Just leave some time for questions. Over to you.
yeah, thank you. I've come down with a bit of a cold since I talked to you yesterday, but I hope that won't stop me. Yeah, kia ora koutou, ko Jen Olsen, toku ingoa. I'm opposed to this bill, and I'd like to see the committee recommend its total withdrawal. I was very disappointed to see that once again the government has cut short the time available for submissions on this bill, because I think it's very important. And it's doubly disappointing that they appear to have responded to requests from some of the subjects of Mike Smith's case that's on its way through the courts to prevent that case from being heard. I'm not a lawyer, but I don't consider this to be a good example of justice in Aotearoa, and I know a lot of the lawyers don't think so either. Tort law in New Zealand deals with wrongful acts, where a party's breach of duty causes harm to another. And tort law is how the law develops to deal with new situations in society. The climate crisis is not exactly a new situation because it has been developing for many years, but is newly recognised for the serious situation it is, and our laws have not yet caught up with the urgent necessity of a response. A small number of companies in Aotearoa are responsible for a high proportion of climate changing emissions. For example, the companies in Mr. Smith's case are responsible for about 1/3 of our total emissions, and there's no scientific doubt whatsoever that these emissions are causing harm. These major emitters have knowingly continued their activities, have not reduced their harmful emissions, and Mr. Smith proposes that the law should provide a remedy, and that remedy is a duty to cease their harmful activities. Contrary to the claims of some members of the government, existing climate law does not deal with this element of the climate crisis. There's nothing to identify greenhouse gas emitters or major polluters, and there are no laws requiring them to reduce their emissions or to stop other harmful effects on the land or water. Aotearoa has been relying on the so-called market influences in the form of the emissions trading scheme, which has become totally ineffective for a number of reasons, including the exclusion of agriculture, making up almost half of New Zealand emissions, companies being given free units, and no effective cap on carbon units when forestry planting is used as a substitute for actual emissions reduction. So failure to reduce emissions has left us with a massive shortfall in our obligations to the Paris Agreement, made worse by this government backtracking on many policies around emissions reduction. We're entering uncharted territory in the climate and ecological emergency that's now taking place. Our government is not providing the guidance that is needed. Instead, they're causing more uncertainty by backtracking on climate legislation that was previously agreed under a bipartisan agreement. So Mr. Smith's case is filling a gap left by existing legislation and attempting to compel major emitters to address their carbon emissions in a meaningful way for the first time. He also argues that tikanga Māori should inform how the law develops, and the Supreme Court took that point. Now, public nuisance is a recognised tort, and as a climate activist, I understand very well the emissions of greenhouse gases that we know are causing global warming, sea level rise, and climate emergencies in our communities. They are a public nuisance of the first degree. Sea level rise is a major threat to many communities, particularly in South Dunedin. I'm speaking to you here from Ōtepoti, Dunedin. I've worked for many years in South Dunedin, and there are people there having to leave their family homes for good because of sea level rise. And storms and unprecedented rainfall are becoming regular occurrences. There's been a state of emergency almost continuously somewhere in the country this winter. Insurance becoming more expensive, hard to obtain, and I think food supplies are very likely to be affected in the future. Internationally, the climate emergency is hitting the Pacific Islands particularly hard, and we'll need to provide a home for many Pacifica who will lose their lands. Europe has recorded more than 200,000 heat-related deaths since 2022, and thousands more reported during the recent extreme heat events. Drought is a major cause of conflict in sub-Saharan Africa. Flooding and landslides have made millions of people homeless in Pakistan and Bangladesh. And this is at 1.5 degrees of global warming above pre-industrial levels. If we don't make some real and drastic reductions in emissions of greenhouse gases, we are heading for 3 degrees of warming. Now, I can give you the scientific studies that have analysed 10 different climate models and found that the majority of Earth will go past 2 degrees of warming by the 2040s, reaching 3 degrees, maybe the 2050s, 2060s. And this comes from Stanford University, Colorado State, the German Physical and Meteorological Societies, work by James Hansen, the Institute and Faculty of Actuaries, and they have laid out a report stating what will happen when we reach 3 degrees of warming, which is going to be sort of 2050, 2060 if we don't act on what we've got. They're saying that the global economy will shrink by 50%. Now, it's interesting to hear that some of the defendants in Mike Smith's case have been talking about the economic impacts if they are made to actually reduce their climate emissions. I don't think it's reached as much as 50%. That's what's going to happen if we don't reduce our emissions. And not only that, they're talking about 4 billion deaths worldwide, significant socio-political fragmentation, failure of states and extinction events. No government appears to have the courage to tell the truth about the climate and ecological emergency, let alone to do something about it. I can't believe that the response from this government is to pass a law that protects emitters from accountability for the damage caused by their emissions. I mean, you will have heard it all and you'll know what the legislation is. So that means we won't be able to claim for endangering or impairing life, safety, health, property, or climate change related risks to a safe and habitable climate system. Corporations, ministers, government departments and foreign-owned entities will all be protected from any legal responsibility for the harm they cause. I think Mike Smith should be commended for his work in finding a way to make polluting companies finally face the responsibility for the harm they cause and to stop polluting, and for bringing Tikang Amari into the picture. The current capitalist political system with its short-term profit-based thinking has brought about the climate and ecological emergency we're now facing. Colonisation, capitalism and climate change are inexplicably linked, and our politicians are so embedded in the financial system and tied to short-term electoral cycles that they're unable to make the kind of changes that we need right now. Climate change requires system change, and taking a Tikang Amari approach to developing some solutions to the impasse that we find ourselves in might allow us to see things differently. Extinction Rebellion, Aotearoa New Zealand have always supported the concept of participatory democracy, of titiriti-based citizens' assemblies, like the Pororua Assembly, to bring mana whenua together with representatives from our communities and allow everyone to be fully informed on the issues around climate, emissions and the future. All the evidence from assemblies that have been held internationally shows that ordinary people are not afraid to face the difficult issues and make responsible decisions. We would support assemblies being organised around the country, with the results being adopted by local and national government. This would broaden the debate about making the social environmental changes we need and enable communities to make their own decisions. Small countries like ours can make a meaningful difference to emissions. Together, the smaller nations make up 1/3 of global emissions. And actually, as we know, Aotearoa has high emissions per capita. We have the ability to set an example that others could follow if we had the courage to break free from the influence of the big emitters. Unfortunately, this law does not demonstrate that. It demonstrates the opposite, and therefore I urge the committee to reject it in its entirety. Thank you.
Thank you very much, Jen. You have reached your full allocation of 10 minutes, and so we really appreciate you spending time with us this afternoon and for your written submission as well.
Thank you.
Thank you. Okay, we're now going to have Jill Jackson. Hi, Jill. Thank you for joining us. If you can just switch your camera on and unmute yourself. We have you down for 5 minutes. We have read your submission already. Please do leave some time at the end for questions. Over to you.
Kia ora tātou, and thank you for having me. Am I the lucky last?
We've got two after you.
Okay. Well, anyway, I'm speaking as a private citizen against the bill. Everything I'm going to say has been said better by somebody else already, but people with more expertise. But I'm just going to make 4 points. I was a primary school teacher, and I've done my best over the last 40 years trying to turn big ideas into small words. So here goes. The 4 points I want to make is, number 1, the bill I feel is unfair. The bill, number 2, is rushed. Number 3, it's not really ready for delivering to the public. It's undercooked. And the last point, number 4, is that it undermines our trust in democracy the way it's being implemented at the moment. So those are my 4 reasons for submitting. It's unfair, I feel, because it appears that the government is putting itself above the law. That if there's a case that it doesn't like the look of, it's just going to change the law, which shouldn't happen. Also, there's got to be some way that an individual can get some kind of recompense if an individual or a business is doing something to the environment that they live in that is harmful. So that's the unfair part of it. It's rushed. Climate response is an enormous issue that needs a plan with everyone behind it. It shouldn't be a political football. It's about the survival of our grandchildren and possibly the whole human race. It's just foolish to be whittering over who's right and who's wrong. It needs cross-party support, public and education, and possibly deliberative assembly discussion, so that we can transition away from the industries that are dependent on fossil fuels or that are emitting greenhouse gases, regardless of whether they're the backbone of our economy. It's obvious that there's damage being done, and it's obvious that we're going to have to transition at some point. I don't think this bill is ready. It feels like it's been done in a huge rush. Obviously, there's got to be some, well, we hope there's going to be some liability that will be recognised in law for damage by whoever, whether it be a business or an individual. We need a national response plan with litigation that doesn't have to be undone. This litigation is too rushed and can be undone next time around. It feels like it's being done so quickly that the whole issue that needs discussion is being swept under the carpet, and then the carpet's being nailed down, and it's just making a mess. It's not helpful to do this at this point. So that's the undercooked part. I think we haven't discussed how we can transition our major industries. You had some fascinating submitters talking about things like plant milk and hemp and other things that we could be doing. And if you listen to people like Greenpeace who say halve the herd and talk about regenerative farming, not necessarily meaning that farmers lose any money, there are ways around this. And regardless of people being kicking and screaming about losing money, it has to be done at some point. When do we start? And my last number 4 point, it undermines people's trust in democracy because things that are rushed and done under urgency, sometimes at night, it does sound cloak and dagger. It sounds secret squirrel. It sounds like you don't want the light of day to see it. And so people don't trust the process. And already we've got not enough trust in democracy. So don't make it worse. There's also been suggestion that advice has been taken from interested parties to the exclusion of the public. I mean, I don't know if that's true, but it certainly doesn't help us believe that this is the right thing to do. So before we look at rushing a bill like this through, perhaps we should be looking at regulating the lobbying and lobbying by industry, and maybe putting some sort of regulation in there first. And my recommendation is that the Smith and Fonterra versus Fonterra case be allowed to continue and the bill be rejected entirely. And recommend everybody gets on board with some kind of genuine climate response survival plan that starts with something like maybe the Fossil Fuel Treaty Initiative, where people have done a lot of work on how to transition from industries that damage the climate. And that's my 5 cents worth.
Thank you, Jill.
Thank
We do have one quick question from Jamie Arbuckle.
Thank you, Jill. In your submission, you highlight the issue around regional councils, and I'm wondering is that still a concern for regional councils to be able to do their job?
I'm not sure whether, I presume this bill would prevent them from doing what the Gisborne Council is doing to the forestry people. I'm not sure, because I haven't read the ins and outs, but I know that the Gisborne Council is managing to get some recompense for the forestry slash and the damage that's done. So if this bill was to prevent that, that would not be a good thing. But I'm not aware of how it's going to affect them.
Thank you, Jill. Appreciate you presenting to us this evening and for your written submission as well.
Thank you.
Okay, we're going to have Zero Carbon Nelson Tasman, Fred and Paul. Hi, Fred. Hi, Paul. Thank you both for joining us this evening. We have read your written submission. We have you down for 10 minutes, and please just leave some time for questions. Over to you.
Thank you, Tom. Tēnā koutou katoa, ko Fred Overmars Toko Inawā. With me is Paul Martin, and we speak on behalf of Zero Carbon Nelson Tasman Incorporated. Our society's purpose is to build awareness of the challenges posed by climate change and other threats to society and biodiversity, and to develop, encourage, and inspire suitable responses to mitigate and adapt to these, particularly in Nelson Tasman. So thanks for this important opportunity to present to you today, and we sure appreciate your attention at the end of a long day. In our presentation, we'll argue that the Tort Liability Bill sets an extremely dangerous legal precedent in undermining the previous Supreme Court decision and retrospectively eliminating Mr. Smith's current claim. In the alternate that the government is asking us to rely on, current climate change policies are reprehensibly inadequate in the face of a world currently on a path to about 2.6 degrees warming at 2100 if current policies around the world are implemented. In our view, the bill should be withdrawn and Mr. Smith allowed to have his day in court. So, speaking in a little more detail, first, the legal aspect, we aren't lawyers, but we've been very impressed by the compelling analysis included in submissions from Lawyers for Climate Action and Jonathan Boston. And we support the Lactanzi submission entirely in arguing that the rationale for the bill is flawed. There's no risk of the courts developing a parallel and contradictory regime. And there is no evidence that the Smith versus Fonterra proceedings have caused business uncertainty. The bill undermines the rule of law and it undermines the separation of powers. The bill extinguishes tikanga Māori conceptions of loss and likely breaches the principles of Te Tiriti o Waitangi. The bill is inconsistent with the New Zealand Bill of Rights Act, and the bill is inconsistent with New Zealand's international obligations. I beg your pardon, I should have passed over to Paul. So Paul, would you like to carry on, please?
Sure. So as Fred has mentioned, we support Jonathan Boston's submission. Jonathan Boston, if you're not aware, is the Professor of Policy Studies at the Victoria University of Wellington School of Government. And one of his quotes from his submission is, moreover, the bill is inconsistent with the government's support several years ago for the International Court of Justice to provide an advisory opinion on the legal obligations of states to reduce greenhouse gas emissions under international law. Why, for instance, is the ICJ competent to rule on climate change related matters while our courts in Aotearoa apparently are not competent to do so? Note too that New Zealand was among the 141 countries that endorsed the General Assembly resolution earlier this year, welcoming the ICJ's advisory opinion. Put differently, the government somehow saw fit to vote for climate accountability through legal mechanisms in New York, but now wants legal immunity from such accountability at home.
Thanks. And picking up next, Paul, from Paul. We speak next to the manifest inadequacy of the government's current policies in addressing climate change risks. In the global picture, scientific evidence shows global heating is occurring faster than previously expected. Our world is now on the cusp of a 1.5 degree global temperature rise. I'm hearing an echo.
Yeah, it's coming from Paul. So if Paul, you can just mute yourself.
Sure.
Thank you. Thank you. Some predict 2 degrees by 2040, unless urgent action is taken to change course. And even at 1.5 degrees C, we're rapidly approaching multiple Earth systems hitting tipping points that will transform our world with devastating and irreversible consequences for people and nature. And examples of these are the Greenland and West Antarctic ice sheets, global permafrost, floor and slowdown of the Atlantic meridional overturning circulation, easily spoken of as AMOC. These may seem far away, but because Earth's climate system is interconnected, Aotearoa will not be immune to these consequences. And for example, just to pick a piece out of paper published in March this year on the consequences of an AMOC collapse, this predicted Antarctic temperatures warming by around 6 degrees. So this is a collapse of the circulation in the North Atlantic, and this has flow-on effects right through the Earth's circulatory systems. And such change in the Antarctic is going to cause immense changes in our climate here in Aotearoa. We sense most of our political leaders are unaware of the scale of these risks. And currently, our legislative framework and policies that we're being asked to rely on are completely inadequate to address these risks, in our view. The government has dismantled many initiatives and programs to address climate change. Instead, for its primary program, it relies on an ETS that is not fit for purpose, which is to drive down emissions. And germane to the bill, it excludes agricultural methane and nitrous oxide. Further, the government is on a path to default on our first nationally determined contribution under the Paris Agreement. This is our primary tool for influencing the world court of public opinion on whose decisions our future climate depends. Further, the government lacks an effective climate adaptation response. It's seemingly oblivious to emissions reductions being the first tool in adaptation and to research showing the global economic losses, for instance, the global economic losses that can be avoided by 2100 with a 1.5 degree scenario are estimated to be 5 times greater than the climate finance needed by 2050 to achieve it. And further, the government has just recently shelved the Climate Change Commission's recommendation that a future Aotearoa contribution to global action is a net negative 20 million tonnes CO2 emissions equivalent per year. As a further comment, we believe this bill will cause further damage to New Zealand's reputation with regard to climate and environmental issues, and with respect to compliance with international rules and agreements. Environmental groups have documented at least 35 ways New Zealand has backtracked on established policies or undertakings, particularly in climate change. It seems highly likely that each change, including the current proposal, would increase that risk. Paul.
So in conclusion, this bill would remove retrospectively the legal right of Mike Smith and of others to seek remedy through the courts for the damages of the greenhouse gas emissions of major polluters in Aotearoa on himself and his iwi, when the Supreme Court has determined that he has this right. So it's basically shifting the risk from the polluter to the public. This would set an extremely dangerous legal precedent and be an abuse of legislative power in undermining the Supreme Court decision and eliminating the current and future claims. Citizens will no longer have access in court to vindicate their legitimate claims to damage by corporates through climate change emissions and other pollution. This is a major erosion of citizen rights. The government's program for addressing climate change is, as we have said, manifestly inadequate and cannot be relied upon to address the existential threats of climate change for our young people, for future generations, and for biodiversity. Please do the right thing, show moral leadership, and recommend that this government allow Mike Smith's case to be tested in court, as well as further such cases. And we welcome for any questions.
Thanks, Fred. Thank you, Paul. We'll look to see if any members have questions. We have one question from Dr. Lawrence Sunan.
Thank you so much, Chair. Thank you, Paul and Fred, for your submission. I guess through your submission, I'm curious to know in terms of the impact on whether you think it has been appropriate, where it would be appropriate considering the most egregious emissions, particularly through agriculture. It's done through agriculture, but the price tag is being left picked up by taxpayers broadly. I'm looking at it specifically from economic angle, but absolutely you're right about the climate angle, environmental angle, and all of the other social costs. But if you look at it from that, do you think that'll be appropriate? Do you think that should be appropriate? You are on mute, sorry.
We could put the argument up that the polluter pays, and I think that that's probably the best way of answering your question. You know, what we're seeing with this bill is that polluters effectively are being exempted from any action by citizens to address the impacts on those citizens, and we're being asked to rely on a government legislative and policy framework that is just inadequate for the task, and in many ways is leaving the cost of that onto the vulnerable, the people who aren't the poor, the people in less developed countries around the world. And you know that those are the ones who will be, and Maori for that matter too. Those are the people who disproportionately will suffer for this bill.
A quick sub. Do you think the polluters are currently paying?
I think when agriculture is completely omitted from the ETS, you know, that's a slam dunk argument.
Fantastic. Well, thank you, Fred, and thank you, Paul, for both joining us this evening and for your written submission as well. Thank you very much.
Thank you.
Right, members, we come to our last submitter of the day, the Law Association of New Zealand, and we've got Warren Pike, who's going to be submitting to us. Hi, Warren. If you can hear us, we'd love for you to switch off your camera and switch on your camera. There you are. Fantastic.
Right. Good afternoon, everyone.
We've read your submission, Warren, and we've got you down for 10 minutes. Off you go.
Yes, well, I was listening with interest to the last presenter, and rather than start by summarising our submission, I thought I would say something about what really is at issue here. What you have is a clash between finding a solution to the problem of climate change. And what Norman Kirk said when he was Prime Minister is what was important was looking for a solution to a problem that would work rather than arguing about the problem. So the solution here is between a parliamentary process, a political solution, and an alternative solution that might rest in a court process. And I think it's worth knowing what the advantages and disadvantages of them are. I can summarise these by reference to two sets of Reith lectures, and I'll just read briefly some excerpts from Lord Sumption's Reith lectures in 2019, where he made a couple of prescient points which I think have to be considered here. The way before I turn to that, the way I'm seeing it is litigants seem to have a great deal of expectation of what can be achieved out of a court proceeding in tort to solve a global problem. It makes no sense. And in my submission, and the Law Association's position, is that Parliament can legislate to solve this problem, and it can exclude the courts from involvement in it as a matter of power. The question is, should it do so? And these are extraordinary measures here, depriving litigants of any rights to access the courts. Some things Lord Sumption said in his Reith lecture in 2019 are regarded as inherently illegitimate. For example, retrospective legislation, obstructing access to a court, acts contrary to international law, and so on. This does not mean that Parliament cannot do them. It means that those who propose such things must squarely declare what they are doing and take the political heat. And on the other hand, he went on to address the limitations of what can be achieved in proceedings before a court. The judicial resolution of policy issues can undermine the single biggest advantage of the political process, which is to accommodate the divergent interests and opinions of citizens, namely, this is my interleafing, trade-offs. It is true that politics do not always perform that function well. It may be that politics are not performing it well at the moment. But judges will never be able to perform it. Litigation can really mediate differences. It is a zero-sum game. The winners carry off the prize and the losers pay. It is not a consultative or participatory process. It is an appeal to law. The overarching message of the Law Association is, yes, Parliament can do this, but it's far-reaching, it's unprecedented for the reasons I've read out from Lord Sumption, and Parliament must pause for considerable thought before taking the steps that are proposed in the bill. The retrospectivity and the extinguishment of rights to access justice are particularly important features to consider. The Association has suggested an alternative, that what could be legislated would not be to bar all proceedings, but give defendants, such as in the Smith and Fonterra case, a complete defence to claims if they can show compliance with the statutory climate change regime. Another option would be to preserve the right to sue in tort for omissions that are non-compliant with the statutory regime. And I want to give an example from my own practice career a long time ago, where I had a client who lived behind a timber treatment plant. It leaked chemicals repeatedly into their section, ruined the value of their property. The regulator took no steps over many years to enforce the regulations to prevent the discharge of these chemicals. They were able to sue and obtain a settlement nuisance. Now that shows you the value. What we have here is we're taking away the rights of all citizens to sue people who are causing a nuisance and to take any steps to make the regulator do the right thing. And in the Law Association submission, that is a very far-reaching step that Parliament should carefully think about before taking it. My neck's a bit that way as well.
Yeah.
I've only been lifting hay. Now, my last point, and I can't see how much time I've run already, and I want to leave some time for questions, is that there's only been 2 judges who have ever given the BBC Reith lectures, and the first one was a judge called Lord McCluskey back in 1986. He touched on the same theme that I've referred you to. He said this about the law and policy, which I think is important here. The point about the development of the law in our society is that the lawgivers, whether they're judges or legislators, create general rules intended to yield acceptable results in all foreseeable cases. Then life throws up unforeseen cases, and either they or changes in society's perceptions show that the rules are inadequate. So they are changed. The courts are the laboratory in which the rules are tested against reality and proved for social justice. We can trust the judges to do that. So with that, I'll take any questions.
Thanks, Warren. We have about three or so minutes for questions. We've got Camilla Balich first.
Thanks very much for your for your submission. Apologies for my voice. I just had two questions really. The first one was, in your submission, you indicated that you thought it was possible for the bill to be drafted in a way that could achieve its aims, but by limiting the effect to only what was necessary. And I think you just gave a couple of examples in your oral submission as well. So that was my first question. And the second question I have is, we have had many submitters talking about how this bill is necessary because it otherwise would create uncertainty for business. But from your submission, I take it that you think that this bill will, by trying to get rid of uncertainty for business, actually create uncertainty for citizens as to the law.
Well, I don't think it will create uncertainty for citizens if it's passed in its current form. It'll give them certainty that they can't sue anyone for this type of activity. And what we're proposing is that a second look be had at it to try and preserve those rights to access courts on the sort of suggestion that we've made. I think the association can see the issue of uncertainty for business, and it's an important issue, and it's a real issue, because otherwise you're going to see claims coming riding over the hill, in unpredictable times and from unpredictable litigants if something's not done to regularise the situation. So yes, it needs a careful look, and I think certainty is one of the factors.
Just to clarify, I was just talking about uncertainty as to what the law would be given your objections to its retrospectivity and its constitutional significance, not as to what the law is in relation to climate cases.
Well, it looks pretty certain to me if it's passed in its current form, you can't sue.
Yeah.
Oh, sorry, Camilla, you're on mute.
If the government changes the law in this way, how can citizens have certainty as to what the law would be in the future, given that this is retrospective?
Well, I'm not sure what your question really is driving at, which is possibly why my answer didn't correspond with it.
I took from your submission, which I read in quite a bit of detail, that there was a significant objection to the proposals due to the way that it essentially challenged our normal constitutional conventions, thus creating uncertainty for citizens as to the workability of our law within its current form. And so I was asking about that aspect of uncertainty, not about the uncertainty in relation to the specific claims of climate tort.
Right, you're talking about the broader impacts here on lawmaking generally. Well, I think the association's approach is this is extraordinary, and it is possibly a thin end of a wedge. I mean, the only other relevant one recently is the marine and coastal area legislation, which was directed at a supposed interpretation problem, but it also nominated specific proceedings. That is a trend that the association has identified that Parliament should be careful about, because where's the end point with that? So yes, there is uncertainty in terms of what Parliament may do in the future.
Thank you. We've got time for one more question. Who would like it out of Lawrence and Deborah?
Deborah can go.
Thanks, Lawrence. It was a fairly straightforward one. In the papers that were released when this bill was tabled in the House, the minister's officials referred to some limited consultation that they had done with constitutional experts and various lawyers. Were you among the people consulted by any chance, or do you know whether the Law Association was consulted?
I don't know the answer to that. I certainly wasn't.
Okay,
but
no, we don't, just,
whether
I'm
the association was, I don't know.
Yeah, okay.
I mean, I don't think there are opaque constitutional questions here. I think we all understand them.
Great. Okay, thank you.
Thank you, Warren. Thank you for your submission and for being our last submitter for today on the bill. We really appreciate you joining us. Members will be moving to the private Zoom link. Thank you.
Goodbye.
Thank you for watching the Order Paper, your express ticket to the New Zealand House of Representatives. Every episode, we unravel the complex world of legislation, debate, and democracy. From bills to select committees, we've got it all covered. From our team of political commentators who will dissect and explain what's happened, so you can remain up to date on what's happened in the Aotearoa, New Zealand Parliament, To support our channel, you can become a Patreon member at patreon.com/itsinthaballot. The Order Paper podcast is brought to you